Hey, welcome everybody to today's Law of Self-Defense show, Snow Day edition. Yes, we are having a snow day here in where I live in Colorado. Pretty big storm coming through. Not terrible where I live. We got a few inches of snow, but it was the threat of snow was enough to close down the schools for today. I got the snowblower out and got it started up. First time I'm using it this winter. Although I do prep the snowblower for storage every spring. Um, put some fresh fuel in it. Took a little bit of effort, but got it started. Got it all ready to go. And I'm that guy in the neighborhood who does pretty much all the sidewalks. I do all the sidewalks up and down my block, both sides of the street. The elderly guy who lives across the street, I do his driveway, do my driveway. So it took a little time. So we're starting a bit later today than has been our normal practice. Hope that's okay with everybody. And today we're going to address day 4, the final day of the Louis Casado self-defense immunity hearing. This is the day in which we'll hear the last 2 witnesses, one witness from the defense, a psychologist, Dr. Lawrence Miller. We'll hear 2 rebuttal witnesses from the state, Dr. Alan Dean, an optometrist, to rebut the defense optometrist, Louis Casado's lifelong optometrist, who testified earlier for the defense, and a rebuttal witness, Dr. Richard Hough, Hough, however you pronounce that, a criminal justice and criminology professor, presumably to testify as kind of a use of force expert to contest the testimony of Dr. Roy Bedard, who is a defense witness we covered yesterday. Now, the self-defense immunity hearing actually took place last November over a series of 4 days. We're reviewing the 4th day now, so it's a playback for us, and resulted in a grant of immunity about 6 weeks later. So December 30th, 2022, Louis Casado was in fact granted immunity from prosecution. Spoiler alert, I guess. But I wanted to go through the video of the hearing. Unfortunately, we only had video of 3 days of it, the last 3 days. To give you a sense of how the self-defense immunity hearings work, how they function. And in a sense, there are many trials that happen before the trial. Now, on the early morning hours of May 29th, 2021, Louis Casado had been working at his job at a hotel, valet/security for 30 days straight. He decided to go out that evening, have a few drinks, socialize. He went to a bar called, he went to a couple bars, but ended up at a bar called Dos Gatos. 1:30 a.m., May 29th, 2021, Dos Gatos closes, last call, people kind of gather out on the sidewalk. Louis Casado is out there talking to a group of men, and one of the men takes offense at something, even though Louis Casado appears on the surveillance video that captures the confrontation to do nothing offensive or provocative. And this man, wearing a black baseball hat, Adam Amoya, strikes Mr. Casado across the face. A friend of Mr. Amoya's, a Mr. Santiago, wearing a red shirt, immediately, within half a second, also strikes Mr. Casado. These are powerful, open-handed blows to the face, sufficient to rock Casado back. The first blow by Mr. Adam Amoya, I guess, takes Casado's glasses clean off. Casado's optometrist would testify that his vision, uncorrected, was something on the order of 2200, maybe as good as 2080, but routinely 2200, which is legally blind for driving purposes. First blow takes off Casado's glasses. Second blow from Mr. Santiago staggers Casado backwards. And Mr. Amoya continues to follow up with a series of left-right slaps, driving Casado backwards until Casado's back is against the wall. And at that point, Casado retrieves a pistol, fires 7 rounds, 5 of which strike Mr. Amoya. One of them with obviously fatal results. Tears through Amoya's heart, his aorta. There was no surviving that particular injury. And part of the nature of the shots being fired may be why we're here today, because all the shots were fired extremely quickly. All 7 shots were fired in 1.6 seconds. And it appears Mr. Amoya begins to twist away from the muzzle of Casado's gun as Casado's firing in this 1.6 seconds. And because he's twisting away, he gets hit twice in the chest, once in the side. And then the most damaging bullet, the one that goes through his heart and the aorta, actually strikes him in the back. It may be because he was struck in the back that the prosecutor feels this was an appropriate case to try to bring to trial. There's perfectly legitimate reasons why a person might be shot in the back, even in a perfectly lawful shooting. This wasn't a 16-second series of shots. It was 1.6 seconds. Mr. Casado's vision was obviously badly debilitated by the loss of his glasses, the stress of the conflict, all of that would explain why likely the final bullet ends up striking Casado, Mr. Amoya in the back. But in any case, Mr. Casado was charged by the state with manslaughter in this case. And because of Florida's 1020 life sentencing statute, a firearms sentencing enhancement statute, Casado was looking at life in prison if he was convicted on the manslaughter charge. And before the matter went to trial, the defense attorneys, Patrick Canaan and Daniel Hilbert, filed a motion for a pre-trial self-defense immunity hearing. This is an option for the defense. Under Florida law, they can demand to have this pretrial self-defense immunity hearing, often mistakenly called a stand-your-ground hearing, but it's no such thing really as a stand-your-ground hearing. It's a self-defense immunity hearing. And it acts as a mini trial before the trial, so a less costly, less time-consumptive, although this immunity hearing is pretty long, 4 days, less time-consumptive than a trial and less risky than a trial. So trials can easily run hundreds of thousands of dollars pre-trial expense. A couple $100,000 pre-trial expense is not unusual. In this case, for example, the defense has 6 expert witnesses. And that gets expensive pretty quick, folks. There were a lot of depositions of witnesses. That gets expensive really quick. Lots of money to go through very, very quickly. And if you lose a trial, you're convicted. And you're, in this case, Casado would be looking at 99 years. At the self-defense immunity hearing, they're not inexpensive. This one definitely wasn't inexpensive with 6 expert witnesses, but typically they'd be less expensive than a full-blown trial. They can take a few days instead of a couple weeks. And the risk to the defendant is much less because if you lose in the immunity hearing, you still have a trial to argue at. Now, at the immunity hearing, the burden of proof is on the state to disprove self-defense by clear and convincing evidence. Now, there is no jury in a pretrial hearing, no jury selected until a trial. So in the pretrial hearing, the judge, and here the judge is R. Lee Smith. He's the circuit judge in this case. He's playing the role in this mini trial before the trial, the self-defense immunity hearing. R. Lee Smith, Judge Smith, is playing the role of both judge, so making determinations of law, as well as finder of fact, deciding what facts he believes have been proven or not proven in this case, deciding what weight to give testimony, to give evidence, and so forth. So the Judge Smith is playing the role of the jury in this self-defense immunity hearing. The prosecutor is one Mark Johnson, defense counsel Patrick Canaan and Daniel Hilbert, and they'll both argue their sides today in the day 4 of the self-defense immunity hearing, which we'll be reviewing today, the final day of the self-defense immunity hearing, kind of like closing arguments in a trial. And that's where we'll be going through that process today. Of course, we know that self-defense immunity was ultimately granted here. That order came down from Judge Smith on December 30th. So if not today, then tomorrow, I'll address the order itself. I have a copy of the order. We'll read through it so we can get a sense of how and why Judge Smith decided to allow for immunity, to grant immunity in this case to criminal prosecution. Now, under Florida law, a grant of immunity in a criminal process does not grant you immunity from civil suit. That would require a separate self-defense immunity hearing. But here at Law Self-Defense, we mostly worry about the criminal stuff. All right, so I'm trying to keep that introductory part concise today because we did get a late start, 2.5 hours late, later than I would have liked. So with that out of the way, I'm prepared to jump into the actual video of day 4, the final day of the proceedings, except, of course, I have a couple things to share with you. Coming up, April 15th, our Law Self-Defense Advanced course. This is our full day course taught live by me over Zoom. We only teach this once or twice a year, and we scheduled what might be the only class of 2023 for April 15th, Saturday, April 15th. Again, this is our full day Law Self-Defense course. We cover each of the 5 elements of a self-defense claim in great detail. We cover defense of others. We cover defense of highly defensible property like your home or business. We cover defense of personal property, of open land against trespass. We cover the practicalities of the criminal justice system, what makes someone look like an attractive target for prosecution to the state, so you know how not to present yourself in the case, a use of force case. We talk about interacting with the police in the aftermath of a use of force event. We spend about an hour alone, or we spend an hour on that alone. So it's our full day course that is taken by lay people. It's taken by attorneys for CLE credit. It's taken by police officers, by judges. It's our most comprehensive course on self-defense law, and it's happening April 15th, Saturday, April 15th. Again, taught live by me over Zoom. Now, the good news is if you sign up for this class this month in January, it's 50% off the normal registration. You save about $100. If you sign up for the April 15th class next month in February, it's only 25% off. If you sign up for the April 15th class in March, it's only 10% off. And of course, if you sign up in April, it's just full price. So if this is at all of interest, I would encourage you to sign up sooner rather than later. Also, I want to mention our book, The Law of Self-Defense Principles, real physical book, not just some PDF download. You can see the reviews on Amazon, 1,200 plus reviews, 5-star rated. But don't buy it on Amazon. Amazon will charge you $25 for the book, plus shipping and handling. We'll give you the book for free. We do ask you to cover the cost of shipping it to you. We have people in the warehouse who need to get paid. We have the U.S. Postal Service that needs to get paid, but we'll eat the cost of the book. So for less than $9 shipping and handling, you get a free copy of The Law of Self-Defense Principles, and you can get this at lawofselfdefense.com/free book. And finally, if you'd like to pose questions to me during today's live show, if you're watching this on YouTube, you can do that, but it needs to be in super chat form, $5 minimum super chat, folks. Or you need to be a Law of Self-Defense member. This show is airing on the Law of Self-Defense member dashboard. And if you're a member, you should be watching it there. The chat is open. I can see it's working. And you can ask an unlimited number of questions there, and there's no charge whatever, because you're already a Law of Self-Defense member. And if you'd like to try Law of Self-Defense membership, folks, and I would encourage you to do that, you can try it for almost nothing. 99 cents for 2 weeks gets you a free trial as a Law of Self-Defense member, full access to everything the normal members have. There's no limits or constraints, access to our many hundreds of videos, podcasts, blog posts on various use of force principles, legal doctrines, court cases, appellate court decisions, tons and tons of content, and you get to ask as many questions as you want for free instead of having to pay $5 a question in super chat form. And if you don't like being a trial member, just in that 2 weeks, cancel. We'll give you 200% of your money back. So it's a negative risk proposition. And you can do that right now, become a member right now at lawofselfdefense.com/trial. If you stay a member, and virtually everybody does, it's less than $10 a month to be a normal member at Law of Self-Defense. About 30 cents a day. I think it's $9.95 a month. So not a lot of money, folks, 30 cents a day for, frankly, world-class expertise, legal expertise on self-defense law. All right, so with that housekeeping out of the way, let's get to the first witness of the day, which is the last defense witness in the self-defense immunity hearing. It is Dr. Lawrence Miller, a psychologist. He certainly looks like a psychologist if I've ever seen one. And let's go ahead and get this started.
Police officer, military soldier, starts to shoot. Why didn't they stop shooting when?
So obviously this video stream is starting somewhere with his testimony already in progress. Nothing I can do about it, folks. This is what I have available. But this is a defense witness, a psychologist. Obviously, he'll be talking about what might be expected from the state of mind of someone in Louis Casado's position. Oh, before we do this, let me play the video. That seems a good thing to do. Before we dive into Dr. Miller's psychology testimony, let's review the surveillance video. So this is from just moments before the first blow to the instant the first shot is fired, this video ends. So we don't see any gore. We don't see Mr. Amoyo actually killed here. It freezes at the moment, maybe an instant before the first shot's actually fired, but it gives you a sense of the conflict. So we have the defendant here, Louis Casado. He's the bald gentleman dressed all in black, wearing glasses. A little bit to the right, you see a black baseball hat. That black baseball hat is being worn by the man who would be the victim here, the victim of Casado's use of force. The legal term is victim. He's, in fact, of course, the aggressor in the fight. That's Mr. Adam Amoya wearing the black baseball hat. He will begin to talk at Mr. Casado, ultimately strike the first blow, smash Casado's glasses off his face. An instant after Mr. Black Baseball Hat Amoya strikes Casado, he'll also be struck by the man here on the left in the red shirt, Mr. Santiago, who will deliver a vicious blow to Casado, stumbling him backwards. And then Mr. Amoya will follow up with a series of right, left blows, driving Casado backwards until Casado gets his back against the wall, at which point he pulls his pistol and begins to shoot. We won't see the actual discharge of the weapon. This video freezes before then. But here we go. There's no audio. Bam, bam. No glasses now. Bam, bam. Strike, 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 strike. There's another strike coming. 2 more strikes coming. And this is the point at which Casado begins to discharge his gun. All right, so let's get back to the in-progress testimony of Dr. Miller. And it looks like this testimony goes on for about 36 minutes from where we are now. And then we'll have a couple of rebuttal witnesses.
Threat was already neutralized, or they no longer realize the threat. And here's where the science aspect is important, because it's important to realize that your body never does nothing. Your body doesn't stop doing things, it simply does other things. What that means is the simplest action, like pulling the trigger, involves the action of flexor muscles in your finger. In order to stop pulling the trigger, you can't just not pull the trigger. You have to engage a different set of muscles. You literally have to engage a totally different set of muscles, which are called the extensor muscles of the finger. And these are what they call the agonist and antagonist muscles. So what the brain has to do in a matter of milliseconds is determine one.
All right, so a key issue here again is the probably the fatal shot that struck Mr. Amoya was the 6th or 7th shot out of the 7, and it entered his back. So the question I expect the prosecution to be posing in its closing argument here today, day 4 of this hearing, is why didn't Casado stop shooting? Maybe the first few shots were permissible, but maybe the last couple shots were manslaughter. I expect that to be the prosecutor's argument. So here we have the psychologist to explain. And yesterday, in our review yesterday of this testimony of Roy Bedard, the defense use of force expert, we explored this as well. Why would it be that Mr. Casado, it would be reasonable of him to continue shooting for that entire 1.6 seconds, 7 shots fired period?
The threat no longer exists. 2, it's got to send a message to other parts of the brain, which we'll discuss in a moment, that the circumstances change. It then has to essentially override the initial motor program, which is to activate the flexor muscles, and then activate the extensor muscles, because releasing a trigger is an action, just like squeezing the trigger is. And this multi-step process usually occurs within a matter of a second or so, everything I've just described. But it is a very active process, which explains why, in many respects, the perception, by the time the person has fully consciously perceived that the threat is gone, there may be several more actions or trigger pulls during that time.
Okay, the brain's programming of behavior.
Yeah, I mean, as you can see, the perception of a threat or the cessation of the threat is something that is picked up by posterior parts of the brain, vision, audition, and so on. It then travels to those frontal lobes of the brain and says, okay, the threat has stopped, what do I do about it? Well, we've got to stop firing. How do we stop firing? We have to engage a different set of muscles. So it sends information to the premotor cortex, which programs the actual movement, in this case, extending the finger as opposed to flexing it. And then sends that information to the motor cortex, this little strip in pink, which then activates those extensor muscles. And this is a reciprocal process, because as the brain is doing this, it's still scanning the environment to detect the threat. But even though the brain works very, very fast, it still takes some time. we've all had experiences like this. If you've ever been outside a stuck elevator and you press the elevator, you keep pressing and pressing and pressing, you sometimes overpress, because by the time you realize the elevator is there, or by the time you realize that a keystroke on your computer has activated the website you want, you've done a couple, or the remote button on your TV, you've done a couple of what are called overpresses, over responses, because your brain is still, it hasn't picked up on the fact that that response is no longer necessary. So those are innocuous, humorous cases, but this is a case where the results could be quite serious.
Next slide. The cessation of shooting.
All right, so this comes from a series of studies that was done by researchers at the Force Science Institute, where they actually measured how long it takes to stop shooting. And, you know,
So Force Science Institute, we had one of their members, I guess I would call it, someone in a leadership position at Force Science Institute in the comments the other day, Von Klein. He's a great guy. I've met him personally. I myself am a graduate of the Force Science Institute week-long course. I forget what they call the course. I've got my certificate around here someplace. I still have to hang that stuff up on the wall of the new office. But Force Science Institute does studies on things like on use of force, human factors, dynamics, reaction times, response times, visualization, what we pick up, how quickly it takes to identify a weapon, things along those lines, often but not always in a law enforcement context. So he's referencing, and they do studies on this and they publish the results of their studies. And by far, Force Science Institute does a better job. These are very difficult things to study in kind of a reproducible, disciplined, methodologically sound manner. But nobody does it better than Force Science Institute. And that's who he's referencing here. Oops.
you know, the actual milliseconds can vary, but basically it takes about a quarter of a second for a person to perceive.
I have to say, this psychologist sounds a lot like Masad Ayub. I mean, if you just close your eyes, even kind of looks a little bit like Masad Ayub. But every time I hear him talk, Masad Ayub pops into my mind. For the folks who don't know, Masad Ayub's a very well-known self-defense instructor. He wrote the foreword to my book. Great guy, a personal friend, also a graduate of his classes. In fact, I'll see him in a couple months. Yeah, March. I think in March, we're both teaching again at Tom Given's Tactical Conference down in Dallas, Texas, sometime in March.
That's where to stop. And it takes about another quarter of a second to determine that this calls for a change of action. Okay, person's not threatening, person is running away, person has fallen, drop the weapon. That takes about half a second. And then it takes another, up to another half second for those various mechanisms you saw a couple of slides ago to program the movement, to tell the muscles what to do. And finally, the actual movement, those antagonistic movements of the finger, takes up to another quarter to half a second. So it takes, if you do the arithmetic, it's about, I think on the next slide. It takes an average, you know, it's going to vary, but an average about 1.3 seconds for the actual cessation of shooting to occur. And this is after the person has realized the threat is gone. And these are under, you know.
Folks, for those who find this guy familiar, yes, he testified as an expert witness psychologist in the Kim Potter trial as well. And that would have been for the defense in the Kim Potter trial.
Relatively stress-free experimental conditions, where these studies are done in a laboratory. So the person is, you know, the volunteers are often trained officers. Sometimes they compare this with civilians, but the results are not too different. And basically what that means is you can fire from 3 to 5 rounds after the person has actually perceived that the threat has gone. But by the time it takes the person to reprogram the neuromuscular apparatus to engage the stop shooting response as opposed to the shooting response, that person could have squeezed off a couple of extra rounds.
Doctor, I now want to suspend the PowerPoint. I know there's a few more slides, and I want to take you to Exhibit 9, Defense Exhibit 9, which are frames from the video. But let me start by asking you a question. What materials did you receive to do an analysis in this case?
Well, I mean, there were some materials that I received, and there were some materials I used for my own research on the subject.
But I'm talking about as far as the case file from this case.
I received copies of the video. I received depositions from various individuals who were either witnesses or consultants to the scene. I received transcripts of statements of Mr. Casado and some others, and then various witness statements that I have read through the file.
And how about police report statements?
These report statements, that's what I meant by collateral information.
And have you also consulted with Paris Ward, who took the original raw data and did an analysis and actually got specific as to time and distance?
Yes. And
have you relied on his work to ultimately render some of your opinions?
Well, I rely on his timing of the events that are seen on the video, because that's what he does.
Let's now go to the frames. And before, this is, as I said, is an Exhibit 9. And what I want to do.
So folks, there's nothing I can do about the courtroom volume. It's cranked up to the maximum I have available to me using both software amplifiers and a pretty high-end soundboard. So that's it. I've put on the closed captioning. We do have closed captioning today for this video stream. I will say, if you're a Law Self-Defense member, we provide a replay of every day's show for our members in the blog, the members only blog. And in post-production for that replay, we're able to manipulate the sound in ways we can't do in a live stream. I have additional audio tools, and we do normalize the volume across the entirety of the show, so it ups the volume for the portions of the stream, the video stream. If you really can't take the low volume here, I don't blame you. To me, it's blasting in my ears on my end. But if on your end it's too low, you might consider, again, becoming a Law Self-Defense member, 30 cents a day, and you have the playback option with the audio normalized.
As you can see that this particular frame is at 5129 time, and it has been timed that it's 60.10 seconds prior to the first shot. And you can see that Mr. Casado seems to be in some engagement, or at least looking at the yellow shirt, who's Mr. Wiersbe, and the red shirt, who is Mr. Ramos Santiago. I'm going to take you through these frames, and then I'm going to ask you, what do you believe the factors the court should consider for a reasonable and prudent person? What factors would suggest that a reasonable and prudent person would be in fear of great bodily harm or death? So let's run through the frames, and then and you've looked at this before, obviously.
That's right.
So let's just run through the frames.
Yeah, the bad outcome in the Kim Potter trial was not this guy's fault. This guy gave good testimony for Kim Potter. The bad outcome in the Potter trial was because the Judge Chu, allowed the prosecution to misinform the jury on what was required for a conviction of reckless manslaughter in that case. They took recklessness out of the requirement of reckless manslaughter. That's why Kim Potter was convicted.
this is the time of 0, which is the first shot, which is framed at 52:29. Again, if you could tell us what factors you think should be considered for a reasonable and prudent person, whether or not they'd be afraid of great bodily harm or death.
Well, up until this point, it sort of is following the playbook that we see, we call it the playbook that we see in most officer involved shootings. Some of them involve an immediate posing of threat, but very often, in some of the cases you read about in the news report this, there'll be a period of conversation with someone who may or may not be threatening, and might become conversation, and fairly abruptly, one person becomes antagonistic, and then the response has to occur. So what it looks like we're seeing here is we're seeing, without actually hearing the content of the conversation, we're seeing a bunch of guys standing around talking. Something humorous is going on, but at some point it becomes clear that they don't want Lewis around. Lewis, for whatever reason, does not look like he gets the message. In fact, moves closer for whatever reason. But at that point, the man in black comes off the wall and begins attacking Lewis, who obviously is surprised, shocked by this, unexpected. Doesn't immediately flee, attempts perhaps there's a reason his way out of the conversation. You don't know that because you don't hear it. Another person joins in, the red shirt approaches and delivers another blow. And then as Lewis is backing out, and the guy in the black shirt is continuing to attack him, he sees the red shirt closing in on him. He sees a bunch of other guys standing around, not knowing what they're going to do next. And at that point, it looks like his perception was, they're going to get me, I'm going down. He's already been hurt. His glasses have been knocked off. He's not seeing quite so clearly. He's disoriented and certainly surprised by the aggression that he didn't anticipate. And now his choice is to flee or to fight. I know he's standing back against the wall, so he can't back away that way. I don't see what's beyond the frame, obviously. His response is to pull out his gun and fire to deflect what he feels is a deadly threat against his life.
Can you be specific as to whether a reasonable person, this would put them in fear of great bodily harm?
This is very, this case is very similar to the scenarios you see in police officer shooting, because that's exactly that mindset. But you don't, it's not the first impulse to pull a gun and fire just because somebody might be threatening you, but once the threat is there, and especially, the thing that's different about most officer involved shootings is their training is not to wait until you're attacked to respond. In fact, there's the Graham Supreme Court decision makes that clear. A reasonable officer at the scene, if they have reason to believe that deadly force will occur, you don't wait for the suspect to get a free shot. You deflect the threat before it happens, because then you can't do anything about it. Of course, it is then the burden on that officer in that situation to prove that those were the extra circumstances. Here, a subject has already been attacked, has already been hit, and he hasn't responded yet. It's only when the threat seemed to be acute, seeing a bunch of people who have already hit and posing it again, that he then resorts to the deadly threat in this case, the deadly result in this case.
Okay. Hands up. This slide here, which is at 10 seconds before the first shot, which is 52:19 on the clock. Mr. Casado has his hands up. What does that represent to you?
Okay, I mean, I can educatedly speculate, I can't say for sure, but in general, it's kind of a universal symbol. Hands up simply means, hey, calm down, I don't want to fight with fool. It's a placating, mollifying gesture that you see most people have in situations like this. So somebody bumps into you, or somebody looks you the wrong way, and you go, hey man, something like that. It's almost universally recognized as trying to calm things down as opposed to agitate things.
And for an objective person, a reasonable person to be in that position, would the speed of what happens next be a factor in creating fear?
Well, if I had just put my hands up in an attempt to calm things down, and instead of that result happening, I was further attacked, then yes, that would be, first of all, it would be unusual, surprising, shocking, and might lead me to send that system one into overdrive, because to me this means nothing I can do to stop them from hurting me. I've got to act fast.
It's now at 10 seconds. Notice how fast the first strike is from 10 seconds. It reads 9.23, which is less than a second. Would that speed create fear?
We can sort of intuitively imagine what it might be for any one of us to be struck that quickly when you weren't expecting it. Of course, that would be, a boxer gets jabbed at around the same pace, but the boxer's in the ring expecting to get hit. Somebody on the street is not.
And the second, look, we're at 9.23. Now let's look for the second flow, which is 8.50. We're looking at frame 52:20 on the time clock. So that is less than a second for the second blow.
It seems so, yeah.
Would that speed also potentially increase fear in a reasonable and objective person?
Again, I mean, I think the answer is intuitively obvious. If you're hit once, then you're hit twice, you've got this 1-2 punch. The more times you're hit, the more it's going to hurt, and the more fearful you're going to be of further attack.
Let's now go and we're going to look at the slides of the shooting. So this, just as a warning to those that may not want to see, it's not going to be live with the frames. I do want to announce that. If we could go to the first shot.
So in the courtroom, now remember, there's no jury here, folks. The judge is playing the role of the jury in this pretrial hearing. But in the courtroom, it looks like about half the courtroom is flooded with friends and family of the victim here, Adam Omoya, the aggressor in this confrontation, but the victim of the defensive use of force by Casado, the man who was killed in this confrontation. And they're all wearing buttons, justice for Adam or justice for Omoya, whatever the button says. That's an entire half of the gallery. So it's full of friends and family. And the judge has been very sensitive about showing video of the actual shooting of Omoya, the fatal shooting of Omoya, while his friends and family are in the courtroom. And for the Kim Potter stuff, folks, Kim Potter is, I believe she's scheduled to be released April 4th of this year. So she's only got another couple months to go. And if she were to appeal, I think she has good grounds for appeal. But she's only got a couple more months to serve in prison, and she can put this behind her. If she appeals and wins her appeal, that just means it's remanded for a new trial. She's got to do the whole trial all over again. And I have no doubt in my mind that Kim Potter feels genuine remorse for the error she made in shooting Dante Wright with her service pistol instead of with the taser, as she intended to do. And she may well personally feel that, you know, that this is just. Not the conviction per se, but what resulted. I don't know. Somebody would have to ask her, but it doesn't really make sense for her unless she just wanted to get rid of the felony conviction, but there's no guarantee that would happen on a retrial. She could be convicted again.
Doctor, this is 0 as far as this is the first shot. You can see the muzzle flash. You can also see, it appears, would you agree that Mr. Casado seems to be being, there's a left arm coming at least towards his face, and the right arm seems to be loading up on the black shirt gentleman to throw another punch. Would you agree?
I can't really tell from this angle. I'll align with perception, but I would infer that, but it's hard to see because obviously it's not the frame of the
And there is testimony from an individual who was on the other side of that who describes exactly what I said. So what I want to do is go through the timing of the shots, and then we're going to get your opinion on what the significance is. And so let's please go to the second shot. And this is at 52:29. It says shot 1, shot 2, and we are now, would you agree, 0.4 seconds in.
I'll rely on you for the math, but yes, that's what
And would you agree that it appears that Mr. Casado and Mr. Omoya are still facing each other?
they are.
And pretty close to each other.
Yes, they are.
And now let's go to the next slide. This is 52:30 on the time clock. Seconds from the first shot is 0.63. And would you agree that they, Mr. Casado and Mr. Omoya, are still somewhat facing each other? There seems to be a beginning of a turn of Mr. Omoya.
Well, he looks like he's backing away and maybe he's starting to turn.
And is it also possible that Mr. Casado was actually backing away?
I don't know that I could definitively conclude that. Certainly, he's certainly not going forward, but he would be limited by how close he is to that wall.
But we could actually watch the video and determine that, correct?
If that's what the video says, it shows, yes.
So at this point, does it appear that the potential danger from Mr. Moya is suspended?
Well, remember, we're talking in fractions of a second. So at this point, Casado was firing in a way to neutralize what he believes is a threat. I don't know that it would have gotten through that the danger was passed. I mean, Moya still facing it.
Let's go to the fourth shot. This is at 52:30 on the time clock with 0.9 seconds from the first shot. Mr. Moya has clearly turned at this point, correct?
Well, he's not completely turned. He's turned, so he's waiting, the waiting stance, facing, his side is facing the Casado as he is in the process of learning.
So, but point 9, you can say that it appears Mr. Moya has now realized and is running from his fearful situation.
Yes.
And point 9, say that for a second. Point 9 ends up being a critical time period for your analysis, doesn't it?
Well, it's important in understanding the whole sequence of events.
Correct. So now let's go to the 5th shot, which is at 1.13, which is 52:30 on the time clock. Now let's go to the 6th shot, which is 1:37. And now let's go to the 7th shot, and that is at 1.6, correct?
It says, yeah.
Let's go back to the 6th shot. There's been no testimony that we actually know whether or not the 6th shot landed, hit Mr. Moya, or the 7th shot hit Mr. Moya. So assuming that the 7th shot did not hit Mr. Moya, the total number of shots that were involved would have taken 1.37 seconds. Would you agree?
That's what the math says, yes.
If we could now return to your PowerPoint. I'd like you to take these perception times, and as we just looked at the time for this particular case, now put that into perspective for us.
Well, it sort of follows the general timeline of what I was talking about before. Even if Mr. Casado had perceived that by the time Amoy was turning, the threat was neutralized, it would have taken about that long, just sort of following the research, in order for a complete cessation of shooting to occur. So within that 1.3 time frame, that was well within the window research shows police officers, even under non-stressful conditions, can continue to fire until the actual anti-firing mechanism is fully engaged.
These are the factors that you put on your PowerPoint. Can you, for shooting response time, could you elaborate on those?
Well, yeah, I mean, that's to sort of emphasize the fact that, not everything occurs under controlled experimental conditions. In the real world, whether it is for actual police officers in a street-level deadly force encounter or for a civilian, you've got problems of perception, often occurs while writing, there might be obstacles, there might be other people standing around. It may take a while to realize that the danger has passed. The individual has to, where working memory would mean the ability to concentrate, focus on what's going on. We talked about optimal arousal level. And again, this may not actually apply to this case, but in many cases of also our shootings, this has occurred after a long series of events, which the officer may be distracted, exhausted, tired, further affecting the ability to respond optimally.
Slide. You've already told us about the stages of memory.
Right, we basically got
We can slide that. Memory distortions, I think we can slide. You talked about that. Let's skip through this one. Tell us, these are some of your, the factors you believe that a reasonable person could take into account for shooting.
So the reason I listed these is, again, a lot of the science-based and research-based that my testimony relies on comes from studies of police officers. And again, the main reason because there are the population of convenience, because the critical incident is going to happen to somebody who's in a position to face danger. But you have a situation where, in this case, what's different than the usual officer about shooting is here there has already been a targeted attack against Louis Casado. So he already knows that the danger exists. That part is unambiguous. It's already been attacked. His glasses have been knocked off, so he's disoriented. He's surrounded by up to 5 different people, 2 of whom have already assaulted him, and he has no way of knowing if all 5 are going to pile on. And at one point, he's almost physically knocked to the ground.
Wow.
And he really can't back away because there's a building behind him. And so under those circumstances, if he feels that the only way to survive, to get out of that thing alive, is to use his version of deadly force, that is what.
So this is the first time I'm seeing this photo. That's quite a beating. These were not love taps. Remarkable. Yeah, that would have been nice to have seen earlier. Of course, it's not that it's anybody's fault. Typically, the courtroom cameras were not pointed at the screen like this very often. But yeah, that's a pretty good beating there.
A reasonable person under those circumstances would probably do.
You had indicated earlier that in this situation, the brain actually considers worst case scenario.
Well, the brain assumes worst case scenario because, if you hesitate and they do jump you and they do pound you to death, then you're not going to learn any lessons from that. So, the danger of assuming the negative is that, of course, you can end up having a tragic result that nobody wants. But your DNA didn't evolve to solve that problem. It evolved to keep you safe enough to leave copies behind. And those individuals all throughout both human history and the history of life on this planet, those who hesitated too much or didn't react fast enough are not the ones we're descended from.
Excellent. This is sort of a summary of the time. Could you just explain that?
Yeah, I mean, this relates to the pattern of wounds that Moyes made, because, and this is a very common phenomenon that occurs in many police officer shootings, even some that are declared justified. If the person already turned around and running away from you, why are you continuing to shoot? Now, this is aside from both constitutional decisions and FBI standards saying that a trained police officer can actually shoot someone who is fleeing if they believe they're fleeing for the purpose of committing further deadly assault. That wouldn't apply in this case. Okay, so not even going there. Here it's just a matter of timing. We know that 5 shots struck Mr. Moore. We know that 2 of them were in the back, indicating that he was moving away when he was struck. 2 of them were in the front. We can see how that happened clearly from these videos. And then there's one on the side. The one on the side is the shot that tells the story. Because what you see, I'm doing it in slow motion, obviously, is somebody backing away, turning around. Remember, the shoot response mechanism is continuing to be engaged. And so those bullets are flying as fast as the subject can pull the trigger. Where they're hitting Mr. Omoya is determined by Mr. Omoya's body position during the sequence of events. And it matches exactly what you see in those frames. And it matches exactly what takes place in many of the officer-involved shootings that we found.
So, Doctor, in your professional opinion, based on all your experience and all the explanation you've talked to about the brain and how the central nervous system works, do you think, based on what you see, and in your professional opinion, it was possible for the science for Mr. Casado to stop shooting once Mr. Moy turned?
A person's brain would not have time to go through the entire sequence of events from perceiving the cessation of danger, making the decision to stop shooting. By decision, I mean a split-second instinctive decision. Disengaging the neurophysiological, neuromuscular mechanisms involved in the agonist muscles of the victim, and re-engaging the antagonist muscles of extending the finger as opposed to shooting. It would take approximately that long for that to happen. And within that sequence of events, those 7 shots were fired.
That's all the questions I have.
Cross-examination.
All right, so cross will be by Prosecutor Mark Johnson. I do want to address a couple of issues, questions that have come up so far. First, from the Law of Self-Defense members dashboard. Let's see. So Law of Self-Defense member ALOL Cat asks, do you see any value in purchasing a matching self-defense ammo to your carry firearm? Like in the case of the SIG P365, 6 makes a P365 V-Crown hollow point ammo as a way to mitigate a prosecutor's inevitable argument that you used the wrong ammo. No, it doesn't matter what ammo you use, really, because the prosecutor will always argue it was the wrong ammo. If you used hollow point, they'll say you should have used ball ammo. If you use ball ammo, they'll say you should have used hollow point. I see another Law of Self-Defense member, Tax Pro Pam, asks if that's actually been argued by prosecutors. It happens all the time. Most famously in the Kyle Rittenhouse case, where the prosecutor Binger was challenging Rittenhouse on his choice of ammo. But whatever choice Rittenhouse had made would have been the wrong ammo. It's always that case. The one thing I would caution you about is don't use ammo that makes you sound like a lunatic. So I don't know if there's an ammo company named Kill 'em all, let God sort 'em out, but I wouldn't carry their ammo for personal defense purposes because it suggests something about your state of mind. Any kind of super bizarre ammo choice, you want to be as boring as possible. So if you can find out what your local police department carries, personally, I have friends in the FBI, I carry what they issue to their agents. Whatever you may think of the FBI from a political perspective, they test the heck out of the ammo they issue to their agents. I mean, you wouldn't believe how much testing they do under how many varied conditions. So if it's what the FBI is issuing, that's typically what I carry. And that's about as defensible as you can make your ammo choice. There's no reason to buy ammo. I mean, there's so many good ammo manufacturers today that I'm sure the SIG ammo is perfectly fine. I'm sure if they sell it for the 365, it's optimized for the relatively short barrel of the 365. I'm not telling you not to buy the SIG ammo, but I don't think it really makes any difference if you were buying Federal or Remington or any major manufacturer of self-defense ammo that wasn't marketed like something crazy. That the prosecutor could hold up the marketing to make you seem like some kind of vigilante lunatic. You would be fine. Just be boring. Let's see. Law Self-Defense member Donnie asks a good question. He asks, do you think if Florida's Stand Your Ground statute passed in 2005 is an unconstitutional infringement on your pre-existing fundamental right to meet deadly force with deadly force? So stand your ground and duty to retreat are opposite sides of this doctrine, right? Under duty to retreat, you have a legal duty to retreat if safely possible before you can use deadly force in self-defense. Under stand your ground, you don't have that legal duty to retreat. I mean, technically, it shouldn't really make much of a difference because even in a duty to retreat state, you only have that duty when it's safely possible to do. But self-defense requires that your deadly force self-defense requires you're facing an imminent threat of death, a threat of death immediately about to happen. So if that's true, and that needs to be true to qualify for self-defense in the first place, how could you possibly safely retreat? I mean, it doesn't really make sense, right? So really, if you're facing an imminent deadly force threat, you should be relieved of any legal duty to retreat because it's not safely possible. And if you don't have a legal duty to retreat because you've been relieved of that duty by the circumstances, it's not safe to attempt retreat. You don't really need stand your ground as a legal doctrine to relieve you of a legal duty you've already been relieved of by the circumstances. It gets a little iffy because the stand your ground statute in Florida does have conditions you have to meet in order to qualify for it. You have to not be engaged in criminal activity. You have to be in a place you have a right to be, so you can't be a trespasser. And if you fail to meet those conditions, you could not qualify for stand your ground, in which case you arguably reacquired a legal duty to retreat. But again, even if you reacquire a legal duty to retreat, if you're otherwise engaged in lawful self-defense, it really shouldn't matter because safe retreat shouldn't be possible anyway, would be my take on it. Having said all that, prosecutors in duty to retreat states are very, very aggressive about arguing that people claiming self-defense fail to take advantage of a safe avenue of retreat. And you need competent legal counsel to deflect that argument by the prosecution. Let's see. All right. See if there's any super chats. There was one super chat from yesterday. It must have come in after I really wrapped up the show. From Bren, $20 super chat. Thank you very much. Says, thank you for all you do, Branka. Stay safe. Yeah, I'm safe. It is, it's still snowing here, but it's not too bad. I'll do another snowblower run around the neighborhood when I get done with today's show. But it doesn't look like things are too bad. See if there's anything else. I'll do a quick refresh there, and then we'll get to the cross-examination of the defense witness, Lawrence Miller, psychologist. Come on, YouTube. Okay, back to Dr. Miller. Cross-examination of defense expert witness psychologist Lawrence Miller, cross-examination by the state. Assistant State Attorney Mark Johnson.
I understand your testimony just a few minutes ago. You testified that the defendant was surprised that he attempted to reason with the individuals in the group. I believe your testimony was that he saw the red shirt, the gentleman in the red shirt coming forward and closing in on him. That the defendant saw the others and thought they were going to attack. He didn't know what to do, and then he had to decide whether to leave the fight, and then he felt a threat against the fight. I also understood your testimony that when you were asked about how did you interpret his hands up, you indicated that that was the defendant indicating that he wanted the gentleman to calm down, that he did not want to fight. Did I understand your testimony correctly?
That was a defensive posture.
Dr. Miller,
Well, poor form by the prosecutor there. He's asking a compound question. He gets one answer. That's just not well done.
people oftentimes overreact to situations, don't they?
I'm not using this answer to be difficult, but sometimes whether a reaction is an overreaction or an appropriate reaction is depending on two things, the circumstances and somebody else's perception of it. But in a broad general way, of course people overreact.
So how do we know that the defendant did not overreact in this situation?
Well, you would have to tell me in your question what you mean by overreact.
Well, there's an assumption here. I mean, I can appreciate the science that you just presented to us. Don't necessarily know that I take an issue with that. But all of that presumes that at the moment that he used the force, that it was proportional to the force that was being used against him. How do we know that the defendant did not overreact in this situation?
Tell me if what I'm about to say answers your question. If I believe that in spite of, or in addition to, being in fear for the defendant's life, any other factor influenced his decision to shoot. There was a previous history between him and the decedent. He waited a while and thought about it, got mad and decided to shoot. Any motive other than a immediate reaction of fear and defense motivated his actions. And yes, I would agree that would be what describes an overreaction.
How do you know that the defendant was surprised?
Two ways that we can sort of perceive. One way we can perceive, and one way we can infer. We perceive what looks like several minutes of normal conversation, and then the abruptness of physical attack is something that would obviously be surprising to any of us in that circumstance. And again, using sort of intuition, if you were having a conversation with me and a bunch of other people, and suddenly I administered what looks like a boxing jab to your face, it's suspected you would be quite surprised. Not something that you would see coming or anticipate as a physical response.
You use, I think, a very important word there. You suspect, correct?
I'm sorry, what was the word?
You don't know for 100% certainty that the defendant was surprised, correct?
Well, this is a standard question.
So this is an odd phrasing by the prosecution. You don't know with 100% certainty that the defendant was surprised by the blows. But the burden here is not on the defendant to prove anything by 100% or by any percent. The burden here is on the state to disprove self-defense by clear and convincing evidence.
Any cross-examination, can you be 100% sure of anything? But I'm testifying to that today because I believe that within a reasonable degree of psychological certainty, what I am seeing in that video, what I am putting together from the other evidence in this case.
And that's the magic phrase, to a reasonable degree of psychiatric certainty. When I do consulting on use of force cases, my expert report, my expert opinion is to a reasonable degree of legal certainty. There's no absolute certainty. There are no absolutes in life.
Indicates that Mr. Casado was quite surprised by the initial series of blows.
How do you know that the defendant in this particular case, you said he was trying to reason with the other people. How do you know for certain that he was trying to reason with them?
I don't recall saying that I thought he was trying to reason. If I did say that, then perhaps I did over-infer that because I can't tell what he was saying. I think the point I think the point I was trying to make is his posture, his body language indicated someone who certainly was not trying to aggravate or agitate the circumstance, but trying to at least neutralize it, if anything, and calm it down.
You said before that he saw the red shirt closing in on him. How do you know that he saw the red shirt, the person in the red shirt closing in on him?
I can infer that because the red shirt was standing a few feet away and the video shows it moving towards him, so I can infer that that was in his direct field of vision while he was engaged by Mr. Moya, so that would be a reasonable inference that he started coming towards him.
Okay, now early in your testimony though, you said that when a person senses danger, they sort of focus in on that particular danger. So how is it that you know that he's focusing on that danger and he sees the person in the red shirt in the periphery?
So again, we're splitting hairs, but if the danger includes the entire circumstance around him, I would not expect him to perceive an ice cream truck going by on the street while this was happening. I would not expect him to hear and remember a song that was playing on a PA system, but the danger here was all of these people around him. What he perceived was both an exit and an imminent attack.
Same for.
And that was a bad question by the prosecutor. Well, you say his mind focuses, his vision focuses on the danger. Why would he see red shirt? Because red shirt's part of the danger?
Or the other individuals. You said he saw the others and thought they were going to attack. How can you say that he knew that he had that perception and had that belief at that moment in time?
I'm inferring that from a combination of my observation of the video and common sense.
Okay. Isn't it true, Dr. Miller, that the best way to know these things is to talk to the defendant?
I don't know about the best way, but it's one point of information, yes.
How would it not be the best way?
I don't object.
The prosecution did this yesterday with a defense expert, use of force expert, Dr. Roy Bedard as well. There's the defendant here is not required to testify against himself. He's got a Fifth Amendment right not to be compelled to testify against himself. All these references to, well, the defendant could have spoken to us and told us what was in his mind, I find inherently objectionable, and defense counsel is objecting here.
Multiple grounds. Mr. Casado has a right to remain silent. Number two, this is an objective standard. This is an attempt to shift the burden. And so, irrelevant.
Overrule the objection. The answer to the question.
And so the judge overruled the objection. He overruled it yesterday too. I don't get it. I'd like to hear his explanation for that.
Repeat it, please.
Yeah, I'd be glad to. So you testified here today where you said you've made several representations concerning what you believe to be things.
So to touch back on so the defense here, and it sounded like that was defense attorney Patrick Cannon. By the way, very highly respected law practice in this area. It sounded like he stated three reasons for the objections, one of which was Casado's right as a defendant to a Fifth Amendment right not to testify. That shouldn't even be mentioned in court. Of course, there is no jury here, so there's no jury that's being biased by this. Also, that there's it's a shifting of burden. The defendant's not required to prove anything here. The state has the burden of disproving self-defense by clear and convincing evidence. And the argument being made by the prosecution that the defense should have done something, like spoken to the psychologist, spoken to the court to explain what he was thinking. That's shifting of the burden to the defense. That's inappropriate. The third thing was that this is an objective standard. Well, I would argue yes and no, in the sense that this touches upon the element of reasonableness, right? Up to five elements of a claim of self-defense. One of them is an element of reasonableness. All the elements are cumulative, so any one of them is a target of attack for the prosecution. If the prosecution can disprove any one of these elements by clear and convincing evidence, immunity should be denied. At trial, if the prosecution can disprove any one required element beyond a reasonable doubt, self-defense collapses as a legal defense, and it's a walk-away conviction for the prosecution at that point, typically. But one of the elements is reasonableness, and reasonableness really has both a subjective and an objective component. The subjective component is that the person who used force and claims it was self-defense has to have had a genuine good faith subjective belief in the need to use force. And that subjective belief has to be objectively reasonable. So a theoretical, reasonable and prudent person in the same circumstances would have shared that subjective belief. But the most common thing in the world in self-defense cases is that the defendant doesn't testify. And so how would you know their subjective belief? Well, you don't really know it even if they do testify, right? Because they could be lying. We don't have brain scanning machines that go back in time to the event, right? So how do we know what someone's subjective state of mind is? Well, we infer it from the circumstances. And here the circumstances, we can make inferences from the video of the circumstances. And it would be reasonable to infer that someone who's repeatedly struck with sufficient severity to result in this injury, this degree of injury, let me see if I saved the image. It should be here. This degree of injury would have a genuine good faith belief that they were being subject to a deadly force attack, meaning that one that could readily cause death or serious bodily injury. We make that inference. We don't have to hear from the victim, from their own words. We can make reasonable inferences from the evidence, from the circumstances, which of course is what this psychologist is doing here. By the way, this would be super objectionable, in my opinion, in front of a jury. The only reason I would give this a pass at all here is that there is no jury in this pretrial hearing. But I think that the defense is absolutely right in its objections. This happened with Binger, right? In the Rittenhouse prosecution, and that judge lost his mind when it happened. Binger referencing that Rittenhouse didn't talk to the prosecution. The prosecution didn't have an opportunity to interview Rittenhouse, and frankly, the trial should have been a mistrial right there. Now, good for Rittenhouse, it didn't go to a mistrial because he ended up being acquitted, but you don't know in the moment that he's going to be acquitted. So super, super objectionable if this is in front of a jury. And I still think it's objectionable here. Oh, sorry.
Saw perceived moment.
One way, but not necessarily the best way.
Sorry, folks. I didn't realize I didn't have the right video back on. So I'll rewind it to...
So, and we'll go relevant.
Question to you, please.
Yeah, I'd be glad to. So you testified here today where you said you've made several representations concerning what you believe to be things that either the state of mind of the defendant being surprised or things that you believe that he inferred, he realized, he perceived, such as seeing other people around him and sensing danger. Isn't the best way to know that is to talk to him and ask him, what did he see? What did he perceive? What did he believe at the moments before he pulled out the gun and began shooting at him?
And I think I said, and I think your follow-up question was what would be a reason that one would not want it or contaminate that information.
Now, my question though is, wouldn't that be the best way to know that what he believed, saw, perceived at the moment?
One way, but not necessarily the best way.
You're saying that it's not the best way. The best way, you're saying that the best way to know what he was thinking and seeing and perceiving is not talking to him?
That's what I said. To elaborate my answer. The two main contaminants to testimony about one's own actions are a fact that we talked about earlier, that is often there's memory distortion due to the fact that the events in an extremely stressful circumstance are not always and frequently are not processed accurately in memory while they're occurring, so they're often recalled in a incomplete, fragmentary, or distorted way. And the other is a self-serving bias that many defendants in any case, I'm sure for this are going to want to tell the story in their own way. So although it is useful to get the statement of any defendant in a trial, it's not necessarily indispensable. In some cases, can even distort the data set, which is why when we do an evaluation like this, we try to get as many data points as possible.
But they could certainly tell you the truth, and you can match that up with what you see in, say, a video or whatever. So you don't even try. You don't even try to talk to him and find out what he saw, what he perceived, what he believed.
Well, of course I try. I try. If the individual is made available to me, then I interview them. If they're not made available to me, then I can.
And in this particular case, you did not talk to us inside.
That is correct.
That's correct.
Be correct.
No questions.
Thank you. That's what's excused.
Yes.
All right, so thank you very much.
Thank you, Your Honor.
Have a good day.
Okay, so that's the last defense witness, was psychologist Lawrence Miller. Now the state does call 2 rebuttal witnesses. So this is, of course, we're familiar with this from a trial procedure. The state presents its case first. The defense has an opportunity to present its witnesses, its case, and then the state has an opportunity to rebut. And this witness will be Alan Dean, an optometrist. So we had heard earlier from defense expert witness, I forget his name, but he was the lifelong optometrist for the defendant, Louis Casado, had been treating him, prescribing eyeglasses for him, doing vision tests on him since Casado was 4 years old. And in that testimony, it was revealed that most of Casado's adult prescriptions were 2200, which is legally blind for driving purposes, uncorrected 2200. There was one recent, within 3 or 4 years, eye examination by a different doctor in the same practice, different optometrist in the same practice, that had prescribed a 2080, but typically it was 2200, uncorrected vision. So the state wants to rebut that optometrist testimony here with the testimony of this Dr. Alan Dean, their own optometrist.
right there, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. So you can come around here and have a seat in the witness stand.
Your Honor. Good morning, sir. Could you please state your name for the record?
Alan Dean, Dr. Alan Dean,
And sir, for the benefit of someone who may have to type this up later, can you spell your first and last name?
Allandean.
Dr. Dean, how are you?
So we got about 35 minutes of testimony coming from this guy. This is a state rebuttal witness, so this is direct questioning by the state. Assistant State Attorney Mark Johnson.
I'm an optometrist in Tallahassee, Florida.
You may have some idea of this already, but can you just, for the benefit of the record, tell us very briefly, what is optometry?
Optometry is an eye profession where
So now they're going to qualify this guy as an expert. If anybody needs a quick bathroom break or a coffee refresh, now would be the time, because we know this guy's qualified as an expert. He was allowed to testify. That's what I'm going to do. I'll play it, but I'm going to step away from the desk just to refresh my coffee.
you're responsible for taking care of people's eye health and prescribing lenses.
Is it part of that process to diagnose people with particular eye problems they have and make efforts to potentially correct those problems?
That would be affiliate, sir.
How long have you worked with the field of optometry?
I began in December of '76,
So that would be what, about 45 years?
45 years. Last couple of years, I haven't been in the office as much. So otherwise,
And can you just briefly describe your education as it relates to the field?
I got my undergraduate degree in Purdue, graduated in honors physics, and I graduated from Indiana University Optometry School in 1976.
Can you describe your experience since graduated from optometry school, since that time?
The backbone of what I've done has been private practice optometry. I had my own freestanding clinic, technically until 2009 when I sold it, but I continued working there. In addition, I worked part-time for the VA, helping run a couple of the clinics for about 10 years. And in addition, point of emphasis, I also was a consultant for the Division of Blind Services, and they would send to me certain people who needed help that wasn't readily available from other optometrists or ophthalmologists in the area.
Your practice has been primarily clinical, correct? You see patients on a daily basis.
That's correct.
Are you licensed in the state of Florida?
Yes, my license is good until 2025.
Or are you a member of any professional associations?
American Optometric Association. First one that comes to mind, and of course, as a subset, you're a member of the Florida Optometric Association and Tallahassee Optometric Society.
Have you ever been retained as an expert in the field of optometry?
I've been retained 3 previous times.
And you testified in those cases?
I testified in court in the first one of the 3. The other 2, I just have been giving advice.
Were you requested by our office to review some optometry records related to an individual named Louis Casado?
Yes, sir.
Did you receive those records and did you review them as requested?
I reviewed all the records I received.
Can you generally describe the records that you received?
Well, one set of records, one concept is I have copies of eye exams performed by Dr. Miles and Associates since 2016. And beyond that, I've had a chance to look at videos that you sent and witness testimony.
The records, you indicated that they were records that dated back to 2016, that 2016 to 2021, so about a 5-year period.
Sounds right, yes, sir.
And what were the dates? These were records that related to visits that Mr. Casado had made to Dr. Miles' office, is that correct?
Yes.
And what were the dates of those visits as it was related in those records?
Let me look through these copies. I have visits September 7th, 1916, January 17th, what did I say, 1970? And I meant to, whatever I said, I meant to say September 7th, 2016, then January 17th, 2018, and finally September 17th, 2019. And beyond that, I also have an exam from June of last summer. June 2nd, I think it is.
Let me ask you this, Dr. Dean, in a general
In general, it's just information collected during eye examinations, which appear in the thrust of the examination appear to be targeted toward rendering an eyeglass prescription, but there's also references to examination of the eye here and there, slit lamp exam, field, that sort of thing, but general routine eye care, I would say.
Let me ask you this. A lot of folks, when they think of vision, they think in terms of the 20/20 scale. Do the records give you any information what Louis Casado's vision was on that scale?
Generally speaking, the corrected vision, at the end of an exam, or at least, the incoming exam, the vision incoming with the glasses that you already had is typically reported as around 20/20 to 20/25. And uncorrected vision was typically recorded as 20/200, although there's one record which stipulates 20/80.
And I want to talk more about that, but first, can you kind of describe the record, the 20/20 system? Can you kind of describe what that means?
So refraction 20/20 refers to what a person can see at 20 feet compared to what a normal person could see. Say a person with ideal vision sees at 20 feet. Now, you could also have 10/10, it would mean that a person can see at 10 feet, but a normal person can see at 10 feet. But normally, in this country, we use 20 feet as the distance measure standard. So if a vision is recorded, say, as 20/200, just to pick on one of these acuities, that would mean that would suggest that the person would have to get as close as 20 feet to see what a normal person could see. A person with good vision could see all the way back for 200.
And that's why 2200 is worse than say 20/20.
That's correct.
So let's go back to the records related to Louis Casado. You indicated that some of the records indicated a vision of 2200, and then there was one record that indicated a vision of 2080. Can you tell us, out of those records, what was the date of Louis Casado's last visit to Dr. Miles' office prior to May the 28th, 2000?
The uncorrected acuity each eye was listed as 20/80.
And that was on what date?
Let's see. That would be September 17th of 2019.
Now, Dr. Dean, did you look at any information within the records or do anything yourself to kind of to figure out that discrepancy?
Well, first, of course, I had a lot of clinical experience, and when I looked at the raw numbers of what the prescriptions were, I thought, it doesn't seem like this ought to be 20/200, but of course, you can't always tell just by looking. So I designed some lenses to look through, which gave me the same sort of vision that this Casado had as if he were uncorrected. And I'm able to see 20/80 in one eye and somewhere between 20/80 and 20/100 in the other eye.
So just to start with what you first said, so when you were, in terms of the information in this record, did I understand you to say that you were looking at his prescription? So the record, in addition to reporting what his vision was, they were reporting his vision, and it also included information about the prescription that he was given in order to obtain glasses to correct his vision. Is that right?
That's correct.
And that's a different set of figures. Is that right?
Yes, on the records, on each of those earlier three records, there's a section where the words new RX, new prescription is put in. And under that is a series of numbers which indicate what the eyeglass prescription is. But on the left underneath, where it talks about vision, VA, that is a different set of numbers.
Was there any like huge great discrepancies on the records where it reported vision as 2200 and the record that described his vision as 2080? Was there any big, huge differences in the prescription level that Mr. Casado was given?
The prescription levels were all pretty much about the same during the last 5 years. I mean, you might have a slight difference and, from one to the next, but they're all pretty much essentially comparable.
So as I understand your testimony today, you looked at the prescription and that was more consistent with 2080 to 2200.
Yes, sir.
You also indicated that you created some lenses to sort of replicate the vision. Is that correct?
I did.
And can you kind of describe how you did that?
Well, I looked at his most recent prescription, in fact, the one from the 2021 visit, and noticed that
I expect the first defense question of this witness to be, did you examine Louis Casado, have you ever even seen his eyes?
The prescription was, and just as a for instance, it says, for the right eye, it says minus 1.25 for the sphere, minus 1.25 for the cylinder at a certain axis. And so that would be caused because you're only refracted. You take those lines and you reverse them. So if he's minus 1.25, minus 1.25, all I have to do to come up with a lens to demonstrate his vision is put plus numbers where the minus numbers were. There it is.
And so you created these lenses, and did you take photographs to replicate exactly how Louis Casado, based on the information from those records, prescription records, were you able to take photographs that actually recreated his vision at that level?
I held these lenses in front of my cell phone and took pictures. A friend of mine standing at different distances and just to show them, just so I have good ideas what the vision as what anybody would see, so what you would see in those lenses.
And did you do that at different distances?
I did.
And did you do that for each of his eyes, his left eye and his right eye?
I did the eyes separately.
Again, an obvious defense question here is, all right, so you created these glasses that supposedly gave you the same uncorrected vision as our client. And then you looked at a friend of yours to see how well you could perceive your friend. Did your friend punch you in the face 8 times with sufficient force to induce these kinds of injuries? Did you have that part of the experience too? It's kind of ridiculous.
Dr. Dean, I'm showing you what's been marked for identification purposes as Q10, I believe. What does that company represent?
It looks like the files I sent you. Yeah.
Are those very accurate photographs as you just described?
Yes. Well, yes.
John, it's time to offer states.
Any objection?
The defense should bring in Raymond Santiago and have him whack this guy across the face.
I do object, Judge. I don't think the proper predicate has been established. He is taking a piece of a record out of over time and wants the court to believe that that's the eyesight when there's other records that indicate otherwise. He's taking this on a cell phone. It's not scientifically established here that this is going to be the accurate eyesight of Louis Casado on May the 28th of 2021.
Your Honor, he actually explained the process. I think Mr. Bananas or goes to the way of the evidence, not the usability of it. If he wants to challenge that, he's certainly free to do that.
Over objection, I'll receive it into evidence. The state's next over exhibit.
Yeah, publish the. All right, Dr. Dean, I'm going to go to this first photograph here. The gentleman here is holding up a sign that says 3 feet, and I'm corrected on the left-hand side, and on the right side it says 20 feet corrected. Can you kind of explain what this photograph is?
Well, I just as a point of reference, I took pictures of my buddy here, and just so we have the best idea as to how a person, would see.
All this evidence is so objectionable. First of all, I've never seen this done before. This is not any kind of standard scientific procedure that's been published on. This optometrist just basically made this up. These were not the lighting conditions in place at the time that Casado was defending himself. There's no blows being struck. This optometrist didn't have the glasses punched off his face as part of the first of many blows in a violent confrontation. Again, some of this is mitigated because we have a judge here playing the role of finder of fact. But certainly in front of a jury, I would find this completely objectionable.
My buddy at these particular distances with proper recognition.
So these are photographs where the vision is actually corrected and what he would be able to see at 3 feet and also.
That's correct.
Moving here to the next slide. Here is that he's holding up a sign that says 3 feet uncorrected and 3 feet uncorrected. There's 2 different photographs. One's the left eye and one's the right eye. Is that correct?
That's correct.
And this is uncorrected. So this is without any glasses and his
That's correct.
And presumably, any of us who wear glasses for being nearsighted, we all know that our vision, our uncorrected vision, gets worse in the dark because your pupil expands to allow in more light. When the pupil expands, you have less depth of field in your focus. Crazy.
And then the next slide, this would be the same at 7 feet.
That's correct.
The next slide would be what he would be able to see uncorrected at 10 feet.
Correct.
The next slide is what he would be able to see at 15 feet.
Yes, sir.
And then the next slide is what he'd be able to see at 20 feet. Is that correct?
Yes, sir.
Now, you indicated earlier too that you had an opportunity to watch or review some videos from the Casado bar that was dated early morning hours of May 29th of 2020. Is that correct?
I did, yes.
Did you observe anything in the videos? One of the issues in your case is a claim that Mr. Casado, once he had his glasses knocked off, did not see. Did you see anything in the video that you thought was important in evaluating his ability to see without his glasses?
I was impressed that after the shooting had taken place, he was standing around casually and
Objection.
Sustain. You can see, you can testify to what you see
okay,
without adjectives.
okay, no adjectives. He was standing by the wall.
Objection. What does it have to do with eyesight?
Let me ask you this, Dr. Dean. If someone has vision as bad as 2200 and they have their glasses either knocked off or removed, well, how dependent are they on those glasses?
There's a lot of variability from one patient to the next. Honestly, some people are very comfortable and some people, aren't just happy if they don't have their glasses.
Hey, Steve, I see your note here in the email about manslaughter and 1020 life. I'll address that as soon as this witness wraps up. But thank you very much, brother. I appreciate that.
Ask the question again, just in case I didn't quite catch it.
Yeah, my question is, how dependent are they on glasses?
You have to answer that in terms of dependent to do what? To do,
What would be their natural reaction if they have the glasses on?
if your vision is bad enough, you're going to be hunting around for your glasses as assiduously as you can. You want to get back to where you can see well.
And did you see any of that behavior from Louis Casado in the video?
I was not impressed that he felt that way.
Objection to relevance.
At some point in time, did he seem in distress where he was trying to find his glasses right away?
Judge, objection. Not like a predicate. This is not a psychologist. This is an eye doctor. This is all about his eyesight.
What was your question again?
I asked him, did he seem to be in distress looking for his glasses?
Overall objection. He seemed to be casual.
At some point in time in the video, does he actually see the glasses?
That's crazy. That was a perfectly legitimate objection by the defense. This guy's an optometrist. He can't provide expert opinion testimony as to someone's state of mind. He can speak arguably to their state of vision. He's not a psychologist or a psychiatrist or even a use of force expert. It's crazy.
Can you describe what you saw?
I noticed that about roughly 2 minutes after the shooting, he did finally spy his eyeglasses some distance away in the street and sauntered over to pick them up.
And have you seen a picture of the glasses?
I did see a picture of the glasses.
And what color were they?
They are mostly black, light tone.
Approximately the similar in color as the street?
Objection. Relevance.
Same. And further.
Cross.
All right, I want to hear this cross.
Doctor, how long has the Miles group treated Mr. Casado?
According to what I've heard from the testimony of Dr. Miles' video from the other day, he said since age 4, The only records I have was 2016.
So you watched Dr. Miles' testimony the other day?
I did.
And did you ever examine Mr. Casado for his eyesight?
Nope.
Did you ever ask to?
Nope.
And who do you think is in a better position to tell the court?
Right. Did you ever even examine this guy's eyesight? Nope. Nope. Who's in a better position to tell the court? I can tell you what the next question is going to be. Who's in a better position to tell the court about Mr. Casado's vision? You, who have never examined him, or the optometrist who's been prescribing his eyeglasses since he was 4 years old?
What his eyesight is, you or the treating optometrist?
I think you can get good information both ways, but
That's not the question.
then you want to look at my opinion. You need to look at all the records and reconcile them, I would think.
Who is in a better position to tell the court what his eyesight is, you or his treating physician, his treating optometrist for 27 years?
Yeah, this is great. Great work by Patrick Cannon. Do not let this question go. You're a pit bull here. You got the question in your teeth. You want to get this guy to concede that the optometrist who actually examined the patient is in a better position to evaluate his eyesight than an optometrist who has not examined the patient. And this guy either answers truthfully in a way that's favorable to the defense, or he loses all credibility.
I think I can make a qualified statement myself for him.
Do you think you are in a better position than his treating optometrist for 27 years?
I would say we're on a par.
So you say that being dependent on one's glasses depends on the individual, correct?
Yes,
And would you agree that someone has had glasses and eye problems since age 3 and has had glasses for 27 years would be more likely to be dependent on their glasses than someone who just got their glasses yesterday?
I'm not so positive that you can categorically make that statement.
Did you calculate in your analysis that the fact that he not only has a 2200, or in your opinion, a 2080, but he also has an astigmatism?
That's part of the refractive area, sir.
And that's actually is a different calculation than the 2200, isn't it?
They are, the 2200 or 20 whatever is just an overall, how can you see, and that can typically be altered by so many different things, whether you have astigmatism or not, whether you're nearsighted or not, whether you have farsightedness or not, whether you have diabetes or not, whether you have corneal scars or not. There's so many things. You can't make any particular connection between the acuity level and what it is that's at the root of it.
And those are things you don't know.
I've got the records to look at.
You don't have the records for 27 years, do you?
I have the records for the last 4 or 5.
And are there records that you have that indicate that he's 2200?
3 of the 4 records indicate that he's 20 over 200. I'm correct.
And so you've chosen the one record where his brother was involved that said 28. That's what you've chosen to be his eyesight.
I validated my opinion by recreating for myself the vision for my own eyes. And with a refractive error like his, I can see 20/80 in one eye and about 20 over 100 in the other. And that also makes sense with my clinical experience of the patients I've seen over the years.
Let's talk about the test you did. That was in your,
Where's the test with the glasses you fabricated to replicate 2200 vision? Where's that test?
your office?
Which
The
is,
test you did was all the photographs.
yeah, I took it in my office.
And who's the participant with you?
So he's a friend of mine, happens to be a retired attorney with the state DOT.
See? And so obviously you weren't using Louis Casado's glasses to do that test.
Didn't need to.
Didn't need to, okay? But would you agree that the circumstances on the street in the night on Hippolyta Street on May 28th, morning of May 29th, 2021, that's a different set of circumstances than taking a picture in your office in the daylight with your cell phone?
Oh, the circumstances are different, but the acuities, as you know, presented are still, as represented by those pictures, still give a,
They would be the same? Would his eyesight be the same in the dark, and on a dark street, with streetlights?
His vision, ask that question again.
Is his vision going to be affected by the fact that he's outside in the dark with streetlights?
His vision, anybody's gonna have, anybody in the dark, will not see as well, but of course, the question is, what are his acuities? His acuities,
I mean, this guy looks like an idiot now. The complete shell.
his acuity,
You can survive this kind of cross as an expert. I don't mean your testimony, of course, becomes worthless, but you can survive this kind of cross as an expert if you answer honestly. You just have to be honest. I mean, this is this guy's fourth retainer as an expert. He testified once before in court. The other, I guess, he just gave some kind of opinion on a case. A lot of these guys, especially older guys who have some professional stature, they hear from their buddies or they see in the news, hey, you could become an expert witness. You can make lots of money being an expert witness. You don't really have to work anymore. Just give your opinion. And they become hungry to become an expert witness. Folks, being a good expert witness is hard. It's hard. And you have to be able to come across as honest for your testimony to have credibility. And if you start waffling like this, I don't know who would hire this guy as an expert witness with video of this testimony out on YouTube. He's just destroying his potential career as an expert witness here.
I'm trying to think of just how to phrase this. So ask me one, ask
I'm going to ask it a different way.
Sure.
You just invalidated your own cell phone test because you just told us,
Objection, that's argumentative.
Overruled.
you just told us that his vision would be different in the dark. His vision, that's not an accurate test that you did because we're in the dark, not in your office. Would you agree with that?
The relative scale of how you see is going to be true regardless.
Whether you're in the light or the dark?
If you're, when you are 20 over 80 or 20 over 200, these are measurements that are typically taken in the exam room. The lights are out, it's already dark. Those are what your acuities are. And so if you have the benefit of being in the light, you're going to see all the better. But you're not going to be seeing any worse than the uncorrected acuities is maybe.
Let me be more specific. When you walk outside into the dark, do your pupils dilate?
Yes, they do.
And does your vision get compromised? Is it less, you have less vision when your pupils dilate?
Physiologically, normally, when you get out into the dark, your pupils dilate and your brain has it all figured out. It dilates just enough to let in enough light to compensate for the fact that it's dark so that you sort of have the proper light.
This guy would have us believe that we see as well in dark conditions as we do in light conditions. That's what we're supposed to believe from this expert witness.
Light level in your eye or the amount of illumination that's out there.
But your eyesight can be compromised by the dilation, correct?
The eyesight will, no, I found an article.
I want to hear Patrick Cannon. Just ask him. Are you asking this court to believe that a person sees as well in the dark as they do in the light? Is that what you're asking this court to believe?
I'm not interested in your article.
I'm going to ask the witness to go out and answer the question.
Overruled.
Is your eyesight compromised when your pupils dilate? Yes or no?
Negligently, yes.
How about when you're smacked in the face and your adrenaline rushes, does that compromise your eyesight, even if your glasses stay on?
Unless you're hit in the eye, your vision should not be affected, no.
How about muzzle flare, a flash of red fire? Would that affect the eye?
It seems to me that a muzzle flash is going to come after a shot, not before.
The question is, would muzzle flash affect someone's ability to see?
It would depend how much.
Well, you've watched the video.
I had trouble finding the muzzle flash, but it was, when I reviewed the film with Mr. Johnson, he said, there it is. And
Are you stating that there was no muzzle flash?
I'm saying it seemed rather mild to me, though I had to have it shown to me. I I'm not gonna say there wasn't any.
Okay,
So
so
apparently
let's just focus in on a bright light going on, as simple as a muzzle flash. Wouldn't that compromise someone's sight?
You're talking about a bright light, you have to say how bright a light. And if there's not much, if there's not much flash, if there's no impingement.
What if there's a lot of flash?
And if the flash is generated forward, I mean, I don't know much about guns and flash, so you're a little, so I don't know anything about guns. I've never had.
The whole point, the value of having an expert witness is that he's giving you his honest expert opinion on a matter. Not that he's trying to sell the side that hired him. Now, of course, I mean, you would expect the person who's paying him might get a more favorable rendition of the opinion. But to the extent that's obvious, they lose credibility in front of the finder of fact. They're supposed to be there just to tell the truth, to provide their expert opinion, their opinion in an area of expertise that the jury would not be expected to understand absent that expert opinion. They're not supposed to be the shill of either the prosecution or the defense. And this guy clearly is here, the shill of the state. And just look at his demeanor and the way he's not answering these questions.
So
He's so defensive. No expert witness should present as defensive. They're just giving their expert opinion.
When I took your deposition, I asked you the muzzle flash, and you said you have to get back with me. You heard Dr. Miles say that even if you had 20/20 vision, once you were hit like that, it would compromise your eyesight. Did you hear him say that the other day?
I don't remember that specific comment.
We all know that you can take a hit that's not to the eye and have your vision compromised, right? We've all seen or been ourselves concussed and had blurry vision without the eye itself having been hit. I mean, this is ridiculous.
Do you agree with that statement?
So read the statement again.
If you were hit like Mr. Casado was, you saw the video, that even if you had perfect eyesight, your eyesight would be compromised.
I don't think you can make that. I don't think you can automatically make that statement. If you're not hit in the eye, I wouldn't expect that at all.
All right, I'm gonna put one last question to you, hopefully. Do you agree that once Mr. Casado's glasses were knocked off, from an eye standpoint, not a psychological standpoint, just from vision alone, that his vision was compromised?
It's compromised relative to what?
Being able to see perfectly. Was his vision compromised when his glasses came off?
His vision was less with his glasses off.
Do you agree that that means his vision is compromised?
It's tough to make that a yes or no altogether because I would agree.
Are you asking this court to believe that this guy's been wearing glasses for 27 years because he doesn't need them?
Farther away you are, the more the vision would be compromised, but the records show that his vision up close with or without his glasses is very good.
That's not my question. Was his vision compromised when he lost his glasses?
Sure.
Thank you.
Correct. Excused. Thank you, sir. You're free to go.
All right, so that was not a great performance by this this purported expert witness. Steve Gosney, our good friend Steve Gosney, is in the chat. Steve has an excellent book out, Ideas and Answers in the Law. You can get this book at crimelaw.net. That's the only place you can get it. I know it's a good book because I wrote the foreword to it, and of course, most of you in our audience will know Rekieta Law. Nick Rekieta provided a nice blurb on the back. An excellent book, even for lay people. You'll find it extremely interesting. I strongly recommend that you get a copy for yourself. And now the second edition is out and available. And the only place to get that is at crimelaw.net. I don't know if, let me see, Steve, I'll email you back where's that email here? I'll email you back an invite. This case, hold on, it didn't work. This case is taking place in the same jurisdiction as Steve works. Steve, of course, is a public defender down in Florida, so there may be reasons why he can't actively participate in our discussion on this. Also, I know he's working on a death penalty appeal, so he's a pretty busy guy at the moment. But I'll send you, Steve, I sent you the guest link if you want to pop in. But Steve was kind enough to send me a correction. So I've been talking about Florida's 1020 life statute. Let's see, let me pop this out momentarily while I'm talking about this. So 1020 life statute. So Florida's 1020 life statute is basically a gun sentencing enhancement statute. If you use a gun to commit one of the enumerated crimes in the statute. Oh, here's Steve. So I can have Steve explain it. Hey, Steve, welcome. Oh, you're muted, Steve.
Can you hear me? No?
I hear you. Move your head a little to the middle.
Okay, how are you doing? Let me get some light. Let me get some light on the subject here. Boy, my mug. Ugh, I'm working so hard. You don't even know. I'll take a little break to see my buddy Andrew and all the wonderful chat folks you got here.
So for
I love it.
Steve got a public defender down in Florida. Now, Steve.
What?
We have an
You hear me?
echo from the speaker's computer.
Oh, sorry. Hold on a second. I haven't done this in a while. I'm working. I've been catching up with all my works here. Can you hear me?
I can hear you perfectly, but I can also hear me over your speakers. So do you have headphones, perhaps?
Perhaps. I'm sorry. Hold on.
Can you hear me?
I hear you. Yeah, wait a second. I'm gonna. All right. Let's
so
see.
Steve is a public defender down in Florida. Does mostly appellate work for the public defender's office now, but has a lot of experience doing trial work. Trains the trial people in his office. Also, former experience as a prosecutor. Also doing civil work. Very, very good attorney. Again, ideas and answers in the law at crimelaw.net. I've been talking about Florida's 1020 life statute, which is a gun sentencing enhancement statute. Basically says if you commit one of the enumerated crimes in that statute and you're in possession of a gun, even if you don't fire it, it's good for a 10-year mandatory minimum. If you fire the gun and don't hurt anybody, it's good for 20 years mandatory minimum. And if you actually cause someone serious injury or kill them, you're looking at 25 years to life. But here's the catch. It has to be for one of the enumerated crimes in the statute. I've been assuming that manslaughter is one of those enumerated crimes. But in fact, let's see if I can share this. Here is, I pulled up the statute on Lexis. Steve sent me an email letting me know I was making an error here. And the error is that manslaughter, which is the crime with which Casado here is charged, is not one of those enumerated crimes in the statute. So 1020 life would not apply. So if we look at the crimes enumerated in the statute, they're murder, sexual battery, robbery, burglary, arson, aggravated battery, kidnapping, escape, aircraft piracy, aggravated child abuse, aggravated abuse of an elderly person or disabled adult, blah, 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 bomb stuff, carjacking, home invasion. So lots of violent felonies, right? They make sense. I had assumed that manslaughter was on that list, but in fact, manslaughter is not on the list. So 1020 life would not apply. And Steve was nice enough to, I can't find it now. Steve, let's see, another email with the, what the actual sentencing range would be here. Oh, here it is. So manslaughter would be good for minimum mandatory of 110 months. So roughly just under 10 years in prison and a maximum sentence of 30 years. As opposed to what I had been saying, which was up to 99 years in prison.
Can you hear me?
Yep, perfect, Steve.
Okay.
So thanks.
Yeah. Yeah, no problem. And see, this is a good man. See here, he listens because you had said that a couple times, and I'm like, and I'm and I've had a case where we had a guy charged with attempted first-degree murder. We actually got him down to attempted manslaughter, and he was not subject to 1020 life. The state offered 20 years, and we got a 3-year sentence. So that was a huge victory at the trial level in a trial I had done a few years ago. And so that sort of little bit of wisdom was rattling around in my head. So I wanted to make sure, if you remember, if you look at that list under the statute, the list does not enumerate aggravated assault. Aggravated assault used to be on that list, but was revised out based on that Jacksonville case. And the legislature then took, well, then of course, manslaughter is also now on the list. Now you would say, well, that manslaughter is covered under murder. The case Jones v. State, which is a Florida 4th DCA case, talks about manslaughter as being under the murder statute, and it is not. So this is one of those esoteric bits of law. Florida sentencing law is extremely complex, okay? And I'm giving you a kind of back of the shoebox calculation based only on the fact, assuming this guy has no prior record, assuming a number of things, but my calculations come out to a little more than 110 months in prison if he was convicted of manslaughter, and a maximum of 30 years in prison. Now, you'd say, why 30 years rather than 15? And that because it's a second-degree felony. Manslaughter is a second-degree felony. Well, a second degree, there is also in the same statute under a different subsection as 1020 life, there is an enhancement for use of firearm, which enhances a second-degree felony to a first-degree felony if you use a firearm in the commission of certain felonies, right? So in that case, that means a second-degree felony maximum punishment of 15 years could be up to 30 years. So it gets, there it is right there. So
right.
Yeah, you got it. You nailed it. So if you have a second-degree felony, see there at 1B, in the case of a felony of the second degree to a felony of the first degree. So that means that the highest sentence under manslaughter that could be charged when you use a firearm is actually 30 years rather than 15. Okay, so that's under 1B. And then if we go down to 775.087, reef classification is 1020 life. I think that's sub 2. Sub 2 is a 120 life, and you'll see that's the enumeration. So
right.
Anyways, I just wanted to kind of, if people are curious about what the punishment could be, it's very statutory. It's very, you have to be real careful reading. This is the kind of thing a lot of practitioners mistake, and they get, obviously there's appellate decisions reversing minimum mandatories on manslaughter convictions because people don't know this. It's a little bit in the weeds, and that's what we in appellate law, that's what we do. Boy, is my light all screwy or what? So, all right.
Well,
Anyway, that's that.
We have here.
Boy, I'll tell you, that cross by Kanan was just devastating. Was it great or what?
Yeah. Very good. Very good. Glad to see that. It's and one of the reasons this 1020 life statute, as Steve said, used to have aggravated assault as one of those enumerated crimes. But what was happening is people were making defensive displays of firearms in self-defense, and they were getting charged by prosecutors with aggravated assault, and then they were being threatened with the sentences under 1020 life to compel them to agree to a plea deal. When in their heads, they were subjectively simply displaying a gun in self-defense. Sometimes it was a father defending his daughter against a bad boyfriend kind of situation. And these were a whole bunch of cases that were happening, and the legislature got outraged that what appeared to the legislature to be cases of self-defense people were being threatened with decades in prison unless they took a plea deal. And that's why they took aggravated assault out of 1020 life, specifically because it was being abused by prosecutors in that way. So we give a lot of power and authority to prosecutors, folks. And sometimes, most of the prosecutors I've dealt with have been good people, but they're not all good people. And the power that works okay if you give it to a good person, it really can go awry if it's in the hands of someone who's not that good.
And what happens is it becomes a negotiating weapon rather than some sort of like extra punishment for the guilty. So, right. So in this case, well, we've charged you, and if I can get you, I mean, of course, even 110 months is still a long time. I mean, I remember I had a Judge Richard O. Watson, who actually the courthouse that they are arguing in is named after. The St. Augustine Courthouse is the Richard O. Watson Courthouse. And he's the judge that I did most of my trials in front of. He was, I think, the best judge I've ever dealt with, ever been in front of. He was so good. And I remember I had a case where I was prosecuting, and I had gotten as the prosecutor 15 years. And it got reversed for a variety of reasons on an improper sentencing issue that Judge Watson had done. It came back, and he gave him 8 years. And I remember telling, I was kind of crotchety because Judge Watson and I were so close. And so I was I shouldn't have been so friendly with him. And I'm like, oh, I got 15 and now you're giving him 8. And I remember he looks down, the judge, he puts his glasses on, he says, son, 8 years is a long time. And I said, good point. Yes. Oh, and these guys.
I do want to mention on Friday, the defense attorneys, Dan Hilbert and Patrick Cannon, are coming on our show live at 1 p.m. Eastern time, folks, to talk about this case. So you can hear it from the lion's mouth, from the trenches perspective. That was Patrick Cannon just doing that cross-examination of this ridiculous optometrist. So we'll get to hear directly from them on 1 p.m. Eastern time. I don't know if you've had a chance to watch any of this so far, Steve.
I've been watching in and out. I watched the entire cross of this optometrist, and I think I don't know, something back, but that tell you, was that just great cross by Cannon, man? I think that's why you pay him the big bucks, right?
So there's been a few times the prosecutor here has been asking some of these experts, like Roy Bedard. They asked the defense psychologist expert witness, wouldn't it have been useful for you to talk to the defendant directly about what he was perceiving at the time? And I find it so outrageous for all the reasons that, Patrick Cannon has been objecting on, Fifth Amendment grounds, burden shifting grounds, various other things. And I think he's completely in the right. And the judge is just allowing these questions to be posed.
Yeah, I agree with you 100%. The judge should have been sustaining all those objections. Those were absolutely entirely proper objections. But here's what's really going on. There's the law, and then what's going on underneath the law. And we're assuming a little bit because the judge may just be clueless on it. He may not, he may have been misreading. All right. But he should have been sustaining those. But why would he not sustain them? Well, because let the parties argue what they want. Let's bring it in. Let's throw everything against the wall. And I'm the judge and I know what they can testify to, and I'll sort it out later. There's no jury. It wouldn't be harmful because there's no jury. So a lot of times it's just like, okay, it's a good objection, but let's just let them talk. That's kind of, a lot of judges have that philosophy. Now, I don't agree with that, but I think it's a fair thing, because like the judge can work it out. Now, if it's in front of the jury, this would be a whole different level. This would be appellate error. And the problem is that the prosecutors think it's okay. Well, that objection went in and it was not sustained. It was overruled. So it must be okay to do that. No, it was entirely improper what was being going on there. Commenting on the right to defend, to remain silent, shifting the burden. Those were all exactly proper arguments. And Cannon was right on it. You see how that's a good defense attorney. It's somebody who knows what they're doing. And they were on top of it. And it was the right objection. It was at the right time. And it should have been sustained. But again, it's like, okay, with maybe the judge is even thinking in the back of his head, I'm going to grant this motion. So I'm not giving the state a basis to appeal or give the state anything, right? So a lot of judges will grant or will sustain defense objections, even if they're on the edge, because they don't want it to come back on appeal. So it may be kind of operating in reverse here, but I'm just speculating. But
and that's a good point, because I've spoken about this before covering these series of hearings. But in these self-defense immunity trials, if immunity is denied to the defendant, there is no appeal for the defendant. He just goes off to trial and has to argue there.
Well,
but if immunity is granted,
point of objection, Your Honor. Actually, in order to, and this is a very esoteric Florida law, and I don't know if it continues on to other jurisdictions, but if you do not get a stand your ground, if you do a stand your ground immunity hearing and lose, all right, in order to preserve that for direct appeal, which is what I do, you need to do what is called a writ of prohibition. You need to do an interlocutory appeal, appealing that denial of your stand your ground motion to the DCA, and have that denied before trial in order for it to be preserved for direct appeal later. So that may be Florida specific. I don't know. Of course, they do everything. It's like a million ways to lose.
Right. That would be preserving it for later appeal.
Right.
I mean,
so it's like if you got to stand your ground here.
The DCA is not going to reverse the hearing judge's decision
They
and grant
could.
you immunity.
They could.
They could. Okay.
They could. Yeah. But you have to, and so you have to do that in order to preserve it for direct appeal. Now, so what would assuming like, so for example, if you do a self-defense immunity hearing, you lose, you do not do the interlocutory appeal. You go to trial and you lose again. I then cannot bring it up on direct appeal that the immunity hearing was granted because it wasn't preserved by interlocutory. Yeah.
Right, because now you have the intervening trial having happened. You'd be appealing things that happened in the trial. But if the state loses on immunity, as they did here, the state definitely has a period of time in which to appeal that grant of immunity.
Right. It's 15 days from the rendering now. Right. It's 15 days from the rendering of the order. The state has a very limited time frame in order to file a notice of appeal. I don't think they are in this case. I mean, if I was to put my money on it, we'll find out Friday if you get your interview in. If they appeal, I imagine the interview's off. If they don't, then you're going to have your interview on Friday. That's going to be great. You're going to love Hilbert and Kanan. These guys are really good attorneys in our area. In fact, Dan Hilbert is also board certified criminal trial lawyer, which I have been for 12 years now. And I will say that is the hardest test I have ever taken in my entire life, was the board certification test for criminal trial law. And I think there's only 17 attorneys in our 4-county area that have that certification. It's a very hard certification to get. And Dan has it. And I know Pat Kanan, he does a lot more than just criminal. He's a very wide-ranging civil trial lawyer. He's been around for a long time, very well respected in St. Augustine. That's funny. He lives right next to the St. Augustine Amphitheater, so he walks over there. So we always see him. He's a fellow progressive rock King Crimson fan. So when we always go and see these rock concerts, I'm like, Pat, how's it going? In fact, I even went over to his house once to see an in-house concert. He brought in some musicians to play at his concert. I'll never forget it. It's like, that is the coolest guy ever. I mean, you know me and music, right? So it's like he's bringing in these musicians to play in his house, and we had an in-house concert. It's with the California Guitar Trio, if anybody knows who that is. But so he's very cool, very nice guy too, really sweet. And you can see, I mean, like how genuine he was. Really getting frustrated with that optometrist. Just tell the truth. All you got to do is say the truth.
that testimony on cross was so outrageous. Oh, it doesn't matter. It doesn't matter if it's dark or light out. That doesn't affect your vision. It's like, okay. It doesn't matter whether your glasses are knocked off your face. It doesn't matter whether you've been smacked around. That's not going to affect your vision. I mean, this is all ridiculous. We all know if you're concussive, blurs your vision.
The right answer is yes. Just say it. I mean, just say the truth, right? But see, when you got a dog in the fight, then it all of a sudden becomes like personal, right? And my ego's on the line. You shouldn't have an ego on the line. You don't have a dog in the fight. You're an expert. You've analyzed, and this is what I see as the facts. This is my analysis, right? I mean, defend your analysis. You're an expert.
Imagine facing this expert in a future trial, and and you got him on cross. Be saying, "Didn't you testify at such and such a date that it doesn't matter whether it's light or dark? That doesn't affect your vision?" Yeah, I did.
Well, and this shows you how great I bought the Art of Cross Examination, by the way, the one you had done, you had read.
Oh yeah.
I need to read that, but this kind of goes back to that, right? There it is. This kind of goes back to what you were talking about the essence of the confrontation clause of the U.S. Constitution. The essence of that is exactly what we saw. I mean, this is textbook. Right. Because otherwise, okay, well, the state just let him bring in the guy Pope Hines that, he had no problem seeing, right? Okay, sit down. Now he's like, well, damn, But I mean, this shows you when he can't stand up to that hard questioning, tells you he should not be relied upon. But if you didn't have that cross, you'd never know that, right?
Yeah, absolutely. Crosses everything. Crosses absolutely everything. Because we all know if you only hear one side of an argument, it always sounds compelling. That's why we have an adversarial process, to make sure you hear both sides.
That was a
grand jury
textbook.
Indictments are so meaningless. I mean, because grand juries are really one side of the argument. So when people get indictments, it's like, well, whether or not the grand jury returns an indictment is purely a function of whether or not the prosecution wants an indictment. And generally they do. So they get it. Yeah, there are weird edge cases where a prosecution might be using a grand jury for political cover and doesn't really want the person indicted. And then they'll feed the grand jury what they need to not return a true bill, to not return an indictment. but those are very unusual cases. So an indictment means nothing in America, unfortunately. It should be a safeguard to keep people from being dragged into a costly, dangerous trial inappropriately, but it's really not. Hey, so
Anyway,
can
well,
you
I just
hang out,
wanted to.
Steve?
No, I'm taking about a 10-minute break, taking my smoking break.
Okay.
To pop in. I've been watching In and Out, and I caught that. Boy, this is a clip though. That cross, how to destroy an expert on cross right there. That would be that was so well done, and I just loved it. I just love that cross. I'm such a nerd when it comes to good at lawyering, and that was a good demonstration of good lawyering, good cross examination of an expert, and wonderful. And he sat down. He got what he needed, and he sat down. Didn't belabor it. Perfect. Yeah. Okay. Well, hey,
the whole thing.
I'm gonna get going. Hey, grift my book.
Ideas and answers in the law, folks.
There it is.
Steve Gosney, forward by none other than me, attorney Andrew Branca. Get this at crimelaw.net. That's the only place you can get the book, crimelaw.net. Now in the second edition, folks. Get the second edition.
This is the second definitive edition, because it has the chapter on closing arguments, ethical closing arguments by prosecutors. That, remember that I said I got my bucket list, the bucket list of attorney destroys. I didn't even know I wanted to do a destroy, but now I've got an attorney destroys up there, and it's on that one the one prosecutor. So I was like, bucket list item I didn't know I had. Oh man. All right. Hey, it was good seeing you, and keep up the good work. I'm looking forward to Friday.
What's happening? Oh yeah, of course, of course.
Stay warm.
We'll have Dan Hilbert and Patrick Cannon on live 1 p.m. Eastern time on Friday. I guess unless the state appeals this grant of immunity, in which case it probably wouldn't be appropriate for them to come on. But hopefully that won't happen. The appeal window, the notice to file appeal will expire as we expect, and Dan Hilbert and Patrick Cannon, the defense attorneys here, will have the opportunity to come on live. We'll have the opportunity to enjoy their participation here live. Law Self-Defense, 1 p.m. Eastern time. All right, Steve, thanks so much for dropping in, man. I really appreciate it. Okay, let's get back now to the next witness. The next witness is the second rebuttal witness, the last rebuttal witness, and the last witness for this self-defense immunity hearing. After this, we'll hear from the state attorney here, Mark Johnson, assistant state attorney, Mark Johnson. He'll argue to the court his position on self-defense. He'll argue for looks like about half an hour. Then we'll hear from the defense. They'll argue for about 20 minutes, and then we'll get another 5 minutes from the state. But this witness's testimony is quite long. It looks to be about almost 2 hours, folks. Now, I am playing at 1.25 speed, so it won't be 2 hours for us. And unfortunately, he's testifying over Zoom, so he's not even a human being in the courtroom. But we'll do the best we can with all of that. So here we start. This expert is Dr. Richard Hough, Hough, a criminal justice and criminology professor. So his rebuttal testimony is to counter that of a defense expert witness, use of force expert witness, Roy Bedard, that we covered yesterday. Here we go.
Raise your right hand. You swear affirm the testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God. I do.
So that's Dr. Hough on the left, and this is the prosecutor, Mark Johnson, assistant state attorney, on the right.
Dr. Richard Hough.
And Dr. Hough, for the benefit of some of the names like this later.
First name Richard, R-I-C-H-A-R-D, Hough, H-O-U-G-H.
Dr. Hough, how are you employed?
I am a professor at East Tennessee State University.
And what department do you work in?
The Department of Criminal Justice and Criminology.
How long do you work there?
Just at a year.
And where did you work before that?
At the University of West Florida in a similar capacity over 20 or so years.
And how about before that?
That probably would comprise the majority of my criminal justice full-time experience in a number of different law enforcement agencies, as well as the Florida Department of Juvenile Justice.
So you, as I understand, you worked in the academic field for approximately 20 years, is that correct?
That's correct. As an adjunct, probably started in the late 1980s, but full-time teaching in higher education, that's right, just about 20 years.
Can you describe your own educational background?
Yes, from higher education standpoint, I have an Associate of Arts degree in law enforcement, a Bachelor of Arts degree in public administration, a master's degree in public administration from Harvard University, doctorate in education with specialization in public administration from the University of West Florida, and all but thesis in a Master of Public Administration at the University of South Florida in Tampa.
What about your work history apart from academia?
Work history apart from that, I have worked in law enforcement since 1979. I've been training law enforcement recruits and officers in service in an academy since about 1983 or 1984, almost 40 years now. My predominant area of teaching certainly would be considered the use of force, and as a forensic criminologist, that is my specialty area, is confrontational homicide and confrontational violence and its investigation. I continue to teach those types of topics, but I also teach homicide investigation for law enforcement and a number of other areas if you'd like to inquire.
Well, let me ask you this first. How long did you work in? I think you said 1979. How long total did you work in law enforcement?
As a certified officer, I believe it was 26 years total. After I left state employment and went fully into higher education, I retained my certification just to be able to still do more modest patrol duties as a volunteer officer, since my work was upwardly mobile over the years. But I worked as a homicide detective in the 1980s in Central Florida, where much of my early research interest came from in terms of matters of violence.
So in terms of work history, both in law enforcement and in academia, would it be correct that that would span a period of 40 years?
That is correct.
Have you written peer-reviewed articles, textbooks, and book chapters that have been published?
I have. I'm the sole author of the textbook, The Use of Force in Criminal Justice and Criminal Investigations Today, co-author of both editions of American Homicide, and a number of peer-reviewed articles, certainly many international and national presentations in regards to confrontational violence.
Have you ever testified as an expert on the topic of homicidal violence and the use of force?
Many times, yes, sir.
Do you know approximately how many times?
I know in deposition, we tried to untangle parts of this as a criminal investigator and homicide detective and officer, probably 50 times, not all on violence, but I was a homicide detective, so that would be most of it. As an expert, I've been retained probably in 180 or more cases, probably testified therefore in about 70 cases that address issues of death or violence, probably 60 or more of those.
And in what states have you testified in?
I've testified, I believe, in 12 different states. The bulk of those would be Florida.
And in terms of criminal versus civil, what would be the breakdown in terms of types of cases that you testified?
As I said, my law enforcement career was all in Florida, so the 50 or so times testimony, both deposition and trial, would all be in Florida. And then also this past year, stand your ground case in, and I know we determined this in the deposition, but somewhere further south in Florida. I don't recall which jurisdiction it was, as well as would be testimony for the state attorney's office in Central Florida. I did presentation for their Central Florida homicide prosecutors team on homicide. I think that would probably be pretty inclusive.
I want to talk to you a little bit about some testimony that was received in this case. You have an opportunity to watch testimony from experts that testified yesterday in this case by the name of Dr. Roy Bidard.
I did, sir.
Did you? I want to talk to you about some of his testimony, specifically the testimony concerning, as it applied to this particular case, where he discussed the application of the use of force continuum and the dealing with whether the force was proportionate to the threat, validity of the perception
I did.
And how would you respond to that particular topic as it relates? And let me stop and let Lacey Brown look here. Did you receive materials from our office in this particular case?
Yes, sir, I did.
Okay, and what were some of the materials that you reviewed that you considered important in evaluating the use of force in this particular case?
The items that I received from your office that I would consider probably the most important would be video that showed Mr. Casado earlier in the evening prior to the shooting death of Mr. Moya, video from the Dos Gatos bar, a couple of the camera angle views that showed, once again, the actions and movement of Mr. Casado up to and then including the shooting. So from the standpoint of trying to evaluate or analyze this type of event that occurred, you're looking at what leads up to it, as well as how it unfolds in the final moments of when something occurs. So to the extent that we have that, which often does not exist, those will probably be the primary areas.
Did you also receive police reports, transcripts of witness statements, depositions, things of that nature?
I did, and of course, in examining the incident as thoroughly as I can, read those, as Dr. Bedard testified to yesterday. Some of the depositions, some are not necessarily as helpful for a variety of reasons. And then also, with the material I've been furnished, certainly the commentary or recorded comments of Mr. Casado as well.
And did you feel that information was sufficient for you to render opinions concerning the use of force in this particular case?
Yes, sir.
I want to return to the question that I began to ask you, and that was Dr. Bedard's testimony concerning the application of the use of force continuum. Do you have a response concerning his testimony as it relates to that issue and how it applies to this particular case from your judgment?
Yes. Again, this is grounded in, I'm sure I'm the only scholar who's done a statewide examination in Florida of all the use of force continua used by law enforcement agencies, as well as in my university teaching, my published works, and training actual officers about the application of these. And
So did I unmute myself? Yeah. So what I expect they're going to have this guy testify to, this Dr. Ho, is he's going to testify that a police officer in this circumstance, in the position of Casado, would not have used deadly defensive force. Does anybody believe that for a moment? I mean, maybe he won't testify to that, but that's what I think is coming, that the prosecutor is using this expert witness to try to argue that Casado's use of force, use of his pistol, was disproportional to the threat he was facing. It was just a slap fight. You can't respond to a slap fight with deadly force. And I'll just remind everybody that this is the photo of the injuries Casado suffered. That doesn't look like just a slap fight to me, but we'll see. All right, so far this is objectionable already. He's saying, hey, there's training used for law enforcement, but and it's well documented, well established. We don't have similar well documented, well established use of force continuum accepted standards for civilians. Well, first of all, this is objectionable because Casado's not claiming any particular training on use of force continuum. The question is simply based on the circumstances, was a deadly force response proportional to the threat? Was it a threat that a reasonable person could perceive as likely to inflict death or serious bodily injury if it continued, right? Was it an imminent, not actually occurring, not what's already been struck, but it was of a nature that could readily inflict death or serious bodily injury? That's the legal standard. It's not a use of force continuum standard. No.
Watch the video and
I'll rewind it just a few seconds, folks. Sorry about that.
Transcripts of witness statements, depositions, things of that nature.
I did, and of course, in examining the incident as thoroughly as I can, read those, as Dr. Bedard testified to yesterday, some of the depositions, some are not necessarily as helpful for a variety of reasons. And then also, with the material I've been furnished, certainly the commentary or recorded comments of Mr. Casado as well.
And did you feel that information was sufficient for you to render opinions concerning the use of force in this particular case?
Yes, sir.
I want to return to the question that I began to ask you, and that was Dr. Bedard's testimony concerning the application of the use of force continuum. Do you have a response concerning this testimony as it relates to that issue and how it applies to this particular case from your judgment?
Yes. Again, this is grounded in, I'm sure I'm the only scholar who's done a statewide examination in Florida of all the use of force continua used by law enforcement agencies, as well as in my university teaching, my published works, and training actual officers about the application of these. And so with that as the predicate, there are not published nor mandatory recommended use of force continuum specific to civilians. And so the comparisons they're there. There are some comparative points, but they are not directly translated. But what we see in both the civilian application and law enforcement may sometimes be proportionality and whether or not the response to some type of perceived threat or overture is proportional in a sense of how the average person would view that, as opposed to how a jury may view something later.
After having watched the video and saw sort of the interaction that Mr. Casado had with the individual in the video, the individual that he eventually shot in the video, and exactly kind of how that event transpired, do you have any opinions concerning the force that was used against him and the force that was used against that individual?
I do. Once again, evaluating this, whether it was my time as a homicide detective, all my years now as a homicide researcher and investigations researcher and computational homicide, there's a lot of fairly classic issues here presented in this kind of violence. But the proportionality issue, as I said, you have to begin before this, the same way as the traffic homicide investigator, we look 24 hours before suicide. As a suicidologist, I look, even further back very often about what leads up. In this case, you have intoxicated individuals, which implicates decision-making at various points in this. You have the behavior, specifically of Mr. Casado in searching out individuals to talk to. You have individuals who are just doing whatever they're doing outside of a bar in a pretty nonviolent area, according to all the statistics in St. Johns County and St. Augustine. So leading up to that, and then.
So, folks, this is something I've talked about earlier, right? If you've watched the previous days of our covering this trials, your privilege of self-defense does not go away because you're drunk. You have the same privilege of self-defense you had before when you were sober. The difficulty is it opens the door, you being drunk opens the door for the prosecutor to argue that, hey, this guy had been drinking. And we know when people are drinking, they make suboptimal decisions. They make unreasonable decisions when they're drunk. And therefore, you should infer from the fact that this defendant was intoxicated that he did not act reasonably in self-defense. And of course, reasonableness is one of the elements of a claim of self-defense. That's the argument this expert is going to make here. Remember, this expert was hired by the state. They've prepped for this. The prosecutor knows, the expert knows what questions the prosecutor is going to ask and what answers the prosecutor is expected to get back from him. And I expect that's the argument we'll see here.
Finally getting to a point where we might.
And to be clear, if you're drunk, but you make appropriate decision in self-defense, so you use deadly defensive force only when you're facing a deadly force threat, for example, that's good self-defense. You don't lose self-defense just because you're drunk. But if you're drunk and you make bad decisions in self-defense that violate one of those required elements, well, then it wasn't self-defense. Being drunk doesn't change the legal elements of a claim of self-defense.
To quickly jump to merely look at what we think we're seeing, and the violent encounter, I am of the opinion, based on all of that, that the proportion or proportional response was not there. In fact, the use of a firearm to the type of drunken behavior and slap fight attempt that we saw would not be considered proportional.
There was a lot of
I would bet $100 that this expert, who's himself apparently a former police officer, would not hesitate for a second to draw his pistol and fire under these circumstances, the circumstances in which Louis Casado found himself.
discussion as well about when the assault occurred, that there was suddenly a sort of a narrowing was a deleterious effect on perceptions and things of that nature. So there's a lot of discussion about that. How would you respond to that?
Yes, sir, that the way both in deposition by Dr. Bedard and in testimony yesterday, seems to me was presented as a rather categorical blanket approach. It is not. Not everyone has any particular deleterious or dysfunctional type of response. Among those that do, from the research that we know from both the military and from law enforcement and from civilians, some people may experience what we commonly refer to as tunnel vision or weapon focus effect, where you may be just focused on one thing. Some people may experience auditory exclusion, where perhaps you don't hear some particular thing that has occurred around you. Some people may have a temporal effect of later believing that it felt as though a situation sped up or slowed down. Some people may afterwards have some aspects of memory, either impairment or gaps, based on a variety of factors that are involved here. But again, not everybody does. Research shows that, again, with law enforcement, you'll have a percentage where more than one effect is there, but many where it's only auditory exclusion or only tunnel vision, something along those lines. So to the extent that it was presented perhaps as, well, Mr. Casado or anybody else automatically is being affected in this period of time, whereas we can clearly see effects of alcohol and a lead up of that, as opposed to whether or not there was any of these other physiological effects in the moments of the final shooting of Mr. Moya. We cannot be certain of that from a scientific standpoint.
Chris, the legal question is not, is there scientific certainty? The legal question is there a reasonable probability that would prevent the state from disproving this claim of self-defense by clear and convincing evidence? We're not doing a scientific study here. And no scientific study, by the way, goes to absolute certainty either.
Given the fact that some people may experience those reactions and some people don't, is it important to find out exactly what the person, how they were perceiving the events around them?
Yes, absolutely.
And what would be the best way to do that?
To sit down, have a discussion with the
Same objection. They want to talk to the defendant. So objectionable.
individual, interview them, ask about what, if any, effects they may have felt in that relevant time frame.
By the way, when police officers in the aftermath of a use of force event are compelled by their department to give an initial statement, that statement cannot be used against them in court. That's part of the deal, to be able to compel them to make the initial statement. So this is ridiculous. This is all the objections that Attorney Patrick Cannon has already raised. Fifth Amendment objections, burden shifting objections. It's just ridiculous.
And is it your opinion, Dr. Buck, that in order to be able to state with any sort of degree of scientific certainty as to what the individual, how they were experiencing the situation around them, whether or not they reasonably believed that those things, that there was danger to them, that they would need to be talked to and find out for sure exactly what they perceived when they believed?
Objection relevance, overruled.
Yes, again, from the standpoint of truly being able to fit some more pieces of the puzzle together here, you would need to do that. That would absolutely be the best way.
I want to go to once the shooting began, we already talked a little bit about proportionality as it relates to the initial assault. At some point in time, when somebody begins to use force to repel force being used against them, there was some discussion about a person's ability or inability to perceive that the danger was no longer there to stop the force that they were used. Did you hear that testimony from Dr. Bedard?
I did. I did.
And was there anything that you saw in the video that you believe is important for the court to know in evaluating the defendant's ability, whether or not he perceived perceived at some point in time, based on your review of the video, that the danger had ended and that he actually had the ability to stop using the force that he did.
Yes, sir. Again, with kind of, my takeaway for the court's benefit of the testimony, both in deposition as well as yesterday in the hearing of Dr. Bedard, I cannot, and I would not, as a researcher and a professor, go through perhaps a bit of a narrative about what I presume Mr. Casado was thinking as we move through the series of events, what I saw and what I would evaluate based on, again, being someone who specializes in confrontational violence, which accounts for over 45% of all homicides in the U.S., is that you have in Mr. Casado an individual who, throughout the evening, we know had alcohol, as did Mr. Amoya, based just on observations of his condition as he leaned against that wall, and then sought out individuals to speak that did not seem well received. Certainly in the case of approaching Mr. Santiago and the other gentleman initially, there seemed to be some back and forth, but laughter. We're not sure what then the interactions, but.
All right, so I have to be, I want to share this again. This is the video. Until Amoya comes off the wall and starts being confrontational with Casado, show me where Casado's not being well received by the other people in the group in this surveillance video. Here it is. Oh, this starts too late. This starts at the confrontation point. Casado is just chatting amiably with all the other people here prior to Amayo becoming confrontational. So this is nonsense.
To see Mr. Casado be unsteady on his feet a couple of different times. This was notable, at least one point, looking off and apparently saying something to, I didn't see anybody there that he was talking to, and there was testimony that I reviewed in this case that I've been provided that indicated that happened earlier at another bar. And in what we teach law enforcement officers, and which again is a different and a higher level of training. And as a security officer, I don't know what Mr. Casado's training actually is, but the going back into your pocket several times is not an unusual display or demeanor of someone checking where the weapon is. I know there was, in this same line of questioning discussion in regards to after, I think, the third interaction with Mr. Amoya turning Mr. Casado away from the group, that Mr. Casado turned and had his arms open. And I heard Dr. Bedard, from his standpoint, repeatedly state that that was a negotiations technique or expression. I would very strongly differ with that as someone who has trained in this area for nearly 40 years about how sometimes what we see is someone who with their elbow is in. And we teach this to law enforcement officers in Florida. This may be more like this. Quite frankly, what I have taught for many decades and what is more supported in literature in regards to aggressive stance and behavior and everything is that this is more,
Look, this is in the video. So let's take a look at this. This is the hand position that actually occurred. Okay, so the hands are inside the elbows. They're not outside the elbows like this expert is suggesting here. The hands are inside the elbows. And look what the expert is doing here. I mean, this is just dishonest. He's countering it most strenuously. He's scientifically countering that most strenuously. This is not science. This is nonsense. Oh, I did it again. Darn it, I did it again. Okay, sorry. I'll go back to the hand position. There we go.
Nearly 40 years about how sometimes what we see is someone who with their elbow is in. And we teach this to law enforcement officers in Florida. This may be more like this. Quite frankly, what I have taught for many decades, and what is more supported in literature in regards to aggressive stance and behavior and everything, is that this is more, hey, don't do that. Once again, I'll interject. I don't know what Mr. Casado was thinking, but I could certainly say scientifically that this is not a universal sign I want to negotiate, and I would certainly counter that most strenuously in terms of what we saw there. Again, we're aware of the rolling of the video that the court has undoubtedly seen many times, as well as the various participants here in the hearing. That when we move forward with a specifically two intoxicated individuals, we could throw in Mr. Santiago, who also slapped Mr. Casado, striped, if you will, who was also, appearance would have it, as 40 years in this business, an intoxicated man, after two strikes in the face or two open hand slaps. And I know this came up in deposition, in the hearing yesterday, because of course I pointed this out in deposition a week or so ago, but it was after the second strike to the face that Mr. Casado was reaching into his pocket for the firearm. Whether he was able to, in the reality of the moment of a drunken Mr. Omoya still attempting to slap at him, able to get that yet as he backed up. That took another second or so to get that out.
And I want to kind of keep going from there, specifically once he began.
Again, when he's reaching for the gun in his pocket is not the legal question. You're allowed to reach for a gun in your pocket. That's not a use of force against someone. The legal question is, at the moment he fired the shots, was he legally justified?
Firing the gun, and again, we were talking about sort of the ability to perceive the danger that ended. In this particular case, as you know, I'm assuming you also reviewed the autopsy before and some of those materials. Is that correct?
I did. That's in virtually, certainly my time in homicide, but over the last 15 or so years.
It would be interesting to know if this expert's testified as an expert favorably for police officers whose shots hit suspects in the back.
Majority of cases I work are usually lethal cases of shootings, and so yes, that's familiar territory for me for a very long time. And yeah, as my observations, again, as Mr. Casado stepped backwards away from Mr. Omoya's slaps and slap attempts, strikes and strike attempts, with his, also at that point, Mr. Omoya, hands down, we're like, come on, let's do this sort of thing, just to be kind of colloquial there. Then as Mr. Casado, you see him withdraw the firearm and bring it to point shoulder, immediately, and certainly I differ from Dr. Bedard's deposition testimony that Mr. Omoya was able to block bullets, but instead he saw the gun and raised his hands. And whether as someone who teaches people about what threats are, as an expert, I would say, oh, hold on, or as the court or anyone else may view that, as the first shot occurs, there was certainly talk made about what generally is agreed upon is about 250 milliseconds or a quarter of a second on interpretation of what you're seeing, which again jumps to the end of this lethal involvement as opposed to hours before and the beginning of what came out as the event eventually. And that, from my standpoint of objective evaluation, is truly important. And then, of course, Mr. Omoya turning.
I'm going to rewind that like the last 10 seconds. And all of you in the audience can tell me whether these words make any sense to you at all, or is this just word salad coming out of this expert's mouth? I literally cannot understand what he was just trying to say. Let me rewind it just a few seconds here.
Which again jumps to the end of this lethal involvement as opposed to hours before and the beginning of what came out as the event eventually. And that, from my standpoint of objective evaluation, is truly important. And then, of course, Mr. Omoya turning away and through, whether it is the firing of several rounds and emptying a magazine, to which we immediately see Mr. Casado step back away from the gentleman passing him and immediately check his magazine. That period of time, you can fire those many shots in 2 seconds. That's not a question. That's really not a difficult thing to do. The question is decision making leading up to that, and the effect of alcohol, as well as the person is turning away and running and being struck in the back by some of those. So the use of science to merely speak about 1.6 seconds or the number, if we really had it, perfectly attuned, is the fact that with the increments of time that your prefrontal cortex, which is the first thing affected by alcohol, has said to your sensory nerves to tell your motor nerves, pull a trigger, it has the ability, in sequence to stop that. Whether he could have at that moment, again, I don't know. I can't say that he did, but that's why everything that led up to that is important to know.
Did you see any?
So he's suggesting here that because Casado had a few drinks, that means it could not have been lawful self-defense. That's not the legal standard. The legal standard is, would this conduct have been lawful self-defense if Casado had been sober? If so, it doesn't matter that Casado had a few drinks.
Anything about the way that Mr. Casado held the gun, pointed the gun, as he was firing the shots that indicated to you kind of a recognition that Mr. Moya.
I'm waiting for this prosecutor to ask, was there anything about the evidence that you've seen that would suggest that Mr. Casado is just guilty as F of manslaughter?
Longer threat that was actually running away.
I did two things, and Dr. Bedard actually used the phrase yesterday about pointing at Mr. Moya, and that's certainly true, where you see Mr. Casado, without getting into too much jargon and trying to jump this up a little bit, he brought his arm up and he pointed at Mr. Moya, who raised his hands, and as Mr. Moya turned and ran, he ran at an angle, and certainly by looking at the Dos Gatos videos that are available, Mr. Casado is seen to track and move at a 30 or so degree angle, whatever it is, to continue shooting. And with
Was he incompetent because he was drunk? Or was despite being drunk, was he so competent that he was able to track a fleeing target departing at an angle?
A good bit of accuracy for firing off that many shots in that short of a period of time, as he's not falling, stumbling, but walking backwards. One shot that's very telling there is the gated view at Dos Gatos, where he walks backwards, and then the overhead view from a bit forward, where he backs into the frame where the three other individuals run down the fully available street there and run away once they realize that Mr. Casado is standing there firing the gun. And then again, as I said, you see Mr. Casado step back with his left foot and immediately check the magazine on his, I think he called it his smallest gun.
I have another question.
Cross-examination.
All right, cross-examination. This should be good. Come on, Patrick Canan, bring it to this purported expert witness. And of course, Steve made a great point here in the comments, that Steve Gosney that I noted too. When, according to this expert witness, when this expert use of force expert witness, when Casado, the defendant, raises his hands, that's an aggressive posture. But when the victim, Adam Amoya, raises his hands, that's a, oh, I don't want any trouble posture. And of course, folks, anything you do is wrong, right? Anything you do in defense is going to be wrong according to the prosecutor. So was Casado so drunk that he couldn't act reasonably? Or he was still so competent despite the drinks he could track a fleeing Amoya and check his magazine after the shooting?
Good morning, Dr. Buck.
Good morning, sir.
Your degrees are in public administration, correct?
1 degree is in law enforcement, 2 are in public administration. The doctorate is in education with specialization in public administration.
And you've never been qualified as an expert in psychology or neuropsychology, is that correct?
While I am a member of a couple of different psychological groups, and the fact that forensic criminology includes anthropology, sociology, and psychology, I am not a psychologist.
You've never been qualified as an expert in human factors, is that correct?
I don't actually know, Counselor. Much of what I testified to in state and federal court has to do with what is now the term of art and human factors, which for my 38 or so years.
So I'm going to interrupt here just a moment. This guy, anyone who does any self-defense instruction, and I did my share many years ago, has run into the student that's a certificate collector. So this particular kind of student, there's nothing wrong with having a lot of certificates, folks. Get training. Training is good. But it's a certain kind of student that, when you get training, when you take a shooting course or whatever, the idea is not that when the course ends, that's the full development of your skill set and what was taught. The course is supposed to teach you what you need to practice moving forward to fully develop that skill set. Right? Here are the skills you need to learn. We demonstrate them. We show you how to do them correctly. And then you go home and dry fire or whatever you need to do to hardwire and fully develop that skill set. But there's a class of student that never does that. Never does that second part. They take the weekend course, they get their certificate, and that's the last time they think about that skill set. And they hang their certificate on the wall, and they end up with a wall with 50 certificates and no fully developed skill set in any of that stuff. They can't run a gun. They can't do trauma care. They can't do any of the stuff that's in those certificates because they never actually developed the skill sets. Well, Steve Gosney was kind enough to send me this expert's website. And that's the first thing I thought of when I looked at this guy's website. So this is it. And Dr. Richard Howe Consulting. And you scroll down, experienced criminal justice manager, nothing about psychology, use of force, human factors, offers expertise and insights to clients facing challenges that come with organizational issues or litigation. Nothing to do with psychology, use of force, or human factors, none of the Force Science Institute stuff. And you scroll down a little more and look at all the groups this guy's a member of. Look at all of them. He joins everything as a member. He's a member of all these things. Does he have expertise in any of these things? Or is he just the certificate collector student? It looks to me like Patrick Canan is digging into the possibility that this expert witness is just a certificate collector student.
Years of teaching defensive tactics and aspects of deviant and violent behavior has to do with what humans do. There's now a niche area in the last 8 or 9 years of actually charging people to get certifications in human factors.
You've never been qualified as an expert in human factors, correct?
That is correct, as far as I know. I don't know what the court felt, but not labeled human factors.
When I look at your CV, it seems almost predominantly, or actually almost every one of your cases is a civil case. Would you agree with that? 95%?
As I told you in the deposition, yes.
And you testified earlier that you testified one time in a stand your ground case, but that was a civil case in Daytona Beach, wasn't it?
It was quite groundbreaking, yes.
You've never testified or been retained in a criminal case for stand your ground, is that correct?
That is correct.
What's the evolution of the stand your ground law in the state of Florida?
Oh, I love that question. It probably is irrelevant, but it's a great question because stand your ground has undergone a lot of change since it was enacted in 2005. I've mentioned this before, but a lot of states adopt the Florida stand your ground law. The stand your ground law is very simple. It basically says if your use of force was lawful self-defense, you can get immunity from criminal prosecution and civil suit. But it didn't tell the courts it didn't provide any guidance on how to determine that. So how do you determine if the use of force was lawful self-defense? Do you have to go to trial to make that determination? I mean, that was an argument that was made in the early years. And therefore, if you're successful at trial, do you get a grant of immunity after that? You don't need it. Either you've been convicted or you've been acquitted. When is this hearing held? Who has the burden of proof? To what legal threshold of evidence is the burden of proof? All these things had to be determined by the courts in Florida, and different Florida trial courts, hearing courts, made different decisions on these things. So all these decisions had to be appealed to the appellate courts and ultimately the Florida Supreme Court. And this has been happening since 2005 in Florida. So it's a very, very complex evolution. And of course, this guy won't have any idea about any of that. I mean, I study this stuff pretty closely, and I wouldn't know all the nuances off the top of my head.
Well, a little similar to Dr. Bedard's recitation yesterday, more kind of globally for the U.S. This is a little bit of a move forward in evolution from Castle doctrine, which really only applies to homes, to where in 2005 we saw the state of Florida move to what was known as the stand your ground law. Shortly after which we saw self-defense claims triple in the state of Florida for self-defense in these kinds of cases. Now, and there was movement to change legislation a couple of times in the state of Florida in regards to, not burden of proof as much as whether or not, again, proportionality was at issue. I think we're now at 38 states in the U.S. that have some version of stand your ground law, or some are called line in the sand laws, and some other colloquialisms for those.
Was there a significant change in the state of Florida in 2017 in the stand your ground law?
There was attempt at, that was one of the years where I think there was a couple of different bills provided as to a memory test for me on what language changed as regards civil suits where a hearing finds that a person was justified in the use of some deadly force. I don't know the language of that. Sorry, Counselor.
Do you know what the burden of proof is in a stand your ground case in the state of Florida?
Well, I would certainly say that I'm not here to offer legal opinion nor comment about the state legislature's intent, et cetera. So burden of proof, I think what you're probably getting at is that may fall to the prosecution, and I don't know that the court needs the input of a forensic criminologist to talk about a legal issue.
Well, you are a forensic criminologist. I'm just asking you, in your education, are you familiar with the burden of proof in 2022 in the state of Florida in a criminal stand your ground case?
I appreciate that, which also clearly misunderstands what a forensic criminologist is.
So you do not know, correct?
I believe I heard you say yesterday in court that falls to the prosecution.
Do you know what the specific burden is? It's a yes or a no.
Counselor, you're trying to elicit a legal opinion from me that generally in a court where I've been, I'm not allowed to give that testimony.
I'm not asking for an opinion. I'm asking if you
Oh,
have
you're not?
knowledge
Okay.
of the burden of proof and how it's stated in the state of Florida. Not an opinion at all. Do you know what it is?
The burden of proof is on the prosecution.
And what type of
Sorry if
burden?
I haven't answered that.
What type of burden is it? What type of burden is it?
I don't
What is
understand.
specifically the burden?
To prove that the individual was not, well, I don't want to, I don't want to say that because
So we talked about this earlier, right? There's several common burdens of proof in court proceedings. One is kind of a prima facie, more than zero evidence of something. There's a preponderance of the evidence, 51% of the evidence. There's beyond a reasonable doubt, which is, let's call that 95% of the evidence. Preponderance is, 51%. The burden here is what's called clear and convincing evidence. We can call it like 75%. It's between preponderance and beyond a reasonable doubt. And the state has the burden here in this immunity hearing to disprove self-defense, meaning disprove one of the required elements of self-defense by clear and convincing evidence. And Patrick Canan is just pointing out that this guy doesn't know what the burden is. He knows it's on the state, but he doesn't know what the legal threshold is. Frankly, he shouldn't know. He's not a legal expert, but that's the line of questioning.
this doesn't run to, I'm sorry, go ahead.
You said the burden was on the state. Is it by a preponderance of the evidence, clear and convincing evidence, or beyond a reasonable doubt?
And again, my understanding is beyond a reasonable doubt, and I'll certainly accept the court's correction on that, because once again, I've not been proffered as a lawyer.
At trial, the burden is on the state beyond a reasonable doubt. At the immunity hearing, the burden's on the state by clear and convincing evidence.
As a legal expert, but as someone who's an expert in confrontational violence.
You indicated that you were contacted by the state attorney's office, correct?
Yes.
initially. In your initial contact, you were asked to rebut Dr. Bedard. Is that correct?
Evaluate this case and then specifically look at Dr. Bedard's views or opinions and offer rebuttal.
So you weren't provided the case and asked to provide an opinion about whether or not this was an appropriate shooting or an inappropriate shooting pursuant to Florida law, but instead simply asked to rebut Dr. Bedard.
As to the wordings or what I understood, as you pointed out, and I think we could certainly go to the.
All right, so this is an important line of questioning. It's a little technical, folks, but this guy was not called as an expert witness by the state to give a generalized opinion on whether or not Casado's use of force was lawful or reasonable. This guy was called specifically as a rebuttal witness to the defense expert, Roy Bedard.
Confusion that you and I had in the first attempt at our deposition to illustrate the fact that whether or not I was clear on how this was going to necessarily, from a procedural standpoint, I certainly understood that I was looking at all the information I was presented as Mr. Johnson presented on direct and come to my own conclusions about what it was that occurred.
But you did just testify that you were, when you were initially contacted, it was to rebut Dr. Bedard, correct?
What I just testified to was to evaluate the incident and to look at and rebut aspects of Dr. Bedard's views if those could be determined, yes.
And you had read some of the, you had indicated in your, before, that you had read some of the statements. How many depositions have you read?
As I told you in both the first and second deposition, in the first deposition that you and I began and canceled, I had read 3 or 4. And then the second deposition we held, I reminded you that I've read the statements because the contemporaneous commentary by various individuals who offered any kind of information was certainly more salient. And by then I'd read several more depositions. Again, as a memory test, how many I read, I'm not sure.
Since the last deposition, can you give me the names of the depositions you read?
No, I have been in 2 depositions and a trial since then. I have a hearing tomorrow to try. Again, if you forgive me, I'm usually in a place where doing a memory test is not really seen as particularly relevant. No, I can't give you the names of those.
He disparagingly calls these questions memory tests, but he's providing an opinion, and it's perfectly appropriate for counsel to ask him, on what are you basing this opinion?
I can't.
And please refer to the notes that you would have taken when you were reading each deposition and tell us which depositions you've read.
I'm sorry, repeat that so that I can
Did you
try
take,
to.
when you read depositions to prepare for your testimony, did you take notes of what you were reading?
Well, of course you know that because you asked me that deposition and I said I didn't know to do notes from those.
So there is no record of what depositions you've read or any notes from those depositions that you've read. That accurate?
No, that's not accurate because of course under sworn testimony, I enumerated for you in both depositions the ones I've gone through. So I'll treat my sworn testimony as proof. Yeah.
That's only after you went back through the names on a screen. My question is, did you take any notes of who you read and notes from those depositions of what it contained?
I'm sorry if I did not answer that several times.
I'm going to ask it real quick. Did you write down the name of the witness on some record once you read the deposition?
No, that's what I told you in the deposition.
Well, we're not in deposition, we're in court. So you did not take down the names. Did you take any notes as you read the depositions? The
I
names
appreciate that you're not allowing me to answer the questions, counselor, that you posed to me. And again, I find that unusual. However,
It's coming. This is bad. This is like the optometrist. This expert is coming across as non-responsive, non-cooperative, hostile.
as I said, my reliance on evaluating this case doesn't fall to whether the 3 young ladies sitting on the park bench across the way who saw nothing, what I take away from those and whether I report that or not. No.
Thank you. So you're relying on your memory for all the depositions, correct?
No, I have the deposition, so I'm not relying on my memories.
You indicated that you talked about confrontational homicide, correct? And you put this in that category, don't you?
I do.
And would you agree with this definition of confrontational? Tending to deal with situations in an aggressive way, hostile or argumentative.
I appreciate whatever you're offering. I go to Polk, Luckenbill, Bailey and Wilson, 47 years of research in confrontational violence and homicide, and the various definitions were really structures and frameworks about the dynamics. No, I'm not going to.
This is so much word salad. So I hope Patrick Canana asks him now, will you provide the court with your definition of confrontational and explain how it differs from what I just read?
I don't know what you're offering.
Just
So,
some words from a dictionary.
Okay.
Do you
I
dispute that that's a definition of confrontational?
If you present that, confrontational,
Yes.
I don't know if that's a definition from some dictionary about confrontational. Again, confrontational homicide is a theoretically based, researched aspect of how much homicide and violence occurs.
But it's typically when it involves two people and something initiates some encounter and then it escalates, correct? You've used the
No,
word
I
escalation.
don't think that's a. Please let me finish, Counselor.
Sure.
No, sir, I don't believe that's a very.
This guy's presenting himself as an expert in confrontational violence. Perhaps you could provide the court with a definition, your definition of confrontational violence?
Good definition at all.
What is the definition of confrontational?
There we go.
Well, as I said, through 40 years of research, we may not come to complete agreement, but one of the major flaws in what you were just asking me is the confrontational violence. Usually, instead of just two individuals, there is also the element of audience, which we have here. There is most frequently an element of alcohol, which we have here. We have the potential perception of an honor contest, a perceived slight, usually within one of the very earliest definitions, retaliation, which is also a word that Mr. Casado used in at least one of the documents that you're aware I saw. So it encounters more than just two people in an escalation.
What can you describe as being any confrontational conduct on the behalf of Mr. Casado?
As I mentioned on direct, as you build through an evening of inserting yourself or attempting to in the conversations of others, what that may mean, we have to look at a cumulative effect where we have Mr. Casado. Sorry, are we there?
Yes.
Okay, where we see Mr. Casado come outside after talking to one other individual who they eventually quit talking. Then he loops around a group of other people on the sidewalk to come over and begin conversing with the individuals who are standing there, Mr. Santiago and the other gentleman. Then the different interactions with Mr. Amoya to include when Mr. Amoya turns him away, Mr. Casado, and then Mr. Casado turns back, which can absolutely fit within a pattern of, we may here have the affront or slight that he might perceive. Don't know that, but that's where it would fit within confrontational violence. The opening hands gesture, which certainly more likely than, hey, I want to negotiate, might be, hey, keep your hands off me. Again, I don't know because I can't hear what he said at that moment, and we don't have Mr. Amoya's comments in regards to what was said.
Have you watched the trial? Have you watched this hearing all week?
No.
Is the only thing you
No.
watched Dr. Bedard?
Yes, that's the only thing that was furnished to me. That's right. No.
Well, let's start with intoxication. Are you aware that the bartender at Bog said that Mr. Casado did not seem to be under the influence of alcohol?
I'm aware that the bartender at Bog had a.
That's just a yes or no. That's a yes or no. Are you aware that that's what she testified to in this hearing?
Oh, well, I'm sorry. I just said I haven't watched anything but Dr. Bedard's testimony. So in answer to that or any other questions about testimony that's been given, my answer would have to be no. But I have seen all the depositions.
Are you aware that in this hearing, the security guard who led Mr. Casado into Dos Gatos testified that he did not appear to be under the influence of alcohol?
I would have no idea how many
Thank
people
you.
he saw.
Thank you.
but he
Yes
said-
or no, sir? Are you aware that two bartenders from Dos Gatos both testified that he did not appear to be under the influence of alcohol?
No, I have no idea about that.
Are you aware that the officer who had contact with Mr. Casado after the shooting, within minutes, Corporal Yarborough testified that he did not appear to be under the influence of alcohol?
No, I have no knowledge about that.
But you are aware that Mr. Moya had a toxicology of 0.266 alcohol.
That sounds familiar, and based on his movement and behavior, I could see that.
And would you also agree that that that's extremely intoxicating?
I've arrested people at 0.42. So as I mentioned, so that you'll get a complete understanding, when we look at homicide, suicide, traffic homicide, how big is the individual? How much did they eat? When did they last sleep?
I'd love to hear the argument for how 0.266 is not 3 sheets to the wind.
No, I couldn't just sign on to saying, yeah, that's extreme intoxication. His behavior and his leaning against the wall and his wild swings would tend to indicate he was pretty intoxicated.
Well, intoxicated people oftentimes are aggressive, aren't they?
More people who are intoxicated are not, so I can't accept your categorical blanket there.
How about add hydrocodone to the mix?
This expert already testified that alcohol is a common component of confrontational violence.
Do you think that would have affected his behavior?
Not being a toxicologist, I would say that a painkiller as a depressant may in fact slow his responses, slow his thought process, could help explain the wild swinging, yes.
But large amounts of alcohol and narcotics can trigger violent and uncontrolled behavior, can't it?
In certain circumstances, there may be some effect because, of course, alcohol is both a depressant and a stimulant. And so you can have, again, as I testified to earlier, a lowering of inhibitions and decision-making by both Mr. Casado, Mr. Santiago, Mr. Amoya, any of the other people leaving the bar that night who had a fair amount of alcohol.
Did Mr. Casado at any time exhibit violent or uncontrolled behavior?
He shot Mr. Amoya several times.
I'm sorry? Say it again?
He shot Mr. Amoya to death.
After he was in fear of death, would you agree with that? He was in fear of great bodily harm?
You're testifying to the record, Counselor. I'm not aware that Mr. Casado provided that as a statement anywhere, but at his shooting, you asked me the question, was there any violent behavior by Mr. Casado? And he pulled a gun out of his pocket and he shot Mr. Amoya. I would only just offer that I observed that.
I'm going to read from your book called The Use of Force in Criminal Justice and see if you agree with me on page 159. There's a frequent connection between alcohol use and aggressive behavior. You agree with that?
As we talked about,
Oh my God, it's a yes or no question.
you're not cutting me off again. That manuscript was completed in 2017. I didn't know here in 2022 we'd be sitting here. So your use of a snippet that I either did write or didn't, since I'm not looking at that book, whether that's a quote or I said that, is there a connection? Yes, I testified already earlier that in confrontational violence and homicide, alcohol is very frequently present.
This is from the same book, the same page. Just tell me if you agree with the statement that's in your book.
I appreciate you offering to tell me how to testify. Counselor, this isn't my first trial. I've told you that. Go ahead.
Thank you. Various ingested substances can trigger violent or uncontrolled behavior.
I think that's an accurate statement.
And would you agree that Mr. Moya exhibited violent and uncontrolled behavior?
I wouldn't characterize it that way. I'm sure that that's certainly how you might view it, or others. I did say wild swinging, the lower inhibition, the fact that after, however it's viewed by the court, and lead up to it, that he did in fact strike Mr. Casado in the face and tried to repeatedly open hand slap him and strike him. Yes, I saw all that.
In your testimony, you didn't mention the word fear one time, did you?
So far today in testimony, I don't believe I have.
Is fear critical to the analysis of a stand your ground case?
Not necessarily, because that may be something that we don't know of. In those last, couple of seconds, Mr. Amoya, what fear he felt, what Mr. Casado may or may not have felt in terms of fear, to what degree and whether that affects the proportion of using a firearm in that circumstance. So to the extent we can know it, it might be helpful to at least hear about it.
So when you're talking about proportionality, you don't calculate fear into the equation,
Oh, it absolutely can be calculated in.
but you do not calculate it in this equation in this case?
We don't, I don't have any information to work from as far as fear goes.
Well, since you're here to testify about stand your ground, and we're here pursuant to Florida Statute 776012, it provides that a person is justified in using or threatening to use deadly force if you finish that sentence.
Well, you're doing another memory test of somehow, I don't know if you're,
No, it's the legal standard. So this is just 776012 is simply Florida's self-defense statute. And I'm sure Patrick Kanan is just about to read it, but let's see. Essentially what the statute does is it sets out the elements of self-defense under Florida law. And I'll just pop it up quickly here. So this is the statute here. This is paragraph 1 is the conditions that have to be met before any degree of force can be used. And paragraph 2 here is the deadly force self-defense provisions of Florida law.
I don't have all the Florida statutes memorized.
Just this one, sir.
Oh, just this one? Well, I'm sorry. I wrote a lot of different things.
I'll sustain the objection. Doc, I sustain the objection. Stop answering, please. Ask your next question.
Did you notice in the videos in the bar that Mr. Casado appeared to have friendly conversations with a number of different people?
I can recall at least one where he was sitting at the end of a bar talking to a young lady, and it's hard to characterize friendly or unfriendly without hearing it. It did not seem unfriendly for whatever benefit that is.
Did you also see him talking to a man with a hat on?
I can't recall.
Do you ever see him hugging a man with a hat on before he left the bar?
No, I don't recall that.
Does it help you if you would know that in this hearing, the people in the bar testified that he was polite, there was nothing hostile, there was no threatening behavior? Can you put that as part of your calculation, or is that not relevant?
Oh, no, certainly. You said, is that helpful? It's helpful only to provide a springboard to point out that what happens the next moment, or the next minute, or the next 20 minutes is not necessarily tied to the fact that you were not confrontational or hostile.
This guy is so self-contradictory. 10 minutes ago, he was testifying that, well, you have to consider what happened prior to the actual use of force event. Now he's saying, well, what happened prior to the actual use of force event doesn't matter.
For somebody who is in the bar.
So when he walked out of the bar, have you seen the video where he also had a conversation with a different person outside the front door?
Yes, sir. I already referred to that a few minutes ago.
And just by looking at that video, did it appear to be a friendly conversation?
I did not see indications in that conversation of any hostility.
And they actually shook hands a couple times as they parted, didn't they?
It seems as though they did. I do seem to recall that, yeah.
And is it your testimony that Mr. Casado walked over towards the group of men on the wall?
Well, and I know there was a certain amount made yesterday of characterizations of like confederation and things like a group. He did walk around, and what I testified to a little while ago was to speak with Mr. Santiago and one of the other gentlemen. I don't have awareness that he knew that anybody else was with anybody else. He's obviously been in bars before, as have the rest of them. At closing time, people, as you saw here, gather or wander around a bit on the sidewalks before clearing out.
But he did not insert himself into their conversation, did he, sir?
It appeared as though he did, but again, I don't know that for a fact. I would certainly defer to the fact witness testimony.
Okay, and if you look at the video, it actually appears the first contact is when Mr. Santiago points at him. Do you recall that?
I recall Mr. Santiago pointing to determine, as you're presenting, that Mr. Santiago has testified that that was the very first part of the interaction. I don't have knowledge of that.
I'm just referring to the video. But after that, there definitely was some encounter between Mr. Casado and Mr. Santiago and Mr. Wiersma. Would you agree?
Yes.
And just by watching the video itself, that lasted for about 4 minutes. Would you agree?
I'm not sure of the time frame, but I would not disagree with you if that's what you portray. Yeah.
And if there was testimony in this courtroom that from the witnesses who were in this group, that it did not appear hostile in any way, would you use that in your calculation in this case?
I would note that like all of the information, but of course, whether that, ultimately played into what eventually happened would not necessarily be relevant or helpful just based on surface level observation of somebody who wasn't there to be.
He's basically saying that he would only consider factors that reinforce the state's narrative of guilt here. And anything else that would be inconsistent with the state's narrative of guilt just isn't that important.
Looking at Mr. Casado or Mr. Amoya to remember something that might happen later.
And would you agree that this, even watching the video, despite what the testimony might have been, that nothing turned hostile until Mr. Amoya got involved?
No, we can't know that because again, we don't know Mr. Casado's motivations, intent, thought processes leading up to being in the conversation, being apparently told, I want you in the conversation, and why.
That's not my question.
Sorry, I'm trying to answer.
That's not my question. Would you agree that nothing seemed hostile until Mr. Amoya became involved in the conversation, which included Mr. Casado?
I'm sure there are, as you're portraying, a number of fact witnesses who could give you a knee-jerk response as to where something that a layperson sees as hostile, as opposed to understanding the dynamics of what may have been unfolding.
None of this is the question. This is not answering the question. The question is, are you aware, did you see anything that would indicate hostility prior to Amayo, the victim here, getting involved?
So if I put myself in the role of a layperson for a second, I didn't see anything hostile.
And if the testimony is consistent with that, will you agree that nothing appeared hostile until Mr. Amoya got involved?
I'll defer to whoever has testified and what weight, of course, the court puts on it, which is the province of the court.
And is the timing of events important? In other words, how long Mr. Casado has to react to different situations? I mean, in other words, let me give you an example. If he got mad and went to his car and got a gun and came back 5 minutes later and shot, that would be different than being suddenly attacked and pulling out his gun in fear. Would you agree that that's a difference?
With your hypothetical, if those were the two choices that existed, clearly there's a difference in these two hypotheticals you presented.
So the timing is critical in your evaluation.
Timing can be important, as I said earlier, that an event can be unfolding over a long period of time, or it can be something that happens relatively quickly.
Give me an idea of how much time period it was once Mr. Amoya became involved and he touched him, he put his hands on Casado. How much time went by?
How much time between when Mr. Amoya turned him and what?
No. I'm at 58 seconds before the first shot, sir. Mr. Casado turns towards the wall. How much time was there an encounter between, any encounter, either looking at each other, talking to each other, between Mr. Casado and Mr. Amoya before Mr. Amoya put hands on?
I don't know.
Isn't that an important thing to know?
Well, I know yesterday, of course, for Dr. Bedard, you had the slides up there with the timestamp on it. So is it important? It can be, as I said, whether it was 1 minute or it was 1 minute and 15 seconds, or if it was 3 minutes. If you continue to perhaps be present in a place where someone's trying to exclude you, and then someone turns you away, and then someone acts in a certain way, and then the slaps occur, no, it's not necessarily relevant in terms of how much time. Certainly your example of go to the car, get a gun, come back, and I've certainly been involved in those cases as well. Now we're looking at a different situation.
Have you reviewed the video that has the timestamps?
I'm sure I have.
When?
Well, as we talked about in the deposition, it was prior to when we had the deposition, and that there were the issues of what the timing and the time stamps of those were. And again, I appreciate all the questions about the temporal nature of what the cameras were showing, but again, that's, well, the answer to your questions, I've reviewed the videos.
Well, when I asked you a deposition, you weren't aware of the timing.
Well, as I said, and that's without benefit of having the deposition, there was, I think, the issues of the time stamp, not how long in each, but what the accurate time was.
Keep in mind, folks, this is the state's expert. Their purported use of force expert, although he apparently on a CV, he has no actual use of force expertise. But this is the state's expert. The state has the burden of disproving self-defense by clear and convincing evidence. And all their expert can deliver here is this word salad.
I still would like you to tell the court, what was the aggressive behavior by Mr. Casado? Aggressive, hostile, confrontation. People, let me preface this. All the witnesses were asked. All the group. Was Mr. Casado confrontational? No. Was he hostile? No. Was he threatening? No. Was he aggressive? No. Did he use cuss words? No. You accept that?
I'm sorry, I'm still trying to process the question. You didn't withdraw.
You accept that as part of your evaluation, that there's no testimony that he was aggressive in any way?
I absolutely cannot differ, counter, would not argue with what fact witnesses perceive and testify.
Just
Are
can't
you
answer
saying
a
you
question.
perceive something different?
Well, your question was about the analysis, and what I pointed out is, since none of those people, as far as the record shows, came out that evening to pay attention to Mr. Amoya nor Mr. Casado, I give it the weight that Judge Smith might in terms of relevance as to what they did or didn't perceive. I've already granted to you in your previous questioning that I did not see hostility.
But you do see hostility for Mr. Amoya, correct?
If this guy was going to be executed, if he didn't give a simple yes or no answer, he would still give a 30-word answer and take the hangman's noose.
You see him come off the wall and point at Mr. Casado, correct?
I saw him point down. I saw him point up. There was a variety of things that I would not interpret as this is a prelude or what we teach officers is a pre-attack indicator, but rather a drunken person either making a point, we don't know, he's not here, Mr. Amoya, he's dead, or whether eventually through his alcohol consumption, he's getting annoyed and Mr. Casado's not getting it.
Getting what? Getting what?
That apparently that Mr. Amoya did not want to continue a conversation with him.
And so
And
can Mr. Amoya then maybe walk away?
Well, surely Mr. Casado or Mr. Amoya could have, and I think Dr. Bedard testified to that yesterday as well. There are many, many opportunities for people to walk away from things, and it's the alcohol and confrontational violence and the audience that very often keeps that from perhaps happening.
Now alcohol is relevant again.
Or in the case of Mr. Amoya leaning against that wall because of, as you said, the high level of intoxication.
On Mr. Amoya's part.
Correct.
So, do you believe that the group was mocking Mr. Casado?
Again, I don't interpret group. I do also work in crowd control and crowd management. Group implies kind of specifically individuals gathered together for some kind of purpose. I saw intoxicated men outside of the bar after closing. Whether anybody in that group has testified that they did in fact find some kind of humor or mock Mr. Casado, that Mr. Casado, I guess you're portraying, was aware of, I don't know. I would defer to their testimony.
But it's not part of your opinion today.
Well, it could be, because if that's the case and Mr. Casado was cognizant of that, as I said, an affront, a perceived slight, the honor contest, all of those are very much elemental in confrontational violence.
Does Mr. Amoya have a right to tell Mr. Casado to leave a public street?
Sure, anybody can tell anything. Is that enforceable? No.
So did you notice in the video right before it becomes hostile that Mr. Casado is sort of gesturing toward Wearsbone in Santiago, and you can actually hear Amoya point and say, what's his name? What's his name? Do you recall that?
Well, that's compound, so let me try to unbundle that, counselor. Again, the lead up to that is not just about at the moment that Mr. Amoya slaps initially Mr. Casado, saying, what's his name? What's his name? I didn't hear any testimony other than Dr. Bedard, so I really don't have any way to answer that.
So you can't calculate any of that in your opinion either?
Calculate what?
Whether or not he was mocked, whether or not everyone seemed to be friendly when he was he seemed to be pleased that he was pleased that they were both named Lewis. That's not part of your calculation?
I don't know how that specifically and what ended up. The answer would be, it would be more information. More information's better. Ultimately, what Mr. Casado intended in that setting and how he responded wasn't proportional. I don't know what his thought process was leading up to it. Whether people were mocking him, I don't know. It would factor in, yes, as I just testified.
I mean, really, your job is not to tell us what Mr. Casado was thinking, is it? It's your job is to tell us what an objective and prudent person would do under the same circumstances. Would you agree with that?
Yes, I don't know what Mr. Casado was thinking, as I testified to repeatedly, even after listening to an hour and a half of Dr. Bedard attempt to do just that.
But isn't the standard that you're supposed to testify to what an objective and reasonable person would do?
Yeah, it's not pull out a gun and empty a magazine into them after being. Yeah,
That's not my question. Is that the standard?
that's
Is that the standard? Objective and reasonable?
proportional, reasonable. Well, I
Was
can't
it
speak to-
reasonable? Was it reasonable to strike up a conversation with some strangers on the street? Is that reasonable?
We know that in this courtroom, reasonable has a specific connotation. Trying to inject into individual interactions of people the use of the term reasonable and then leap somewhere is not, again, that's not part of the evaluation. It was not reasonable, for an individual contemplating proportionality to respond in a public place, not a crime-filled, alleyway at 4 a.m, with a gun to that circumstance. And those are my professional learned observations.
Was it reasonable for Mr. Casado
Those are professional learned observations.
to have a conversation with some people he didn't know that he just met in the street? Reasonable or not?
I find nothing unusual. I told you my caveat about reasonable. I find nothing unusual about drinking people in a bar, talking to one another. That's a big part of the point.
Would it be unreasonable for an objective and prudent person to be pleased to meet two people who had the same name?
Again, in that social setting of drinking at a bar, I would not find it surprising that someone might express something at finding out your name is the same as mine.
Do you find it reasonable?
Again, you're misapplying a term.
No, I'm not. That's the standard, sir. I'm not misapplying anything. That's the standard.
Reasonable is about force, not whether someone's name is the same. I think, again, I don't presume, but hopefully I'm clear enough with the court that I'm just trying to be very careful with my terminology here and not apply, was using a gun reasonable with the same as, is it reasonable that you're pleased someone has your same name? That's an apples and oranges to me as a researcher. I'm sorry.
Okay, so you will not accept that that was reasonable conduct to be pleased that two guys' names were the same? That's just
I
not.
made
That's
very
a yes
clear
or
that I
no.
don't-
It's a yes or no.
For a fact witness, it might be. I'm not here as a fact witness.
Do you think it was unreasonable for Adam Amoya to order Mr. Casado away? Was that unreasonable conduct?
To the extent that we're saying that Adam Amoya told Mr. Casado to go away, again, that would not be surprising. I'm not.
Would it be
we've already-
unreasonable? Would it be unreasonable from an objective standpoint?
Now you're trying to join the two words that I'm not allowed to use, which is objective reasonableness. So.
You're not allowed to use those two words, sir, in this hearing?
Not that I'm aware of. That's for the court to determine, objective reasonableness. I can certainly speak about whether the proportional response or whether the response of using that semi-automatic pistol is reasonable in this setting, but
Was it unreasonable for Mr. Amoya to put his hands on Mr. Casado and turn him and push him away?
it was certainly not unusual for drinking people to do things like that. And I certainly disagree with the characterization of battery. And also the testimony that I heard yesterday that even officers can't do that. Officers do that every single day.
It was a battery.
So Mr. Amoya had a right to put his hands on him and turn him away?
It's not about right or not right, whether or not you, when you were assistant state attorney or Mr. Johnson there, would prosecute for a drunk turning another drunk away. I think we both know the answer to that. It's no. Whether it's right or wrong for me as an objective evaluator, it's merely a factor to look at in the development of this interaction.
But you won't agree that that was unreasonable conduct.
I'll agree or say to you again, my words rather than the ones you're trying to put in my mouth, which is I'm not surprised that drinking people, after pointing here, pointing there, talking, turn somebody, that's what.
So now unreasonable conduct is excusable if the people are drunk. But if Casado was drunk, then he's inherently acting in an unreasonable way.
Happened.
So you won't
Okay.
agree that that was unreasonable conduct?
I'm trying to, after asked and answered 7 or 8 times.
You haven't
I'm
answered
trying-
yet. Do you agree that pushing him away was unreasonable human conduct?
Again, I'll try to respond.
It's a yes or a no, sir. It's either reasonable or unreasonable.
I
Which one
appreciate
is
the
it?
argumentativeness. I appreciate the argumentativeness, but for the benefit of Judge Smith, for the court, for the record, I'm not here to agree to your language. As a researcher, as an expert in this field, this is
God, this guy is so annoying. Oh my God, so many appeals to authority. Jeepers.
a place to apply the words you want me to say, which is reasonable, unreasonable, objectively reasonable about touching someone. Instead, it's a matter of, is this surprising? Does this track? Is there anything unusual? It is not for me to provide an equivalency of what I am here for, which is force. Is it reasonable? No. Versus talking, drinking, speaking, touching. That's a different connotation. And so,
I'm gonna try one more time.
Go ahead.
Whether or not you think objective and reasonable is part of this trial, do you consider personally the conduct of pushing him away to be unreasonable conduct? Yes or no?
I'm gonna object this to ask and answer several times.
I can't give an answer, but okay. All right. So when Mr. Casado was pushed and he put his hands up like this, you don't agree that this means, and I have my hands up like he did, you don't agree that that means I don't want to fight?
what I testified to earlier, and again, we have a compound here.
Can't answer a question.
Mr. Moya turning him and directing him to walk somewhere. When he turned back around and raised the hands, that could be interpreted certainly either as, hey, don't touch me, or hey, I just want to stay and talk to you guys. I'm not in a position to say which, but what I differed with Dr. Bedard's insistence that that was absolutely a universal, I want to negotiate, that's not accurate. And that it is more often seen in the circumstance of, hey, don't touch me.
Did you see him, Mr. Casado, do anything at that point that indicated he wanted to fight, that he was being aggressive, that he was threatening, that he was cussing, anything like that?
I'll object this to answer.
No, I'm at a new point now.
Sorry,
Sorry, apologize.
Objection to what?
It's asked and answered. It's asked and answered 5 minutes ago.
Why is this different?
Because we were free touching. Now, when he puts his hand up, I'd like to know if he thinks that that's aggressive behavior.
The objection is overruled. You can answer that question.
Did you notice at this point, when his hands are up, whether or not you would characterize any of that as being aggressive or threatening?
So as I believe I testified to, we don't know when he did this, he, Mr. Casado, we don't know what Mr. Casado was thinking. And as I've already testified to repeatedly, just accepting, raising hands, and trying to, trying to characterize it as, does it appear to a layperson to be aggressive or hostile, when that may not be the calculation? It's what will be the next series of actions by anybody here. I don't know.
Do you believe that an objective and reasonable person who didn't want to engage in any type of fisticuffs or fight would put their hands up as he did?
Let me try to unpack that. I don't know whether Mr. Casado wanted to continue.
I'm not
this
asking about Mr.
interaction.
Casado. Objective and reasonable person, under the circumstances, when he put their hands up, that would indicate they don't want to fight. Did you say yes to that?
No, you can't say yes to whether, someone who'd been drinking and being in that conversation, aside from Mr. Casado, whether they were offended by being, as you said, pushed and excluded, or whether they were like, hey, sorry, and then they were going to leave.
All right, how long after he put his hands up was he smacked in the head?
As I said, without the benefit of the slides and the timestamp, I don't know exactly prior to Mr. Moya striking Mr. Casado how long in between that was.
Do you think he was given time to walk away?
Was Mr. Casado given time to walk away?
Once he put his hands up, yes.
Well, certainly. I know the
How about
testimony.
how long after the first hit was the second?
Can I
hit?
finish? Can I
Yes,
finish? the
yes, sir,
answer?
sorry, I apologize.
Thank you, I appreciate it. You keep cutting me off when I'm trying to give the board a considered, thoughtful, contemplative answer. I think I recall, if we freeze frame this down to like a second until it happened, and again, I appreciate your attempt and desire to focus on that second, as opposed to when he was assumedly told walk away, when he was turned and pushed or directed away. Anybody, whether it's Mr. Casado or not, could leave at that point. Now, post hoc, here we are, and if we see Mr. Casado in this circumstance raise his hand, and then a second or so later, Mr. Amoya strike him, that's a logic fallacy. We know how that ends up. And so, eliciting for me, did he have time? If Mr. Amoya even knew in that second, that's what his next act was going to be. Again, we don't know.
Do you believe that Mr. Casado was being bullied?
I heard that, that raised in Dr. George's testimony yesterday. I don't see evidence of bullying, and I've certainly been involved in looking at bullying behavior.
How long after the first punch was the second?
I don't recall any punch. Is that just a slip on your part?
Well, are you calling this a slap?
From just a technical standpoint, and certainly we can get further into characterizations of whether the drunken Mr. Amoya is the same as Mike Tyson. I don't really think he is, or whether the bouncing Mr. Santiago delivering a second slap in about a second and then bouncing away, again, whether that's someone who's trained in the martial arts or anything else.
Did it appear to you that Mr. Casado almost fell to the ground after the second hit?
I saw part of the stumble. How much of that was with a strike from Mr. Santiago combined with intoxication? But again, as I testified to, was already obvious and he's stumbling earlier when nobody was near him. I don't know.
Did you notice that Mr. Santiago wound up, went from way down like throwing a baseball, all the way from the back through when he hit him?
Again, I remember yesterday's testimony and the fact of where his arm was, and you just added in some euphemisms as if it were the.
Hey, Steve. Steve Gosney, I think, is back. That's his office. Steve fell out of his chair. He must be laughing. There he is. I can't hear you yet, Steve. Can you hear us? Oh, well, he disappeared. He blinked out. Can you hear us, Steve?
I can hear you. Can you hear me?
I can hear you. All right.
Hey,
How about this?
Hey, man, I just had to come in and have fun with you.
I hope this witness is drunk. That's like his only excuse for this performance.
Is this unbelievable or what?
He's obviously just there to say pulling the gun, firing the shots was unreasonable, period.
Would you let me answer my question? You keep interrupting me. I'm trying to answer the question and you keep interrupting. Now, is this some defense trick? You're putting words in my mouth. Is this like the way he testifies?
Like you could fit any more words into that mouth. I mean, it's chock full of words. They're spilling down his chin. And he doesn't say anything. The more words that come out, the less information it has.
The guy, he was probably speaking at some prosecutor conference, and all the prosecutors are standing around going, wow, this guy's really great, man. He is so good. We need to get him,
Listen to all the words. He knows so many words.
All these words, boy, I'm so bamboozled. Oh, this guy's worse than the optometrist.
He is. At least the optometrist, when he was stumped, would mostly be silent. This guy, when he's stumped, it's just like word. It's like remember the old salad shooter things? You could put lettuce and carrots and stuff, and it sprays out the front.
And he's so defensive. He can't answer a question. Has Kanan asked one question that's actually unfair?
No, and he keeps falling back on these appeals to authority, self-appeals to authority. Well, as a researcher, as an academic, as a lecturer.
You know that I can't answer that question. I can't use that word. This is a hearing. I mean, this is unbelievable. This guy is freaking terrible. Oh, and I mean, and they're like are they sitting over there going, yeah, he's really showing this defense attorney a thing? Is that what they're thinking over there? I mean, come on.
This guy's testimony might have lost the immunity hearing for the state all by itself. I mean, this is
Just
is horrific.
I don't know what is up with this guy. It is horrible. This is everything you do not want in an expert. This is the reality that we defense attorneys have to live with. And you've been doing it for long enough that it's like this is what the defense gets accused of. This is what the media likes to portray. The defense is like, right. We go hire these hired guns who will say anything and do anything. And that's a defense. You're just a paid defense witness. Those defense witnesses were spot on. They were credible. They answered the questions. And these state witnesses are freaking whores. They're coming in there just saying like, whatever helps the state, then I'm not going to admit to any positive fact that could possibly be construed because you're trying to be tricky, Mr. Defense Attorney, by asking me a question. I mean, this is just all
this wishy-washy word salad nonsense as a state witness where the state has the burden of disproving self-defense by clear and convincing evidence.
He doesn't know that. He doesn't know the standard. He doesn't know the factors that should be considered, yet he's rendering an opinion. And then when asked to be giving the basis for his opinion, he gets all like hostile and like you're trying to cut, like what's unbelievable. I mean, Kanan is awful patient here, I must say. But
any of the testimony in court, except for Dr. Bedard, he doesn't know. He says he looked at the depositions. He's got no notes, no memory of anything in the depositions, no record.
Doesn't know what I've seen. Doesn't know what I've reviewed. Doesn't know what happened.
What he said in his own deposition, he can't remember.
Well, you're just trying to be tricky.
Right. It's a memory test.
You're reading from my book. Well, that's what I wrote 3 years ago. Right. I didn't know I was going to be testifying here today.
He would have written something different in his book if he knew he was going to be testifying.
If I'd known I was testifying here and would have gotten paid money, man, I would have changed that sentence.
That would have been a great question. So you're saying you would have written the book differently if you knew you were going to be testifying in this trial? Exactly how? How would you have written that sentence differently?
Oh,
and he keeps changing his own standards. Either alcohol matters or it doesn't matter. What happened before matters or it doesn't matter. It's whatever appears to him.
This means this is aggressive or this means he was surrendering. The smack was not an aggressive behavior, right? It's just unbelievable. Anyway, we're just having a blast.
Did you see the picture of this defendant's face?
The injuries. That's pretty horrific. Yeah, that's quite a violent hit. That is not a little slap. That takes. Look at that. The bruising on the eye. That's That's one of the most powerful slides. And look at the way it's done here. Look at the right hand side.
Yeah.
I mean, this is very well done. Didn't I tell you Kanan and Hilbert, these guys are good? I mean, they are this is great cross. Both the optometrist and this guy is textbook cross. They are just making these experts look like freaking idiots, of which they are earning every reputational strike. It's very poor, very sad that I don't know. It's just shocking. It's shocking when you see this level of these people are getting paid how many thousands of dollars to come in and do this performance?
I don't know. I think that optometrist for the state, I hope they didn't pay him much. This guy, good heavens, Steve, look at all his certificates. Look at all the clubs he's a member of. Where the hell is this?
I know. I sent you that. I sent you that link of his, looks impressive. Got to hire this guy, man. He's got all this. How do I get in this expert witness gig? It's like I am legitimately an expert on Florida criminal trial law. How can I parlay that into some money, thousands of dollars to testify? Some defense attorneys or process, I'll testify for either side. I'll give you my honest opinion. Is that what you want?
How many of these organizations are you a member of, Steve?
I don't know. I don't even know any of them.
I mean, Caliber Press is just a publishing house for like retired cops when they write a book. It gets printed by Caliber Press. The American Jail Association. I never even heard of that one. What the hell is that? And I'm pretty sure most of these you can become a member of by sending them the $50 they need for an annual membership.
Well, it's an associate. I don't know any of these. Not that
I know.
not that that's a
Alita,
problem.
I know Alita. That's a retired cop thing. But Caliber Press I'm familiar with, but it's just a publishing house. Council of Juvenile Justice Administrators. I mean, all this guy's degrees are in administration. It's
Well,
like holy
it's like
crap,
it's like an EDD. You know, it's good. It's a credential and it's fine. But what did you learn? I don't care what the guy's credentials are. He could be Harvard educated, Yale, go to every fine Ivy League in the world. Look at what he's testifying. How is he testifying? I mean, this is exactly what you do not do. I mean, this is what this expert should not even be allowed to testify. I mean, I'd move to strike his entire testimony. He's not qualified. He's not testifying. He doesn't know the standards. What's he testifying to? What's he giving an opinion on? Why is he even there? I mean, I don't know. I mean, I'm offended as a Florida taxpayer, you know, that my state hired this guy, paid him how many thousands to do this? Come on, I'm a taxpayer. Can't I complain? Who do I complain to, man?
But he's got a shelf full of books behind him, so he must be smart.
I know. I should get my books out. Where's my degrees and stuff? I don't have any of that stuff. I guess over there. But
I'll have to confess to the audience, I'm not a member of any of those organizations. I'm not.
If I didn't have to be a member of the bar, I wouldn't be a member of the Florida bar if I didn't have to be one. They forced me to do that.
Oh my God. Have I ever told you the story? I was accused by somebody on the internet of not being a real lawyer because I wasn't a member of the American Bar Association.
Oh, well, here's my look here. I'll give you a tour of the office. Here's my office. There's my degree wall.
Right.
I boxed up. I've got piles of stuff, and it's like I boxed that stuff up. To put it like that's his lead. This is just painful. Anyway, we're interrupting. We got a long way to go, but it's 5 o'clock, and so I'm off. I'm actually off at 4:30, but I was working until 5 o'clock. But
it looks like
thank you for having me back on.
Yeah, of course. We got another 25 minutes of this guy, and then we have maybe like 45 minutes of wrap up. The argument that each side's going to make to the judge about this. So we don't have that much more to go.
Well, let's do him, and I might have to head home. I've got to be on Megan Fox's tonight.
Oh, cool.
Comment on something. I don't know. She sent me something to watch, and she wants me to comment. So at 8:30, I'll be on Megan Fox Investigates. But
all right, well, I think we have about an hour of time left, and it's like at 1.25 speed, so we should be able to get through it.
Well, let's see what we can get through. You know,
the baseball, and that was going to be an intentional strike, and that kind of overhand strike like that without a lot of body movement, hips, ankle, knees, shoulders, and follow through, like I would train, an officer or a martial artist. I don't read it the way you're characterizing it.
I see. If the testimony yesterday in the courtroom that those were blunt force trauma strikes, do you disagree with that testimony from the doctor?
Now, I don't recall that Dr. Bedard has my background in trauma and homicide.
Not Dr. Bedard. This would be a medical doctor.
Well, I've already said I haven't heard any other testimony other than Dr. Bedard. I'm sorry, I have to say that again.
So would you defer to the medical doctor who described it as blunt force trauma?
By definition, striking something or tree falling on you would be blunt force trauma.
And do you know that there's testimony from the medical examiner that after those two hits, that would have caused a brain shake and Mr. Casado would have been dazed? Do you agree with that?
Is that also this week?
Yes.
Well, then no, I'm not aware of it.
And wouldn't that be important to know in your calculation of whether or not Mr. Casado was in fear?
Oh, the fear part. It could be. It could be. I mean, law enforcement officers and others get struck, every single day, and they don't shoot people. Mr. Casado was not impaired as he came to point shoulder and then tracked and fired at Mr. Arroyo.
How do you know?
We'll get to that in a minute. I'm trying to go piece by piece, sir. We're going to get to that.
I understand that. I'm trying to give you a thorough answer. I'm trying to provide for the court.
I see. Do you believe that Mr. Casado's right to defend himself is different than a police officer under the Florida law?
Oh, what happened?
Oh man, that was a killer question.
Is that me? Did I do that?
I don't know.
No, it's still. Hold on, folks. It's still running. I don't know why it went black like
Police officer as to a
Sorry.
citizen.
Well, I didn't say that.
It's the same.
That's your testimony.
Is it the same? Under Florida law, is their rights to defend themselves the same, to use deadly force?
If a law enforcement officer shot somebody in this circumstance, they would be charged.
I'm asking you if they are under the same
No, they
law
wouldn't.
for self-defense.
Again, you're asking me, about what is the statute, and this is what the court's going to determine. This is not what the fact witnesses or a couple of expert witnesses. or
I'd be
medical
like,
doctors
what
or
are you here to
optometrists
say
are
exactly
going
then?
to be able to give
Why are you
weight
testifying?
on.
What is your opinion?
What I am able to say is it is not the same as a law enforcement officer in this circumstance from the standpoint of, do you understand threat? Can you go from a couple of open palm strikes or several in a crowded area with people around at light and 4 security officers inside and telephones in everyone's hand? Can you pull your gun out as an officer and shoot someone dead in that circumstance? You cannot. You will be charged.
That's
Not my question. That's not
I
my question.
understand that, but that's my area.
I understand. As a criminologist, can you tell me if the self-defense law in the state of Florida applies equally to a police officer as it does a citizen? It's a yes or a no.
Whether it's written exactly the same, I'm not sure. And so, in an abundance of caution about
there's no Florida police self-defense law, folks. It's Florida self-defense law. There's no special police self-defense law.
being caught by you saying a word wrong and reading something into that, I'm not certain.
Do you believe that when Mr. Casado's eyeglasses were knocked off, that would have increased a level of fear?
It could.
And do you believe that after the first 2 blows, that continuous blows to the head could knock him down?
If that had happened and he'd been knocked down, that could.
Do you believe he has to suffer great bodily harm for him to be able to have immunity from the stand your ground law?
That's not my area to address.
Do you
Oh,
realize that he retreated over 10 feet after being hit the first 2 times?
I'm aware that in my evaluation and looking at how that unfolded, that as he was withdrawing the firearm from his right front pocket, he stepped backwards several steps. That's where I testified to earlier about how you can see him in the camera view, stepping backwards, not falling backwards, and shooting and tracking to the right and continuing to shoot. That's what you can see.
Do you realize that he fell back into the wall?
I'm not sure at what point, and on the camera, if you want to show me the slide where he falls into the wall in that, I remember some discussion about that, and at the very right-hand side of one of the camera views being near the wall.
Do you agree that him going backwards and putting his left hand up is an indication that he is trying to retreat and he doesn't want to fight?
Once again, not knowing what security officer Casado's training is, how much training he's done with his various handguns, what his state of mind was there.
This guy doesn't know anything. He just
why,
doesn't know
why are you here and what are you testifying to?
not knowing this, not knowing that, not knowing the other thing.
Hand up is a taught response so that you can get to your weapon with your other hand.
Do you,
So I don't know.
do you agree what Nicholas Ray, the witness, has to offer is really important to your analysis and whether or not this was justified?
Well, with the various witnesses and statements, and I appreciate you just throwing out Nicholas Ray's name as opposed to what position a particular individual was and when.
Because it wouldn't, an eyewitness perception of what was going on would not at all be relevant to his evaluation of whether or not this use of force was legitimate or not.
Wasn't be said.
I guess you can't look at your notes and see.
Wow. Okay. All right, Counselor, that's great.
I apologize. Do you know who Nicholas Ray is and what position he was in?
Nicholas
God's
Ray,
getting
I recall,
impatient.
was one of the several individuals behind where Mr. Casado's position would have been.
And you have no idea what his testimony was yesterday?
As I repeatedly testified to, that would be correct.
This is another problem that we see is that it's like this is a prosecutor and state mentality that the defense is the enemy. and
Right.
everything that you're saying is a trick, and you're out to get off on a technicality, and you're twisting my words and all this BS, when he's getting asked direct and specific questions that are exactly relevant to what's going on here. And it's like, oh, you're just being tricky. You're a defendant. You're trying to trick me. That is exactly wrong. And police officers, this is a good example for a police officer to witness. This is not how you testify. Your job is to testify to the truth directly. And if you can't say it, don't say it. But instead, it's like, well, I'm on this side. You're not on anybody's side. You should be on the truth side. But this guy is on somebody's side, and he's trying to warp his testimony, and he's way in where he isn't. He's over his head. He's being called. Now, why was this guy hired? The state put him on the stand.
Right, to make the blanket statement that pulling a gun and firing 7 rounds on these facts was not reasonable and not lawful. That's why.
And they knew what he was about. They put him on knowing this is what he would do, thinking that this is great and this is going to help the state.
Right. And then cross-examination happened like a train wreck in real time. It's it's absolutely amazing. And folks, so my legal practice is consulting on use of force cases to lawyers who are lead counsel for their clients. And when we don't actually take outside consults anymore, we just do them for our Law Self-Defense Platinum members. If you're not a Platinum member, we don't do a legal consult for you, something to keep in mind. So you may want to consider taking a look at lawselfdefense.com/platinum. But for many years, we would take outside consults, and our minimum retainer for a consult was $10,000. And people say, well, how could it be that much money? Well, it's that much money, folks, because when I do the consult, I look at every piece of evidence, every second of video, every crime scene photo, every report, everything written by a cop, every deposition. And these can be thousands of pictures, thousands of pages of things that need to be read and evaluated, critically analyzed. And then what I deliver to my clients is a very lengthy, typically a 200-page report, doing my legal analysis of whether or not, to a reasonable degree of legal certainty, that use of force was legally justified or not. And there is no question you could ask me on a witness stand that I would not be able to answer about that case. There is no deposition I haven't looked at, no witness testimony I haven't heard, no photograph I didn't see, no timing interval that I'm not familiar with, because I have memorized that damn case. This guy did not do anything like that. He's got nothing but whatever's off the cuff coming out of his mouth.
And he didn't take notes. And on top of that, if you're asked a question, and this is something it's taken me a while to learn, but maybe this is a share. If you're asked a question, you don't know the answer, say, that's a good question. I don't know the answer. I need to refer to the statute. That is a fair response. It's not a trick question. It's like, what's the standard of care? Well, I'm not good at memorization. I would like to refer to the statute. Do you have it handy? Yes, right. Just say you don't know. Or, because I'm terrible about remembering things off the cuff of my head like that. I always go back to the paper because I'm terrible at that. And I know it. And so it's like, I'll just admit it. Like, I don't remember the case name. Oh, that's the case where the guy shot. But this guy thinks it's a trick question. Just answer say, oh, I'm not sure. I always rely on my statutes. And here, I have it right here. Can you provide it?
He doesn't know, or he's afraid if he gave an answer, it would be harmful to his client, the state prosecutor in this case. So he gets defensive about it instead of simply answering. And man, if it were me, I'd be referring to my report almost every question, because to me, that's the definitive document. I'm not going to rely just on my memory of fine details. I'll say, you mind if I refresh my recollection? I'll look at it, close it, give my answer. And by the way, that also has the effect of slowing down the rate of questions, breaking up the pace of the, whether it's direct or cross-examination.
One more observation too about Pat here, because I know Pat in a different light. He's such a nice guy, but I can see the level of frustration is getting quite high with him. But now let's see. It's easy because we know that the judge eventually grants the stand your ground here, but he is getting very frustrated. His client is facing 30 years in prison.
Right.
His client is facing a life-ending prison sentence, and he's dealing with this guy on the stand that's trying to put his guy away, and he doesn't know the result of this hearing. He could lose this hearing. He could be going in front of a jury. He could lose in front of a jury, and this guy is trying to bury his client. This is not This is not fun and games. This is not games for the prosecutor or for anybody. This is serious stuff. This is somebody's life on the line, going to prison for the rest of their life, basically. This is life-changing stuff. It is not to be treated with this kind of frivolity.
Yeah, and I agree. It's offensive that this purported expert shows up completely unprepared when he knows the purpose of his testimony is to try to put a guy in prison for 30 years. Really despicable.
Could his testimony be important in your calculation?
Whatever he may have said contemporaneously at the time, that would have been the most telling. And at this point, very often we would see that be placed up to where we could be reminded of what that was, as opposed to something that he said that I have no knowledge of until you're about to tell me.
If I read this to you, would it may affect your opinion?
It might, as long as you gave me a comparison of what Mr. Ray said at the time of the shooting.
Well, at the time of the shooting, he said that he was being knocked back into the wall, he was being hit in the head, and then his eyes rolled back into his head, and he looked dazed like a boxer.
That's a lot of observation for Mr. Ray to make, and I'm sure the court will evaluate it as the court sees fit as to whether his angle would allow him to see or know that, or whether Mr. Ray's testimony may have been affected by human factors of his own.
Do you believe that he was in a position to see what I just said?
Again, not recalling whether he was around enough to see in an instant. I'm trying to remember part of yesterday's testimony of whether for any brief matter of milliseconds that Mr. Casado's eyes rolled, in fact. They may or may not have, but clearly did not affect his handling of the firearm.
Well, that's a perfect example, though, of someone who is dazed from punches. Would you agree? Like a boxer?
What's the perfect example?
The witness who's feet away saying that his eyes were rolling back and he looked dazed. Doesn't that indicate that he's, in fact, let me add one more thing to this. He testifies that he thought he was going to fall down and he was going to try to catch him, but the wall caught him. Does that factor into your analysis at all?
Let me try to add those. So again, first of all, separating Mr. Casado's actions and Mr. Moya's actions from what Mr. Ray claimed either at the time contemporaneously, which I told you in deposition was more important to the evaluation, but what now, some considerable time later, Mr. Ray may or may not have said, whether he thinks he saw eyes roll for some period of time, days, falling. It certainly, is what the witness says, and how much we can intuit from that, whether first it's accurate, based on whatever his alcohol consumption was, his angle was, his own perception of how much weight his providing information would be to the officers present. I don't know.
Sir, are there any other factors that you think you should have or did consider that would suggest that Mr. Casado was afraid, that his actions were reasonable, that you haven't offered thus far?
I'm not sure, but it sounds like you're asking me to reevaluate on the spot here about what.
Well, I'm looking in your book on page 7, and there's a whole chapter charge called "Who is in charge of the encounter?" Would you agree that Mr. Moya and Mr. Santiago were in charge of the encounter?
Well, now that's, I'll say, not intentional, I'm sure, on your part, but misleading the court, since that book was talking about a police officer interacting with somebody and who's really in charge of what occurs in that encounter. So I will attempt to first make a very clear distinction that that book manuscript that was finished 5 years ago had nothing to do with Mr. Moya and Mr. Casado or two civilians in a drunken interaction on the street, and say that who is in charge of that may come down to how the court may rule here in terms of what the court feels.
So you don't,
based on all this testimony. I'm trying to be accurate here.
you do not agree, and you can't tell this court that you believe Moya and Santiago were in charge of this encounter. In other words, it was unpredictable to Casado. He was not in charge. Would you agree with that?
No, I don't know that, because I don't know what he was thinking, and whoever's driving the car if you've been drinking, you may claim you're in charge of the car.
You say in the book, it's the reality of the unpredictable in human behavior that is ever present in the mind of the officer. Isn't it also ever present in the mind of the person being attacked? In this case?
Well, I know you're just plucking sentences out of a 200-page textbook and applying it to this particular case. And of course, that was about officers. But no, is the answer to your question, because again, law enforcement officers have specific training and specific psychological job roles that have to do with
What does that mean?
analyzing.
Hey, Andrew, stop for a second.
Certainly,
He
I
just
will
makes
stand
these
behind.
phrases.
I've written this book. This has taken me about 8 years to assemble the thought. I'll stand behind every sentence in this book. Will you stand behind every sentence in your book?
Oh, hell yeah. And by the way, if someone were to take a sentence out of my book and try to use it out of context, I would explain exactly
I'd be
why
like-
it's out of context.
I'm like,
I'd
that's
love to
great.
talk about it. Right?
Thanks for buying my book. Let me explain it to you. That's a great question, right?
And make sure you're throwing crimelaw.net somewhere in the explanation. Right?
Hey, there was another question in the chat, and I thought if they're a platinum member and they get into a self-defense incident, it's you doing the call. You don't have a firm, right? It's you doing the actual advising for the other firm.
Right.
Yeah.
So the way it works, folks, if you're involved in a use of force event, you're facing criminal charges, you need to retain local counsel in that jurisdiction to be the lead counsel on your case, your attorney. Then your attorney calls me and I consult with your attorney. We may never talk to each other. Probably not. Generally, I don't talk to the client. I'm looking at the evidence. I'm talking to the attorney. Of course, what I produce is all work product for the attorney, so it's covered by privilege. And I will say that it's well, that's the way that works. So
yeah, so it's not a firm. You are the firm. You are the person that would actually doing it. So I just thought that's clarified, because see, this is the thing. I mean, you're not going to get this guy. It's like it's just
no.
And can I make I'm going to make a personal endorsement for Branca yet again, and that is that the reason I associate myself with Mr. Branca, and we are associated, I would say, is that when you did the hearing, what was it, the Sanford shooting,
or
Zimmerman shooting,
right?
I was reading, and this is somebody who actually knows what they're talking about, who is talking clearly and concisely, who's like, look at Kanan. He knows what he's doing, right? It's clear. Right. Whereas this guy's clearly a buffoon. And it's amazing the level of buffoonery that impacts the criminal justice system, and it's putting people in prison for years. This is frightening. So you really want the best team. When you're in a trouble and your life is on the line, you want somebody like Kanan and you want somebody like Branca here backing you up, because this is the kind of stuff, buffoonery you get. And how do you know? How do you know who your good guy is? I mean, so anyways, sorry about opining. This guy is just terrible.
Yeah, I call these whoopee cushion expert witnesses, because it's every time they, like when they're being asked the question, it's like the whoopee cushion's being inflated, and then when they open their mouth to answer the question, it's like, I mean, and nothing helpful is coming out at all.
Fact that had Mr. Amoya believed that, as Dr. Bedard said, that Mr. Casado should think everybody has a gun, and if Mr. Amoya thought everybody has a gun, he probably wouldn't have slapped anybody, drunk or not. So no, and we'd have, people shot all day long, everywhere as a result of drunken interactions and slapping.
Well, don't you think that it's actually more unpredictable for the citizen as opposed to the trained officer when you're in a situation like this?
No, because the officers typically in an enforcement situation or an in-court situation, not two people outside of the bar who've been drinking at the end of the day. So again, this attempt to make direct comparisons to law enforcement is unsupported.
Okay. Well, is there any difference in this? The human officer, unable to read minds or intentions ahead of overt behavior, is left catching up to a fastball that has already been hurled. Isn't that what Mr. Casado is, the position he's in? The human citizen as opposed to the human officer? It's unable to read their minds? Will you agree to that? Is he unable to read their minds? Can you tell me yes to that?
Well, that's different. So which question do you want to answer?
Do you agree that this sentence applies to Mr. Casado?
No.
That's all I need to know.
Such a dishonest piece of junk. I'm very disgusted.
This is page 60, one matter frequently taught to law enforcement and to civilians is whether a threatening individual had ability, opportunity, and presented jeopardy. Would you agree that Mr. Amoya and Mr. Santiago had ability, opportunity, and presented jeopardy?
Not to kill somebody or seriously injure them.
That's not my question. Did they present the ability, the opportunity, and did they create jeopardy? That's my question.
And again, normally I have the document so I can see in what way you're taking this out of context as opposed to reading a snippet and then have you respond. So ability, opportunity, jeopardy has to do with a specific incident or circumstance. In this particular case, we're talking about what's the basis? Well, death or great bodily harm. So did they present with the ability in this circumstance? They weren't. There was no evidence, nothing I've seen. I'm open to more evidence that they possessed weapons. Opportunity is taken away because, again, we don't see an opportunity to cause death or great bodily harm in this context, in this setting. And then create jeopardy, once again, no articulation, no testimony in regards to weapons other than that unbeknownst to everyone else Mr. Casado had. So no, this is not, once again, from a book I wrote several years ago about law enforcement officers, this is not directly applicable.
Even though it says it's taught to citizens as well. Agreed?
It what? It what?
The last sentence I read to you. I'm gonna move on. I didn't hear you testify about any psychological or physiological changes to Mr. Casado once he started getting hit. Is that because there were none?
I believe, Counselor, I did testify to the fact that the various physiological, psychological issues may or may not affect an individual.
All right, let me read you from page 76. If we perceive a threat or are responding to one, would you agree he was receiving a threat and responding to one?
Yes.
Physiologically, we shift into different gear than the one we operate under normal conditions. Our heart rate increases, blood pressure alters, vessels constrict to shunt blood to vital areas like a ship, fattening compartments against a storm. And there's an introduction of chemicals into the bloodstream in response to the increased heart rate. Respiration increases, and vision may become distorted as physiology actually changes the functioning of the eye. Hearing may increase or decrease, and perhaps focus on specific sounds more than or to the exclusion of others. Time and perceptual distortions may occur with implications in the moment, as well as memory and recall following a force event. I didn't hear you say any of that.
I heard me say all of that. I testified to that on direct.
I see. Do you agree that you can't, it's unfair, it's inappropriate to have 20/20 hindsight when he's making decisions in 15 seconds and you're deciding over a period of hours, days, months? Doesn't your book say that the courts have even recognized that not using 20/20 hindsight to evaluate the reasonableness of an officer's force? Is that different for a citizen?
Okay, I'll undo the compound there again. Now that addressed what the Supreme Court and various other courts have said in regards to what the officer does. As it applies to 20/20 hindsight about what Mr. Amoya did in his drunken state, or what Mr. Casado did is not necessarily amenable to that, as opposed to being in a place at a time drinking with a firearm where you can't be, or we're not sure why, for a trained security officer to do that. So again, to be thorough, I'm not sure if that's the best comparison, because again, that court case and that language goes to officers. The Supreme Court did not write that about citizens in that case.
You state on page 108, law enforcement officers have been found to receive more severe injuries when dealing with individuals who are under the influence of alcohol or drugs. Does that apply to a citizen as well?
From the standpoint that if somebody slapped you or even punched you in the head or face, the person's probably not feeling it until later and know the effects of it. And so when you are attempting to control or struggle with someone who's affected by intoxication, yes, officers in those circumstances are more frequently injured.
Now, in your book, you do also say that you should calculate the speed, the lack of time that an officer has to make a decision. That should be part of the calculation of whether it's reasonable or not. Would you agree that's in your book?
You have me again at a disadvantage here. You're plucking something out of.
Well, forget the
He
book.
wrote the
Do you
book?
agree that you should take into account the speed in which the person has to make a decision to determine whether or not it's reasonable?
Oh,
I would say
Unbelievable.
deciding whether to carry a gun into a bar.
That's not my question, sir.
I'm
The
aware of-
speed in which you have to make a decision to pull the firearm, shouldn't that be accounted for in determining whether or not it's reasonable?
The reasonableness issue is, first goes to the proportionality. Again, you're trying to utilize something from my textbook about police officers and kind of shoehorn or force it in here. I want to try to be responsive, but with a translation for the court about what my professional view would be about how that can be adapted, not adopted, but adapted to discussion of interaction between civilians.
I'm befuddled. We've both written books. We're both experts in our appropriate
Tell me
areas.
to agree with the statement. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, and its calculus must embody an allowance for the fact that the police officers are often forced to make split-second decisions about the amount of force necessary in a particular situation.
That sounds
Do you
like
agree with that sentence?
that sounds like Garner.
I agree about police officers, and as Judge Smith knows, even though I say that in the book, in the court setting where I find myself typically, I can't speak to objective reasonableness. That's an ultimate trier of fact issue. Do I agree with what I said about police officers? Yes.
Doesn't that apply to a citizen as well?
Which, the whole sentence you just
Yes,
read,
sir.
the whole,
Yes, sir.
the whole part of it?
Yes.
Again, this case, the evaluation and my rebuttal of Dr. Bedard goes to proportionality.
I'm not asking you about that,
I'm
sir.
trying
I'm
to
asking you about this
answer
sentence.
your question. I'm trying to answer your question that I wrote about
you're
police
not.
officers 5 years ago and adapt it, as I said, to what you want, which is about Mr. Casado not trying. I want to be responsive. I want to be respectful to the court and provide the full explanation that I can. And the idea that, decision-making is often time compressed, that is absolutely true. And how the people got into that time compression situation is also absolutely relevant.
I'm going to change one word of the sentence and ask you the question again. The reasonableness of a particular use of force must be judged from the perspective of a reasonable citizen on the scene, and its calculus must embody an allowance for the fact that the citizen are often forced to make split-second decisions about the amount of force necessary in a particular situation. Is that a true and accurate statement?
It's incomplete.
Do you realize that you don't realize this, that there was testimony yesterday that if the assault would have continued, that Mr. Casado would have suffered great bodily harm? You're not aware of that?
But by who and with what credentials?
By the assailants. You disagree with that, or will you defer to the medical doctor?
Well, you said the assailants, who was Mr. Moya, so it wasn't.
Mr. Santiago?
So Mr. Santiago, you're saying testified that it continued, and then you said a medical doctor. So is it that Mr. Santiago testified that?
No,
And-
a medical doctor testified that if the hitting would have continued, he would have suffered great bodily harm.
Obviously, taking that out of the context of however long this medical doctor was on the stand and what the factors were, to just pluck a statement like that out.
Here, Andrew, I got a question for you.
Now, you told me earlier, you're not.
Here, I'm going to read from the law, your book. Okay. Escalation occurs when someone in a fight escalates what is non-deadly force fight into a deadly fight. There are two ways escalation can affect the element of innocence. The first is if it is you who escalates the fight. Would you disagree or agree with that statement?
I would agree.
Would you care to could you elaborate on that?
For an hour.
Yeah, exactly. I mean, so you wrote this book, and you mean you actually wrote the words and you know what they mean and you stand behind them?
Yeah, see, I recommend this book, folks. And by the way, you can get it for free at lawselfdefense.com/free book, because I like this book enough. The book I wrote, I like it enough that I actually remember what it says.
I would say, of course, if a second incoming blow is imminent, you may protect yourself from an ongoing attack. That obviously that's important to accurately judge when a threat has become imminent. Would you agree with your own book?
I would agree. That would be an important factor to consider.
Would you consider that? Have you factored that in your analysis? I mean, this is like, how could that, what is going on? He's like, I'm reading from your book. And by the way, officers are not above the law.
Right.
Let's just make that clear. There's no like, the only difference is that an officer has to approach certain situations. Their job requires it. So there's certain immunities that surround that. But as far as use of force, you know, there's no special law that a cop can blast you away because he doesn't like you. Right. I mean, it's like they're put in situations, but this whole thing of like, well, you know, officers can get beat about the head and they may be unconscious because of that, but regular human beings can't get hit about the head, and that it affects them differently because they're citizens and they don't wear a badge. Right. What kind of moronic statement is that? Is that actually in his book? No, he's an idiot.
Same self-defense law for everybody, folks. There's little differences in flavor in how the law is applied. For example, if I were to go hands-on with Steve, I would be an unlawful aggressor. I'm not allowed to do that. Cops go hands-on with suspects all the time. The difference is my going hands-on would be an unlawful use of force. The officer doing it, if it's in the course of their duties, they're compelling compliance with a lawful arrest, for example, their going hands-on would be a lawful use of force. But even a cop's not allowed to do, obviously, it sound like an idiot even having to say this, even a cop is not allowed to engage in unlawful use of force and then claim that that's justified. He can't shoot you because you're jaywalking.
Can I also say that, I mean, I must say, and I used to be a prosecutor in this jurisdiction. I've practiced in this courthouse by the judge that's in front of the judge that this courthouse is named after. I could do such a better job prosecuting. You know, the issue here is disproportionate use. There is a legitimate argument that could be made to say that the guy is responding to deadly force against a non-deadly attack. Okay, that's arguable. That's arguable. They're not even, but he's not even anywhere close to that. We're disagreeing with fundamental kind of basic concepts of reasonableness and way people of stuff that's like, we're in la la land here. We aren't talking about, this guy is so in such la la land that we aren't talking about the issue.
Now, this guy's got a pet peeve about Casado was carrying his gun concealed with a permit, but in a place he wasn't, in a bar. He doesn't like alcohol. There's all these things that he's not comfortable with that he wants to put Casado. He wants to put Casado in prison for 30 years because Casado was carrying his gun in a bar and had some drinks.
And there's no evidence from what I remember. I haven't seen the whole thing. You watched the whole thing. There's zero evidence that the shooter was intoxicated in any way.
Well, we know he had drinks. So he was at a different bar before, and I think he had 2 beers. And then he was in this bar, Dos Gatos, and he had 2 drinks in Dos Gatos over a period of some hours. So there's no reason to believe
not intoxicated, though.
Intoxicated, right. So he'd consumed alcohol, but there's no stumbling. There's no hostile conduct. He's not tripping over his own feet. He's certainly not .266 like the victim here.
This guy, yeah, Kanan, this is masterwork. And I'll tell you, he's very patient. And this is tough because this is very hard what he's doing, to have this amount of patience, to be going through it and to not letting him get rushed. He's not letting anybody disrupt him. He's going and he's going and he's going and he keeps that. Even when he gets stupid ass answers, he's not like, this guy's not answering anything. Instead, he keeps clicking along. So, I mean, I'll tell you, this is master cross-examination, both this and the optometrist, I would say, by Kanan.
Yeah, very good.
I'm not a psychologist, but were you able to listen this morning to Dr. Miller, who is a neuropsychologist?
Well, you know, I wasn't. I've testified to that many times now.
But you've recited him in your books, haven't you? You quoted him, or you've cited him.
You know, there's a lot of things I don't know. I'm not aware of that. What's his name?
Dr. Lawrence Miller.
The name rings a bell.
That's all the question.
You're right. All right, thank you.
Horrible.
Thank you for your testimony today.
Good term.
Whoops, sorry. All right, so that's it for...
Horrible. Looks like, by the way, on Megan Fox's show tonight, looks like the warrant in the Idaho maggot killer, the guy, the what do they call him, the Moscow maggot, the quadruple homicide, I think it is, up in Idaho. The warrant has been released, so I'm going
All
to
right.
go over that with Macon Fox tonight at 8:30. That was just this disgraceful. I want my money back. I'm a taxpayer in Florida. I'm a taxpayer in these counties, in this circuit.
Yeah, absolutely atrocious. So this should be the state's argument, basically their closing argument for this immunity hearing.
Yeah, let's hear what they say.
Listened tentatively to all the testimony in this particular case, and I know that as a lawyer and a judge, you understand the issues, the legal issues, the factual issues at hand. But I do appreciate the opportunity to address you and to summarize the arguments and the evidence that was laid out in the last 4 days. As Your Honor knows, that it is the state's burden in this particular case to prove by clear and convincing evidence in this particular case, and really what boils down to the singular issue in this particular case, and that was the moment that Louis Casado used deadly force. Did he reasonably believe that he was going to suffer death or great bodily harm, and that his use of force was necessary to prevent that? Now, a lot of people can look at the evidence in this case and come to different conclusions. But here's the thing: we heard from a lot of different witnesses who saw the event from a lot of different perspectives. At the end of the day, it's going to come down to what Your Honor sees in the video. This is a situation that was captured on a number of different cameras, and the event was recorded. But there's two particular things that I think the court should focus its attention on. And that is, number one, we heard a lot of evidence the last couple of days about reaction time and all of that kind of stuff. But all of the stuff that we've heard the last couple of days really presumes that at the moment that he pulled the gun, that his use of force was proportional to the force that was being used against him. Was that use of force reasonable under the circumstances? And
That's not the standard, folks. The standard is, was his use of deadly defensive force proportional to the imminent threat he believed he would be facing in the next moment? Not whether or not what had already happened. He's not dead. He's not maimed. Clearly that hasn't happened yet. But we had testimony from the medical doctor. If this beating had continued, and it was continuing, it was still in progress at the moment he pulled his gun, he would have suffered death or serious bodily injury. That's the question. You're defending yourself against what is about to happen, not what's happened in the past.
would a person in the same situation reasonably believe that that force would cause them death or great bodily harm? And as Your Honor saw from the video, these were slaps. Now, I'll grant you, when you watch the video, they were hard slaps. I'm not going to get up here and try to pretend otherwise. I'm not going to get up here and pretend that somehow Adam Amoya, Felix Ramos Santiago were justified in doing what they were doing. They were wrong. They were dead wrong.
No kidding.
They shouldn't have done it, but they did do it. But at the end of the day, these were slaps. They weren't punches. They didn't use a weapon. They used a firearm. There was some discussion, some argument, some testimony about how there's really not much difference between a slap and a fist. And reasonably, that's just simply not the case. A fist is you're basically using a very hard object supported by bones against someone's face. And here, the palm of your hand, there's a lot of skin, tissue, muscle. It's a lot soft.
Just to remind everybody. All right, this is what it looked like after these little slaps that the defendant was receiving that were still ongoing. The beating was still ongoing when he pulled his gun and started shooting. Just to refresh everybody's recollection.
And most people reasonably understand that. That's what happened in this particular case.
Are you telling me that if there had been punches, that your analysis would be that if there had been actual punches, fists, as opposed to open hands, then you would have been entitled to?
I think it would have been, it's a closer call, to be sure. I'm not going to concede that, Your Honor. I think, first of all, when you're talking about proportionate force, you look at, okay, he had a gun. Did they have a gun? They didn't have a gun. Did they have some other kind of deadly weapon? They didn't have another deadly weapon. Did they have any kind of weapon? They had no kind of weapon. And then you begin to look at what they did do, and would a reasonable person in that circumstance reasonably understand that could cause them death or great bodily harm? And here, there were slaps. There were slaps.
What about the testimony of the medical examiner that this portion of the hand here, which clearly the second strike was more with this portion of the hand, was just as powerful and strong as a fist?
That medical examiner testimony, the medical examiner was, of course, a state witness. So it's his own witness the judge is asking about now.
Right, and his testimony also, Judge, was that he was asked that question, but he also said it would be extremely rare that something like that would cause death of great bodily harm. That was his testimony. Well, when you talk about something that's rare, that's a reasonable person would not understand that to be something that might cause them death or great bodily harm. So that's the first part of this analysis. Mr. Casado would have been perfectly justified in using any other reasonable force to repel the force that was being used against him, but not pulling out a gun and shooting Adam Amoya as many times as he did, which leads me to the second part.
Would he have been justified in shooting Mr. Santiago?
No, Your Honor. Mr. Santiago hit him once and did, like I said, hit him hard. Mr. Santiago at that point moved back. And I know there was testimony or argument that Mr. Santiago was moving in his direction. That's really open to interpretation.
But you don't believe that the strike from Mr. Santiago in and of itself was sufficient to have created a reasonable person to believe that they were in fear of great bodily harm based on the force of that. You agree with that, at least on the video, is by far the strongest of all of the blows.
Of course, Your Honor. Yes, I would. But I do not believe that. Our argument, Your Honor, is it doesn't matter what I believe, or what it matters what a reasonable person would believe in the circumstance. But my argument to you is that a slap to the face, a reasonable person. And here's the other thing about it: when most people understand that when you're slapping someone, that it's almost like that's a message in and of itself that I'm not trying to hurt you like really badly.
What that means,
People would understand that. In this particular case,
It's a love tap.
else to try to repel that force.
We backed away, right?
True, but I'm talking about actually using actual physical force.
You're saying repel the force.
I'm talking about using affirmative force to repel, such as fighting back, Your Honor. Fighting back, using your hands to fight back. The second part of it too is once he used the force that he did, he continued to shoot over and over and over again. And there was a lot of testimony about, well, a person is going to, once they see that the force is no longer necessary, it takes some period of time for that to register in the brain and then that to be communicated to their limbs in order to stop using the force. But as Dr. Huck, if you look at that video, Your Honor, and you watch the video as he's shooting, you see Adam Amoya turn and begin to run. And he continues to shoot, and not only shoot, it's not like he's just holding his hand out and shooting over and over and over again in one place. He's tracking him. You can see the gun moving as Adam Amoya is running away in a diagonal fashion. You can watch him. And even with the testimony that we heard from Dr. Bedard talking about reaction time, I think it was actually the psychologist that testified today that said that your brain tells you to do one action, and then it has to tell you to do the other action to take your finger off the trigger. Well, here, the brain is telling him to move his arm. I mean, he's moving, he's tracking that Mr. Amoya as he's trying to run away. So it shows that clearly he understood and realized that Adam Amoya was no longer a threat to him.
No.
Maybe the evidence I've heard so far as the timing from first shot to the second shot is 1.6 seconds. You don't dispute that time.
I don't
Right.
dispute that, Ron. The reason that's important about him tracking and shooting him as he's running away, the reason that's important is because it is the lower back wound where, as you heard the testimony from Dr. Fulcher, enters the lower back and it's at a steeply upward trajectory, goes through the lungs, the kidney, the heart, through the aorta. And it's at such an angle where it's clear that Mr. Amoya is bent and he's running away. He had time to stop doing what he was doing. The video evidence I submit to you, Your Honor, showing him tracking Mr. Amoya as he's running away demonstrates that.
What evidence have you presented during the course of this hearing that to show that he had the ability that refutes the evidence that the defense put on, that he did not? What expert testimony did you present that shows that he did not actually have the ability to stop, or that he did have the ability to stop? Well, given
So this is actually interesting because what they're doing now is basically the equivalent of closing arguments in a trial, except when you make closing arguments in a trial, the jury doesn't get to interrupt and ask you questions to clarify or contest what it is you're saying. It's much like in a trial, the jury doesn't explain how they arrived at their verdict. They just deliver the verdict. But here in these immunity hearings, not only does the judge ultimately write an order explaining his rationale for granting immunity in this case, and we'll go over that tomorrow, but the judge gets to interrupt and ask clarifying questions, challenging questions of the prosecution, and presumably he'll do it of the defense as well. You don't normally get this experience in a closing argument in a trial.
You know, what's interesting too is to compare this shooting to the one that we talked about over in, was it Texas, where the guy did the four shots, and then the one shot?
The
Because
taqueria.
see, that was contemplation. The four
Right.
shots, boom, 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 because your brain says, shoot this guy. I'm being attacked. I'm in fear. Shoot this guy. Boom, 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 boom. One, less than 2 seconds, he's just shooting, and his brain doesn't communicate. His brain's just telling him, shoot, defend yourself, right? He's trying to say, like, okay, contemplate one shot, contemplate two shots, contemplate
Right.
three shots. Whereas, see, that's where that Texas shooting is problematic because of the gaps between the four, and especially the last one. But see, he's trying to impress that onto this fact pattern, which
Right.
is not what we're seeing here. We're seeing
Yeah.
what 5 shots in a row as quickly as the guy could fire. Basically, I'm being attacked, fire, defend myself, and then stop shooting. So, that's
After having his vision compromised by the attack in the first place, if only by losing his glasses and probably from blunt trauma to the head as well. And in the taqueria shooting, it was unambiguous that the circumstances had changed. The shooter picked up the gun of the aggressor. He didn't have the gun anymore. And then he shot him a ninth time in the head. Unambiguously that the circumstances had changed. There was no longer an apparent threat, based on the evidence we have, which is the video, of course. Here, it's all in 1.6 seconds. He's had his vision compromised. He's had 7-8 blows to the head. Sufficient to cause, the picture I showed just a moment ago, completely different set of circumstances. Where people legitimately get in trouble for continuing to shoot after they shouldn't have is typically when there's some kind of pause or unambiguous change in the circumstances where a reasonable person should have reevaluated whether or not there was still a threat, and then they shoot again.
Unless you're in this jurisdiction where this guy had to pay how many tens of thousands of dollars to defend himself against this prosecution when he did not continue the firing.
Oh, this has got to be, they have to be deep into the six. They had 6 expert witnesses, the defense alone.
Kanon's law firm is not cheap, I will tell you that.
Yeah, and I didn't know 5 of the experts I'm not familiar with, but Roy Bedard's a very prominent use of force expert witness. I know that guy does not come cheap. So they spent a lot of money on this hearing.
But the state experts were probably bargain basement.
Apparently, they better have been.
And what you know, and
Right.
what you've probably seen in police shootings and things of that nature, that within 1.6 seconds, entire event.
Your Honor, you heard the testimony from Dr. Huff today, and you compare that to the testimony you heard from the defense's experts about reaction time and stuff like that. When you consider what they said in comparison to that movement of him tracking Mr. Amoya, you couple that together. The video is the evidence. The video is the evidence of his actions and whether or not he really, if you watch that video, Your Honor, Adam Amoya is further and further and further away. By the time he gets hit in the back, he's probably 10 feet away. 10 feet away. And so, Your Honor, that would submit to you that those two factors, number one, this was not proportionate force. A reasonable person in the same situation would not perceive these slaps to justify using deadly force. And also, even if it did, the fact that he continued to shoot Mr. Amoy as he ran away and tracked him as he did so also shows this was not reasonable under the circumstances, Your Honor. And I would ask on that basis, based on the law, based on the evidence, that you deny the defendant's motion for immunity.
Let me just ask you one question. So why don't we have Mr. Casado's blood alcohol? Why was that not taken at the night?
I don't have the answer to that question, Judge. That's
Was a search warrant sought for it?
no, Your Honor.
Disappointed.
Indicated, I've yet to hear any argument.
The reason we don't have a blood alcohol level, almost certainly, folks, is because everyone involved, including the police officer who interacted with Casado immediately after the shooting, all testified that it did not appear to them that he was under the influence. So there would have been no rational reason to get a blood alcohol level from him.
You check private chat, dude.
Whether or not he was engaged in an unlawful activity at the time. We charged him with possessing a concealed firearm inside the firearm. That is a crime. A crime? That is a crime.
It is, Your Honor.
And so why are you not also arguing that his possession of that firearm? I mean, the crime is obviously designed to prevent people from going to bars where drinking is present with hidden guns.
Yes, sir.
Most likely to prevent this type of outcome, correct?
Yes, sir.
So what is so distinguishable about him possessing this firearm inside the bar versus taking 2 steps outside of the bar. Still under the same level of intoxication that he is, same with the same people who are all inside, they now just moved just a few feet from inside that bar. What changed?
I appreciate that question, Your Honor, but as an officer of the court, it's my understanding of the law. He was absolutely committing a crime when he went into the bar with a gun and during the entirety that he was inside that bar with the gun. Before he went into the bar, he was not yet. It's pretty clear he had a concealed weapons permit. And when he left the bar, the crime ended at that point.
Well, it doesn't.
What? What? But listen, I don't think any of these gun laws should apply. I think they're all facially unconstitutional. But by this rationale, someone who's completed a robbery is no longer, you can't charge him with robbery because the crime was over at that point. That's ridiculous.
Isn't there a case that suggests that the criminal activity can also be applied if it's moments before? So in other words, if you're engaged in a criminal activity, does it stop the second the criminal activity ends? Or does it continue for at least a certain amount of time, unfixed, but certain amount of time after the criminal activity? Isn't there a case, I believe it's State v. Kirk? You reviewed that case?
I have not.
Well, it's
Oh, were they asking that question in the context of stand your ground? Because one of the
Yeah.
conditions.
Oh, that might be. I was trying to figure out where he was going with that. Yeah, that could be.
Well, that would make more sense. But frankly, stand your ground doesn't apply here because you would only have a legal duty to retreat in the moment before you used force, deadly force in self-defense. You're not required to just go around the world retreating from everything. And once he wouldn't know he would be contemplating defensive force until the strikes began coming in, and then he is retreating.
I'm going to check what he's looking at here.
So I would encourage you to review that. I'm sure that Mr. Canan will certainly have arguments as that as well. But your position is that the court can't rely upon the fact that he was engaged in unlawful activity at the time. I would have to deny and find that you've proven this week by clear and convincing evidence that based on the video evidence that we've all been watching numerous times that was not reasonable.
Our primary argument, Your Honor, is this was not reasonable under the circumstances.
All right, thank you.
Thank you, Your Honor.
Oh my God, Steve, you got to watch this eye roll by the judge.
Oh, wait, I missed it. I'm sorry.
It's like you can tell which way the order is going to go just by this eye roll at the end. So the judge just asked them, so you're telling me that I have to decide, you want me to decide just based on what we heard in this hearing that you've proven by clear and convincing evidence this was not self-defense. And Johnson goes, Prosecutor Johnson goes, yes, Your Honor. And the judge just rolls his eyes. It's like, all right, whatever. Watch this.
The position is that the court can't rely upon time after the criminal activity. Isn't there a case, I believe it's State v. Kirk? You reviewed that case?
I have not, Your Honor.
Well, it's 276 Southern 3rd 994. So I would encourage you to review that.
Watch this, Steve.
Mr. Canan will certainly have arguments as that.
Watch this right here.
But your position is that the court can't rely upon the fact that he was engaged in unlawful activity at the time. I would have to deny and find that you've proven this week by clear and convincing evidence that based on the video evidence that we've all been watching numerous times that was not reasonable.
Our primary argument, Your Honor, is this was not reasonable under the circumstances.
All right, thank you.
Thank you, Your Honor.
Well, okay, so I get it. What he's doing here is he is
It's not clear. You're both going to
we go ahead. I'm going to find it for you.
Okay.
still requesting for written judgments, correct? So you're going to have some time to. Yes, sir. I know that I'm throwing some things at you, but you'll have an opportunity to address those in your proposed written orders.
Just 1 minute.
Yeah, okay, so he's looking at the jury instructions in Florida. Okay, and this goes to, let's see, if defendant is otherwise engaged in criminal activity or was not in a place where he had a right to be, then the use of deadly force was not justified unless he used every reasonable means within his power consistent with his own safety to avoid the danger before resorting to the use of deadly force. So
you know what? There's another issue here. So my preferred, the way I would prefer self-defense immunity to work in Florida is you simply take whatever the conditions are for self-defense at trial and you apply them in the immunity context. but I was informed by Don West, who was one of the co-counsel for George Zimmerman in his trial, also a Florida attorney, of course, that the standard's a little different for immunity than it is for self-defense at trial. And that is, the appellate courts in Florida have apparently ruled that the conditions for stand your ground, not being engaged in unlawful activity and being in a place you have a right to be, are also a condition of qualifying for immunity. I don't think that's the way the law should read, but that's apparently what the appellate courts have said. I think they've misread the statutory language. So normally, if you're at trial and you're engaged in criminal activity or you're not in a place you have a right to be, you might lose stand your ground. You might reacquire a legal duty to retreat. But in the immunity context, being engaged in criminal activity or being in a place you don't have a right to be loses you the opportunity for immunity. And off to trial you go. So that's why the judge was asking about it.
I will see here. I will admit my ignorance, even though I'm an expert in criminal trial law. I will say that I don't deal with that on an appellate level and have not encountered that. That may very well be true. And I would defer to Don West and I would look up that issue if I didn't know the answer to it, you see, rather than just saying, well, this is a compound question. I mean, you're using that out of context. And it's like,
yeah,
that's
so there's
interesting.
There's really two ways to be disqualified for immunity. One is on a straight up self-defense argument. You violated one of the elements of self-defense. The state's disproven by clear and convincing evidence one of the required elements of self-defense. That's the same way that they would defeat self-defense at trial. The second way to lose immunity would not apply at trial, but it's that you fail to meet the specific conditions for stand your ground. That might lose you stand your ground at trial, but in the immunity hearing, it could lose you immunity.
Okay, that's interesting.
I don't think that's the way the law should be, but
I'm not sure about that. I'd have to check that, but that may have been where that question was being directed from the judge, because he's applying an immunity statute,
right.
We're not at trial. So I'm usually reviewing trials and not stand your ground. This is, a lot of law, people think it's like, I know how to access the law and to research and double check the law when it hits my desk and the issue presents itself. I don't have a catalog of every statute in my head. That's why I rely on books.
Right. Okay, so that's it for the state. Now it's going to be the defense turn. And of course, this is, again, Patrick Cannon, lead defense counsel here. That's Dan Hilbert with the facial hair. And of course, the defendant, Louis Casado, sitting in the chair. I don't know who the young woman is.
Yeah, and also in the front row, that's Andrew Morgan. He's also the Cannon firm. And on the left, I think that's also an associate with their firm. Dan Hilbert, I'd like to know how much is involved in this, because I haven't heard him. Was he doing any of the cross? Because
he didn't do a lot. He was definitely questioning witnesses. The camera work in the courtroom was very poor. So often we just saw the witness. We didn't see the lawyers unless they wandered into the camera view. I did see Dan Hilbert wander into the camera view once or twice while witnesses were being questioned. But most of the time it sounded like it was Patrick who was lead here.
I'll just tell you, I mean, Patrick is phenomenal. He's a star attorney. And Dan is a real up and comer. He's an expert in criminal trial law, and I'm sure they were very tightly. Obviously, they've got their ducks in a row, right? I mean, he read that guy's book cover to cover, obviously, and applied it to this case.
Yeah,
right? He knew the book better than the stupid guy that wrote it. I'm questioning whether the guy even wrote the book.
I know. But it's consistent with him. I was describing this guy earlier as, and I'm speculating a little bit, but in decades ago, I was a pretty active self-defense instructor, and occasionally you'd get a student come into a class, and the way the classes are supposed to work is really like any class. You teach them how to shoot a gun. This is a safe way to shoot a gun, but they're not proficient as a result of a weekend class. They don't become proficient until they apply those lessons over time. And that's the only way to actually develop the skill set. You've shown them, the class teaches you what you're supposed to practice to hardwire in the skill set. But there's a certain class of student that will go from class to class to class, and all they do is they collect their certificate and they never do the work to actually hardwire the skills. So they don't actually know any of it. They can't do any of it, but they have a wall full of certificates. And when I see all these little membership things on that expert's website, I'm like, he just joins stuff. He's just a certificate collector. And I bet when he wrote that book, it's like a college kid who takes the final exam in a class he hates.
Well, I'm looking at this.
Easily disappears out of his head.
I'm looking at this too, and I'm just looking at his about on his page here. This guy is basically a professor. So he's not used to being challenged. He doesn't do anything. He's teaching, right? He's teaching criminology. And I have a master's degree in criminal justice from UCF, and there's a big difference between the practitioner and the academic, right? I mean, like when we're talking American law courses and we're doing our thing with that, we have practitioners. We have people who know this stuff who are teaching. It's not just like somebody who's written on it for 30 years. Now, I don't know what the guy's background is and what he's actually done, but he's saying he's taught for 30 years at the university level. Well, so he's got all this academia, he's teaching students stuff, and he's coming up with all these little things that and he's not used to getting grilled and questioned by his students. He's the grade giver. Nobody's going to question him. You would
think if you've been teaching something for 30 years, you'd be untouchable on the witness stand. Right?
Or you wrote the book. You would at least know. I mean, I'd love to talk about my book. Let's talk about it more, right? I'll go on for an hour. Crimelaw.net. Buy my book, right?
Got to hold it up, Steve.
I'll hold. Well, look, we'll put them both up. See there? Right? I mean, we could talk about these books. I could ask you any question in this book. You could open up any page of anything in this book, and I will tell you what I'm talking about and why I'm talking about it and how to distinguish it. I wrote the thing. I know what I'm writing. Did he write this?
In fact, on April 15th of this year, I'm giving a full day class that's basically me talking about the book for 7 hours, folks. So we only teach this class once, sometimes twice a year, April 15th, 2023, Saturday. Sign up this month for that class. You get 50% off this month.
What's on page 54, the fifth sentence? All right, let's take a look. 54. I'll tell you. See, and the thing is, I'm not going to come out. I'm going to ask 54, fifth sentence. Testimony the touchy was touching was actually non-consensual. Thus, there was no testimony. So this is talking about battery, and that basically the objective versus the subjective view of when you have a touching is a subjective touching or an objective, whether somebody perceives it is required in order to have a battery. If somebody does not perceive the touching, then it is not required. See there? And just a random number from the book, and I can tell you what I'm talking about just off one sentence out of context.
Right. All right, here's Patrick.
Oop. Yeah, I think, you're going to have to ask Hilbert. I think I actually taught, Hilbert was, I think, an intern at the state attorney's office when I was a prosecutor. And I used to teach the prosecutors. I'm not sure if, you have to ask him if I actually taught him anything. Do I get any credit at all for this spectacular performance? I want to get some credit. I'm sure Hilbert's behind the scenes. I mean, this is a team effort. They don't operate alone. You group think these things and you designate, like, he might be the one having to read the book going, give me some great quotes that apply to this case, right?
Yep.
Technical difficulties. What's going on? It's not playing.
Oh, sorry. Sorry, I've done this a couple times now. Let me set up. Okay. Here's Patrick and I.
At this court. Thank you, Judge. I also would like, I want to begin where I started earlier. This is a tragic event, and even though I realize it comes from me and the family, the Casados, the condolences for the great loss to the Amoya family is heartfelt. This is a tragedy. And now
that's always a smart play, whether it's to the jury or it's to the judge making the call on immunity here, because this is arguably, certainly to the family of Adam Amoya, this is a bad outcome event. right? Everybody would have preferred that this didn't have to happen. So there's not a great sense of justice here for many of the people involved. And you're asking the judge to make a difficult call. Somebody was shot dead on a street in St. Augustine, and he's going to say that person doesn't even have to go to trial.
Obviously, the question is whether or not Mr. Casado is rightfully deserving of immunity, and obviously our position is we think that he is. I agree with the statement that was made by the state as far as the law. He's justified in using deadly force if he reasonably believed that using deadly force is necessary to prevent imminent death or great bodily harm. But also there's an or if he was trying to prevent the imminent commission of a forcible felony. And I would argue to you that this is clearly a forcible felony, because a forcible felony would include an aggravated battery, an attempted aggravated battery. And so even if he wasn't in great bodily harm, he's allowed to use deadly force if there is a forcible felony being asserted upon him. The legislature is quite invested in the gun laws in this state. And in fact, so much so that in 2017, they decided to change the burden, where before 17, that person accused of shooting with deadly force had the burden of proving by a preponderance of evidence that it was a justified shooting. But our legislature said in 2017, no, we're going to shift that burden from the defense to the state. And it's not going to be by preponderance. It's going to be by clear and convincing evidence. If the legislature wanted to make sure that you could only shoot somebody if someone else had a weapon, they would have said that, and they haven't said that. So obviously you don't have to have a weapon. The other person doesn't have to have a weapon to fire the gun. You just have to be in fear of great bodily harm or death. The language from the case Bowie v. State at 292 Southern 3rd 471, clear and convincing evidence requires that the evidence must be found to be credible. The facts to which the witnesses testify must be distinctly remembered. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts and issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established.
I can tell you there was no such evidence presented by the state in this case, inconsistent with self-defense, and their rebuttal witnesses only made that worse. I mean, their testimony was completely non-credible, completely ambiguous, vacuous, word salad nonsense.
Those rebuttal witnesses need to be clipped out separately for, like, this is how you cross. This is destroying a witness on cross. Both those guys, the optometrist and the second guy.
That guy's next book is going to be How Not to Be an Expert Witness.
I would like to go through a brief rundown of what I think the facts showed. Let's talk about pre-hostility. Mr. Casado goes to work for 30 nights in a row, works from 10 p.m. to 6 in the morning, typically wears black, gets the night off, goes to have some drinks. To answer your question about why they didn't do blood alcohol level, every police officer that testified said he didn't appear to be impaired. That was Yarborough and Farrell. That would be one reason why a search warrant wasn't solicited. Goes to have a few drinks, parks his car at his house and walks into town. Goes into a local bar, and you see in the video having friendship with local citizens. Even talking to a woman, talking to a man. Actually, when the bar closes, he hugs a man. He walks outside in the same type of friendship he finds out right outside the door, and he has this minute-long conversation with a gentleman, and they shake hands. And then he walks just a few feet to the east, and he gets a completely different mentality. He gets a hostile. It turns out to be a hostile event. So what this case, Judge, I think comes down to, it's about science and it's about fear. And what we've tried to bring you is the science, even though the burden is not on us. Could you imagine if we didn't have the video? Mr. Britton said the first shot to the last shot was 25 seconds, and the man was running across the street and getting shot in the back. That would be the testimony. Mr. Britton said that Mr. Casado came up and got in Mr. Amoyda's face. That would be the testimony. But with the video, we can see he didn't get his face. He didn't do anything aggressive. Everybody said, I asked every one of them, was he hostile? Was he threatening? Did he cuss? Did he attack? Did he do anything that was aggressive? Every witness said no. Instead, would a reasonable person think that they might get the same treatment that they just got in the bar with some friendship? So he has this 3.5-minute conversation, it appears, out with Mr. Wiersma and Mr. Santiago. Every one of the persons I asked, did it appear to be friendly? Yes. Did it appear to be social? Yes. In fact, I think Mr. Britton testified, well, I thought Flex knew him. Thought they were talking business. Everything changes.
at 58 seconds before the first shot. Because Mr. Casado turns and his attention is directed towards Mr. Amoya, because Mr. Amoya engages him. The total time that they engage until hands go on Mr. Casado is 37 seconds. You can see by looking at the video that Luis Casado is kind of pleased by introducing, or pleased that these guys' names are also Luis. Mr. Amoya actually seems to accept that. You can hear it on the video. You can see it. He goes, oh, okay. He goes back to the wall. Then at some point, right now, which I don't know exact seconds till he puts his hands on, but it's like 10 seconds, he figures out he doesn't know anybody. He's not the same as us. He doesn't look like us. He doesn't dress like us. You don't know us, get the hell out of here. Get the fuck out of here. And you would think that a reasonable person at that point might think, what? In fact, he leans in and you can hear him say, what? That would create confusion. What do you mean? I've just been having this conversation and you're actually telling me I have to get out of here? That's confusing. He doesn't move within a second or two or three, but it's not much longer that hands come on him. Hands, physical hands, from a guy who's a 0.26 and got hydrocodone in the system, basically out of his mind, because he might not have done this otherwise. Turns him, pushes him. Would the reasonable person then be confused? You just put your hands on me. How do I react to that? Would the reasonable person put their hands up and say, don't want any of this? And then within a second, he slapped, or watch his head go. Call that a slap? This is a slap. Hit hard enough where his glasses break and come off his head. And then with less than a second comes a throw by Santiago from here all the way through, knocking him so hard that it buckles his knees and he almost falls and hits his head on the ground. That's a reasonable inference. Piers almost falls. But he's able to follow his way back up. And now we know he's dazed. The medical examiner said he'd be dazed. The medical examiner said it would take him at least 2 seconds to try to get his composure back. But now he also doesn't have his vision correct. It's certainly been compromised. You would think then they would give him time to walk away, even though he doesn't have to. The law doesn't require him to. From that time of the hands up to the first punch is 1 second. From the time of the bobbing back up, it's another second, where Mr. Amoya is coming after him. And he's backing up. Why is he backing up? Because he's afraid. And he's putting his hand up. And now he's confused, he's dazed. And what you hear from Mr. Ray, that the blows were coming, even though they get off the video. And thankfully for Mr. Ray, who's only feet away on the west side. The blows were coming and knocked him back into the wall, where Mr. Ray thought he was going to fall to the ground. Thought he was going to have to try to grab him. But the wall saved him. But at that very moment, he said he was being hit by the left hand. And then he turned his hit by the right hand. His head turned to the right, and he saw his eyes. He saw his eyes rolling back in his head. He said it looked like a boxer, someone dazed. The exact same word that the medical examiner used after the first 2 blows. And so in fear and in panic and in survival mode, he shoots his gun and unloads as fast as he can.
If you did not speak English, could not understand a word of this, just note the difference in presentation between this defense counsel here, sharing the narrative consistent with self-defense, and the very flat presentation made by the state prosecutor at the start.
Well, and I also say that I know Pat independently of this, and I've never seen him in action. I know his reputation from talking, and I am just blown away, completely impressed, and I can't wait to tell him that personally, that this is the top level of defense attorney work right here that you're seeing. And I love to see great attorneys practicing, and this is what you're seeing as what you get when you get a great defense attorney.
Yep. I mean, he's clearly impassioned for his client here.
We brought you the science. We brought you Dr. Bedard, who's a psychologist. He's a human factors expert. We brought you Dr. Miller. That's the science of neuropsychology. The state brought you Dr. Huff, who has a doctorate in public administration, who's never done a stand your ground case, who didn't even know what the standard was, who wouldn't answer a question with a straightforward answer. We brought you the science with taking the video and breaking it down into segments, not only of millimeters, but milliseconds, so you could see exactly what was happening. We brought you the science of what was happening to his head by talking to Fulcher when he said,
the head would be, the brain would shake, and it would cause him to be dazed. We brought you the science with Dr. Leak, who said that that's not slaps, that's blunt force trauma. She also testified that if this beating continued, he would have suffered great bodily injury. Dr. Fulcher said, well, it's rare that one slap could kill, but he said one slap can create great bodily injury, and he didn't put any qualification on that at all, that it happens all the time. One slap. And if you want, again, it's really kind of crazy to talk about those as being simple slaps. But the fact that Deidre Leak testifies that if he would have suffered great bodily harm, there's the answer to the question. Because if you noticed, right when the gun was going off, it hadn't ended. The left had come in, the right had come in, and if you notice, look at the left and the right, the hits were still coming. And what was Felix Ramos Santiago doing? Smiling, grabbing his crotch, and then coming back in. Would a reasonable person perhaps see that in some type of image coming back, or Mr. Britton turning on him and kind of putting his arms out like that? Could that create some additional fear? Where you think this gang is maybe more of them are going to attack you? Because you heard the testimony, you think of the worst case scenario when you get attacked unexpectedly. It's unpredictable, even though Dr. Huff wouldn't agree in his own book. You don't know what these people want. You don't know their motive. It's unpredictable. That creates fear. Mr. Santiago, it's interesting. Did he have a weapon? No evidence that he did. No evidence that he did. But he was grabbing his crotch. And he was told to stay. His brother had just been shot. He was told by law enforcement to stay, but instead he disappeared. So did Mr. Wiersma. Mr. Santiago, who gave the greatest blow, as you said, Judge, could have been charged with felony murder. That's a good argument. Wasn't even charged with a battery. The bottom line is, we've brought you the science. We have showed you the science of fear. We've broken down the time. As far as the 1.6 seconds and whether or not he knew that he was, the threat was over, that's from Dr. Huff. There's no evidence other than what Dr. Huff said, saying he's tracking the gun. We know that some bullets missed. It's not necessarily 1.6 seconds. The sixth shot was at 1.37. The seventh shot could have missed. But it's been real clear from the experts in psychology that his brain could not have told him in that amount of time that the threat was over. That's actually uncontested. The fact that he was going to suffer great bodily harm, if this continued, is uncontested. And the burden is not ours. 1 minute, please.
Excellent.
As far as reaction times, I would ask you, and this is in evidence.
Right. So arguably, the defense has proven self-defense by clear and convincing evidence, right? When
Yeah.
the burden is actually the reverse.
I'm actually a lot more convinced after this presentation than I was going into it. I was skeptical, but I'll tell you, they have proven clear and convincing the other way.
Right.
Until 1.6 seconds on shot 7 that Mr. Moore turns and runs. That tells you something about reaction time. It's consistent with exactly what Dr. Bernardo Miller told us.
Excellent point.
And you can see that in the exhibit on shot 7. Mr. Raymond Santiago hasn't even started moving away.
Right.
But after 1.6 seconds, that's when everybody starts running. Because that's when they perceive that there's something bad going on.
That's a brilliant point right there. Didn't see that, because yes, very good point.
Yeah, so I was hoping they were going to bring that up, because that's an obvious example of reaction time in this precise scenario, in the moment, to a much more decisive stimulus, right? Gunshots being fired, and people
In the actual event, the bystanders did not react but until the shooting was over.
But I wonder if he held that back, that argument, just for his closing, as opposed to asking it of one of the witnesses.
Right. Good point. See, this is so textbook. See, what you do is, when you get done, you always have a side man who makes sure you cover all the points that you're supposed to. So they're both familiar with what they're supposed to do. When you're up there in the moment, I'm not being to stop it. I'm just saying, like, what they're doing is, when you're in the moment, you get caught up and you're passionate and you're laying it out. See, he knows his facts. He's not got notes. He's just going down the list of what he remembers. And then he goes back to his second chair to say, okay, have I covered all the points? And he'll say, well, you should cover this point too, you see,
Right.
just to make sure. That's really good.
Yeah. I mean, that's why you have second chair. That's why you have co-counsel, because it's very difficult for one person's brain to keep track of all the spinning plates.
Judge, I just want to talk about a little bit about the gun. There is no law regarding this gun law that it carries on after you leave the bar. The crime is carrying into. And so, I mean, if you take it a few steps further, if he walks down the street and he walks a couple blocks away, is he still part of it? Because he's outside on a public street, there's clearly
But he's not, right? He's feet from the.
yes,
I mean,
but at minutes,
we don't have curtilage on structures, but on a dwelling, that would certainly be considered within the curtilage of the dwelling, within feet of the front door.
but it is a public street, and that's what the evidence is.
And you
And
didn't even make it to the street, it's on the sidewalk. It's literally within feet of the front door.
This is a bad argument by the judge. So the
Yeah.
crime is being inside the establishment. The moment you're an inch outside, you're no longer inside the establishment. This is what I always have to caution people, because these terms of art, like curtilage, have different meanings. It's the same word, but it has different meanings in different contexts. It has a different meaning in use of force law than it has in search and seizure law, and the judge is applying the concept inappropriately here.
Correct?
I can't.
And the law is, what's the purpose of the law? Is to prevent people from bringing guns into bars where people are drinking
He was outside the bar.
within a couple of feet with all the same patrons who were just inside the bar. I don't know if there, I'm curious about the distinction.
Well, I mean,
I'm
I
curious.
think importantly, the state has conceded that. And so, I think we need to move forward. The bottom line is, I'm not going to disagree that the crime was in the bar, but he had walked out of the bar. And I say that as soon as he walked out of the bar, the commission of the crime has been completed.
I will say that this judge is a former prosecutor. He has not been a defense attorney. This is very typical. Almost all the judges we have are all former prosecutors, because, of course, prosecutors are for the law and the defense attorneys are for the criminals.
Right.
Yeah. So they come at it from a prosecutorial perspective, which is kind of what I'm hearing from this judge, which is typical. This is what we deal with at the Seventh Circuit all the time. And they come at it and it's like they're looking for ways to nail your client.
Right.
And that's what he's looking for. He's like, why didn't you, if I was, see, but he's also looking at that prosecutor. If I was prosecuting this, I would have brought this up.
It's like the crime is a bad smell, right? And the bad smell continues to follow you after you depart the bar.
Right. Well, he's looking for that angle. He wants to deny the stand your ground based on this loophole. See, people get convicted on loopholes all the time.
Right.
And this is what we're talking about here.
That's fine because the state conceded the argument. If there's case law out there that suggests otherwise, or suggests that perhaps that's not as clear cut as you might think, I'm precluded from making that finding.
I think you are. I think that's not a contested fact.
Okay. So wait here. What this is important. So this is an interesting question too, because what the judge is saying, if the state concedes, then can I consider it in my order? So it's because the state conceded, they said, we aren't arguing that.
Yeah.
So does the defense attorney need to rebut that? Because that's what the judge would do, right? And so that's what he's saying, and that's the road he wants to go down. But now the judge is in the position that the state's conceded. So if the state's conceded that, does the defense even have to argue it? Can he put that in his order? Because that's where I want to go, right? That's a tricky position for a defense counsel.
So when the judge is ruling on a motion, like this motion for immunity, he's supposed to be basing his decision on the arguments made by the parties. He's not supposed to be a participant in the arguments. He's a ref. And if a party doesn't make an argument, the judge isn't supposed to introduce it.
Based on this, the language of clear and convincing, Louis Casado, despite this tragic death, was put in this position and had to make really quick decisions about his own life. And certainly that was a reasonable and objective thing to do. The suggestion that he could have fought back with his hands, use common sense. That's what the jury instruction is. Can you imagine what would have happened if he started fighting back? That would have just put fuel to the fire. And let me tell you, what would Flex have done to him? What would Amoy have done to him? That would have been the worst thing he could have done for his body, for his life, for his survival. Even the way it was, they were going to put him on the ground. Is that an unreasonable inference that they wanted him on the ground? If not, why would you keep hitting him? You already got him 10 feet, 7 inches back hitting a wall. Why don't you just leave him alone? Why don't you leave him alone? He puts his hands up. And now we're going to put him in the position where, no, you made the wrong decision. I'm sorry we only gave you 15 seconds to make this decision. That's your fault. You should have been smarter than that 15 seconds. That's unreasonable. He deserves immunity. Thank you.
Oh boy, love it. Great. A plus.
Very brief rebuttal by the state.
I'm certainly not going to respond in kind by referring to any of my colleague, my opposing counsel's argument is crazy.
Oh, see, oh,
It's all reasonable representing his client as I'm representing the state of Florida. A grand jury returned an indictment in this particular case, and I'm representing that decision.
That's so, like I said earlier today, folks, grand juries return what the prosecutor wants them to return. Pointing to the grand jury indictment as some kind of evidence of misconduct is really contemptible.
did I call this? Did I tell you beforehand? I said, this is what this guy does. He's like, I'm not even going to respond to this argument. It's so crazy. It's so, this guy is so crazy and out there. I'm just representing the state of Florida, right? Mr. Reasonable. I believe I've dealt with this.
He was not arrested the night of the incident, is that right?
No, he was not, Judge. And the reason for that is because you take care. You don't rush to judgment. You collect the evidence, you interview the witnesses, you get the videotape, and you make a deliberative decision. He was not arrested until the grand jury heard the case, and the grand jury made a decision that he should be charged. So, and that's the point.
Did the grand jury have to, I know you can't necessarily get into it because of what's presented to the grand jury, but I have to imagine that the grand jury did not have the benefit of the breaking down of the video, the expert
kidding.
testimony that this court has heard. They didn't have the benefit of all that when they made the determination.
Obviously, I can't reveal what happened in the grand jury, Judge. I certainly.
It clearly was not an adversarial process because that's not what a grand jury is.
That, who does he think he's talking to? A defense attorney and anybody in the criminal justice system knows that a grand jury is a tool of the prosecutor. For him to say, I'm just relying on the grand jury,
Right.
that's absurd.
Why didn't the state charge Mr. Santiago with battery?
Well, Your Honor, I don't think this goes to any of the issues in this particular case, but, and this was not presented during the course of the hearing, but Mr. Casado invoked his right to an attorney and refused to make any statements. And so in order to be able to prosecute a case, you have to have a victim who's willing to make a statement and is willing to prosecute.
You think you have no video?
Absolutely, Your Honor. I mean, you got to have somebody testify that it was unwanted touching. I mean, it certainly, you look at it, so that's
Actually,
but you need somebody that's going to come and testify to that fact. And he invoked his right to an attorney, Your Honor. So I came up for rebuttal to address a couple of points that counsel made, and that is he was arguing that this is an either or, like he has to be in fear of death or has a reasonable fear of death pre-filing or be resisting a forcible felony. And counsel, unfortunately, is incorrect about the law on that. That has to be an independent forcible felony. What that contemplates is somebody is committing a robbery against you or a burglary against you. It's not the actual force that you're using at that time. It has to be a separate forcible felony. So
Let me just understand. So you're saying if someone had come up and put a gun to his face, that would be an aggravated assault. That would not be a forcible felony that he could then pull out his gun and shoot him?
well, that would give him the reasonable fear of arrest rate by the harm. It would fall in that category. The case law, as I understand it, is there needs to be an independent forcible felony. The assault is.
No, the prosecutor is mistaken here. This is a bad reading of law. He's conflating this with things like felony murder, where there has to be some independent felony that's being committed other than the force that's actually used to commit the death. So if someone if you shoot someone and the prosecutor wants to argue that's a felony murder, the shooting itself can't be the underlying felony of the felony murder. There needs to be some independent felony, like an armed robbery taking place. That doesn't apply in this context.
Yeah, I don't think that's correct based on the jury instructions. That strikes me as wrong, but I'd have to research it.
Right.
Felony. You can,
So there's a robbery,
that's right.
but not necessarily just the aggravated assault.
Correct, Your Honor. Kind of murder
That's
thing,
not
Your Honor.
correct. The
So
jury
that's my
instructions are
understanding
clear on that.
Along those lines. And so anything else I would say?
So
Judge,
wait,
to be repeating
wait a
myself.
second. Okay, the use of deadly force is justifiable. This is Florida law. If defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him, or any attempt to commit a applicable felony upon him, or attempt to commit applicable felony upon dwelling house which he's present. Let me see. Here it is. If defendant was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of applicable forcible felony listed 77608 against himself. Okay, so let's look 77608.
That's just an enumerated list of various forcible felonies.
Right, 77608. All right. Forcible felony means treason, murder, manslaughter, sex battery, carjacking, home invasion, robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, blah, blah, blah. So the two felonies that the defense counsel listed are enumerated forcible felonies under the statute.
Right. So you might argue that if you were the prosecutor that this might have been a battery, but not an aggravated battery. But you can't argue that the underlying battery doesn't qualify.
No, this is that maybe that's true, but the forcible felonies that they pointed to were covered under the statute.
Right.
Okay. Sorry.
I do appreciate your time on this particular case.
Right. He doesn't want to. Oh, but I don't want to get into the weeds.
Yeah, I don't want to get into that. I don't want to respond to all those crazy defense arguments.
I know that Mr. Johnson had indicated he needs some time for his, about to go into trial in Putnam County, and both sides are requesting time to provide the court with written arguments and proposed orders. Yesterday, there was a request to submit those at the end of December. What is the absolute earliest? Tell me when your trial is, Mr. Johnson. I mean, I don't want to stretch this thing out another month and a half.
The judge wants to get this over with.
Before this court can rule on this
My
matter.
trial was the week of December 5th, Your Honor.
Okay.
By the way, it was a month and a half before the judge delivered his order on this.
And I'm also.
Well,
in the holidays.
I'll love to watch your order. I'm going to work
Be done
tomorrow.
The 9th,
I anticipate that we go, Your Honor.
so that you would be able to get it to me before, that would give you all the week of the 12th, and then we have the week of the 19th prior to breaking for Christmas holiday. So how about making you have to do by the 6th?
All right, well, I'm not going to listen to all the scheduling talk.
Yeah, I gotta
But
I gotta run too. I gotta get multiple things to do, but I'm looking forward to your analysis of the order tomorrow.
So the order is 11 pages, typical, form court document. It's double spaced. It's not a lot of stuff. I'm basically just going to read it. Is there some time tomorrow? You got a lunch break or something that we could schedule it?
Yeah, probably 11:30 ish.
Your time. Why don't you take a look at your calendar? Send me an email, and I'll just schedule the show for when you're available, and we can go through the document together.
Did I call that prosecutor? I'd love to respond to all those, but I'm just not going to talk about it.
Below me. It's
It's
below
below me. I'm just relying on the grand jury, Your Honor. Come on. That was great.
It's ridiculous and outrageous, and then
Outrageous.
It's not really a response.
Boy, was Kanan, man. I'll tell you, I haven't seen him in action, and he lives up to his reputation. So let's grift because I got to run.
All right, go ahead, hit it, Steve.
Ideas and Answers in Law.
Excellent book. Look how thick it is. Worth
It's
every
thick.
penny, folks.
Look at this. It out thickens the.
It's the thickening.
But the difference here, though, you have to buy my book. I don't give mine away for free, but you do get Attorney Andrew Bronco at the forward. But you have to buy my book. I don't do this charity thing.
And I have a fancy graphic, so you can get the Law of Self-Defense Principles at lawofselfdefense.com/free book. All right, Steve, I'm not going to keep you any longer. Send me an email when you're available tomorrow. When I get that, I'll schedule the show for that time slot. Probably, I think an hour will be more than enough to go through the order.
If you do it 11:30, between 11:30 12:30, I can make lunch at that time, so that's good.
Okay. All right, let's plan on that then, unless you indicate otherwise. So that's what I'll plan to do.
Great.
All right, take care, Steve. All right, folks, a couple other little follow-up things. So there's the book, lawselfdefense.com/free book. Don't forget our advanced course, Law Self-Defense Advanced Course, is a live full-day course in self-defense law taught live by me over Zoom. We do one, sometimes two of these a year. The 2023, the only definite class is Saturday, April 15th. You can sign up for that. If you do it this month, it's 50% off. Save yourself $100. Next month, it's only 25% off. March, it's only 10% off. April, it's full price. And trial membership to Law of Self-Defense. Oh, I have to do questions. I almost forgot the questions. I will go through the questions, folks, before the end of the show. Law of Self-Defense members get to ask their questions for free. Everybody else is on, if you ask a question on YouTube, it needs to be a $5 super chat. You can get a trial membership to Law of Self-Defense, full, complete access to everything for 2 weeks for just 99 cents. And if you stay a member, it's only about 30 cents a day after that, less than $10 a month to be a Law of Self-Defense member. Get to ask as many questions as you want. You can take advantage of that trial, 99-cent 2-week trial at lawofselfdefense.com/trial. All right, so let's take a look at the questions from Law of Self-Defense members. Let's see. Where did I leave off? Oh, folks, only the last 100 comments are shown on the Law of Self-Defense member chat. That's the first time I ever saw that. Sorry, folks. So I can only go back so far. My apologies for that. Let's see. Well, all these are referencing the ridiculous criminologist state rebuttal witness. So that's where we are. Law of Self-Defense member Kyle asks, I feel and wonder if it's better to answer honestly, even if it damages your client, than destroy your credibility. Yes, as an expert witness, if you're asked a question and you don't know, you just say you don't know. If you're asked a question and the answer would be harmful to your client's case, you answer honestly, and your client can address that on redirect if there's clarification to be made. You're just supposed to tell the truth. You're not supposed to be a shill and destroy your credibility in the process. Let's see. Law of Self-Defense member Kyle says, if I were this DA, I'd have gone for the cover of the grand jury. My opinion of these has changed. He's prosecuting for a win. Yeah, he could have used the grand jury as political cover by actually presenting the grand jury with all the evidence, including the evidence consistent with innocence, and the grand jury would not have returned an indictment, and he could have said, hey, I did what I could, and not ended up prosecuting this guy. But he didn't. He wanted to prosecute Casado, so he did what prosecutors normally do, which is only present the grand jury with evidence consistent with guilt, and surprise, surprise, he gets an indictment out of it. That's the norm. Let's see. Let's see. All right. So I know I missed some of the member questions. I'm sorry, folks. I didn't know it cut it off at 100. We'll have to see if we can address that in the code, but nothing I can do about that in hindsight. Let me take a look and see if there's any super chats that need to be addressed. Let's see. Just a couple. So Suck It, $5 super chat. Thank you very much. Asks thoughts on the new BATF, Bureau of Alcohol, Tobaccos, and Firearms. Should be a convenience store, but is in fact a government agency. Ruling on pistol braces. So pistol braces are gadgets you can put on an AR platform, or I guess any gun really, but let's use AR platforms that are initially, they're really intended to allow, for example, to be strapped around your forearm. So you can hold the pistol grip of the rifle, you can strap what would otherwise be the buttstock, but is a pistol brace around your forearm. You can fire it one-handed, as if your left hand was disabled, for example, and you couldn't use two hands to manipulate the rifle. And for many years, you could buy or build an AR platform with a less than 16-inch barrel, which would normally make it technically a short-barreled rifle that needs a $200 tax stamp or whatever the tax stamp requirement is, registration, months to get a special license from the ATF or special permission to get the tax stamp from the ATF to make it legal. Normally, you can't have a rifle with a barrel under 16 inches unless you meet these special licensing requirements. But there was if you had a AR pistol, and a pistol is basically an AR platform without a buttstock on it. I know the ATF, all these rules are ridiculous. They're all facially unconstitutional. But an AR rifle is different from an AR pistol in that the pistol doesn't have a buttstock. So if it doesn't have a buttstock, you build it as a pistol or you buy it as a pistol, it can have a barrel under 16 inches because it's not a short-barreled rifle. It's just a pistol. And for many years, the ATF was allowing you to take that AR pistol and attach a arm brace to the rear on the theory that that wasn't a buttstock. So it didn't convert the pistol into a rifle. And they've changed that ruling now. Well, there's, I'm sure, millions and millions of Americans who built these AR pistols or bought these AR pistols with the arm brace and a shorter than 16-inch barrel, and that's been perfectly lawful. And now it's a federal felony under the new ATF rule because the new ATF rule is treating the arm brace as if it were a buttstock. So now it's a short-barreled rifle where if you haven't jumped through the hoops, it's a felony to be in possession of that firearm without the taxiam. What do I think of it? I think it's all bullshit. I think all these gun laws preemptively applied to law-abiding, mentally sound American citizens are facially unconstitutional. This one, too. So nothing's changed for me. Ben Cheevers, $5 Canadian, asks, if Kim Potter appealed and got a new trial, that only happened, I don't know, buddy. It looks like your question got cut off. I did address this earlier. Kim Potter is scheduled for release early in April 4th of this year. So, February, March, 2.5 months, and she's out. If she appeals, she would, and won on appeal, which is not at all certain, although she has very good grounds for appeal. Her jury was misinstructed on the law by the prosecution, and the judge allowed that. So I think her conviction should be reversed on the merits. But if the conviction's reversed, the state could try her again. It's remanded for a new trial. And if she's tried again, who says they're not going to get away with lying to that jury about the law and get another conviction, maybe with a different judge who doesn't sentence Kim Potter only to effectively 14 months. It's not a risk I would want to take when I'm 2.5 months away from my sentence being done. I mean, Kim Potter, she's going to have a felony conviction if it's not reversed, but does she care? I mean, she's not she's not a cop anymore, never will be. So I think the prudent play is to not bother appealing this. Just wait out the 2.5 months and you're out. Move on with your life. It's terrible. She has the felony conviction. It's wrong. If I were governor, I would pardon her, but I'm not. So she's probably stuck with it. But from a legal strategy perspective, it doesn't really make sense for her to appeal. If she was going to be 20 years in prison, then it would make sense. But on this, it doesn't. All right, folks, I think that's all we're going to address today. What happened to my cursor? Here it is. So another, oh my gosh, a 5.5-hour show today. Tomorrow, it looks like 11:30 Eastern time. Tomorrow, 11:30 Eastern time, I'm going to go over the order, in this case, by the judge, Judge Smith, granting immunity to Luis Casado. So he's immunized against prosecution in this case, and we'll hear the judge's explanation for why he decided to grant immunity. We'll hear the judge's representation of the facts as having played the finder of fact role, the jury role in this hearing, the evidence the judge believed to have been proven or disproven to be credible, to be given legitimate weight in arriving at a conclusion here. We'll go through all of that tomorrow. Probably a short show. We're going to shoot for 11:30 to 12:30. Steve Gosney should be joining me. So I hope you join us for that tomorrow, 11:30 Eastern time. We'll go over that. Until then, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. So my family is hard to kill. You also owe it to yourself and your family to make sure you know the law, so you're hard to convict. All right, until tomorrow, folks, I remain Attorney Andrew Branca for Law Self-Defense. Stay safe.